Just a couple seconds.
Yep. Sorry about that.
No, you're fine. You're fine.
Good.
Oh, it needs to fill. Okay, now you can go. Thank you.
Thank you very much, Supi, and good morning, everyone. Welcome to the Judiciary Committee meeting of May 21st. Representative Thorne, do you have your hand up for a reason?
I do, Mr. Chair. I wish to apologize for my comments and the tone in which I made those comments yesterday in committee.
Thank you very much. You know, I know that my nerves are pretty frayed these days. I think this has been a very difficult session. And, you know, I have some words I'd like to take back to. So I appreciate your acknowledgement of that. Thank you, Representative. We have a quorum, and I really want to get us started because I know some people will have to leave. So I'm going to begin with committee introductions. I'm going to just call on people as they appear on my screen, starting with my co-chair, Senator Carney.
Good morning, everyone. I'm Ann Carney. I represent Senate District 29, and I am happy to be here this morning. I'll have to leave to go to the Environment Committee, but we'll be back as soon as I can.
Thank you, Senator Carney. Representative Moriarty.
Thank you, Mr. Chair. Good morning to all. I'm Steve Moriarty from House District 45, which consists of my hometown of Cumberland and part of Gray.
Thank you, Representative. Senator Sanborn.
Thank you, Representative Harnett. I am Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And I may have my camera off from time to time as I try and dig out from the papers on my desk during our public hearing today. But I'm happy to be with you in Judiciary. I've been over in my other committee all week long. Thanks.
Thank you very much, Senator. Representative Galgay-Reckitt.
Thank you. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland. I too will be in other places today as well as here.
Thank you, Representative Reckitt. Representative Thorne.
Thank you, Mr. Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in fabulous Penobscot County.
Thank you, Representative. Representative Babbage.
Good morning, everyone. My name is Christopher Babbage. I represent House District 8, which is about 4/5 of the town of Kennebunk.
Thank you, Representative. Representative Sheehan.
Thanks, Mr. Chair, and good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you, Representative. And Representative Newell with the beautiful picture behind you.
Thank you, Mr. Chair. That's a picture of Katahdin. Good morning, everyone. I'm Raina Newell, and I serve as the Passamaquoddy Tribal Representative. Thank you.
Thank you very much. And I really appreciate people getting here so we could establish quorum. Today, we have a series of 5 public hearings in the morning, and then we have a slew of work sessions this afternoon. The first bill that we will have a public hearing on, I want to make sure the bill sponsor is available. And I am not seeing the bill sponsor, so with your indulgence, I'm going to shut off my camera for a second and try to reach the bill sponsor.
Folks, can you tell me the 5th bill that's on the agenda? I've got my old agenda here and not the last one is what?
Chris, they're in the chat.
Oh, thank you. Yeah, 1719, thank you.
Representative Newell still here? No.
Yes, sir.
You must have been happy with the cover photo then of our
Oh,
130th legislature.
yeah, I brought some of those home.
Yeah.
This
Nicely
is a
done.
picture of when we gathered over in Katahdin. It's actually mirrored, so
Mhm.
at sunset. I think it was maybe 2 years ago.
Is Peggy or Soupy on? Hi, I just
Hi.
want to verify that this afternoon would be work sessioning 1692 and 1688. Is that right?
I will.
Yes, as
let you-
well as 3 other bills.
And are those listed in an email somewhere?
Yeah, they should be. It's 1292 and 1510. So both of Senator Kimes' bills and 1591, the offensive geographic names. So those are the 3 bills that were originally scheduled to be heard on May 6th. And then we ended up hearing them on the 13th. And IT did get all the testimony in one place for those, for 1592 and I'm sorry, 1292 and 1510. So you can go to May 13th hearing date for those.
Okay.
So we have 5 scheduled for this afternoon.
Got it. Thank you.
I think actually 1292 might not be run this afternoon. We're waiting on an amendment. So we may be down to 4.
Okay.
Okay, I am back, and I would ask the committee clerk to please move the sponsor of our first bill over, Rachel Talbot Ross. And welcome Representative Talbot Ross back to the Judiciary Committee. The first bill that we have today is LD 1703, an act to amend the bail code. And as soon as you are comfortable and ready to proceed, please present the bill, and welcome back, Representative Talbot Ross.
Thank you. Can you hear me?
Pretty well.
Okay. Thank you. So good morning, everyone. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. Good morning once again. My name is Rachel Talbot Ross. I represent House District 40 in Portland and serve as the Assistant House Majority Leader. I want to thank you for the opportunity to present LD 1703, an act to amend the Maine Bail Code. On any given day, 60 to 80% of the people in Maine's jails are there pre-trial. This means they are legally innocent. They haven't been convicted of a crime, yet they are stuck behind bars. Many of these people are stuck because they cannot afford their freedom. For hundreds of years, money bail ensured people would be free pending their trial. Pre-trial detention was the exception, not the rule. But now cash bail has morphed into a system of widespread wealth-based incarceration. Poor Mainers and people of color often can't afford to come up with money for bail, leaving them stuck in jail, awaiting trial for weeks or months. Meanwhile, wealthy people accused of the same crime can buy their freedom and return home. This is not what our Constitution promises. It is not what justice should look like. The way our pretrial justice system works has fundamentally damaged the presumption of innocence, which is the bedrock of our criminal laws. LD 1703 attempts to address this in two ways. First, it puts some guardrails around bail decisions. So bail decisions. And second, it gets rid of cash bail for most, not all, Class E crimes, which are the least serious crimes in our state, as you know. So the guardrails include a couple of things. One, establishing a burden of proof to overcome the presumption of release on personal repugnance. So establishing a burden of proof to overcome the presumption of release on personal repugnance. Right now, the law says that a person arrested for most crimes should be released on their own promise to return or on their promise to show up to court, coupled with a promise to pay if they do not. However, a judicial officer can impose bail conditions if they find releasing someone on personal repugnance wouldn't effectuate the purposes of the bail code. But there is no standard to guide how much evidence judicial officers need to make this decision. So one judicial officer could impose sanctions based on a hunch that a defendant won't return to court, while another judicial officer could need to be convinced beyond a reasonable doubt, and neither would be wrong. Under the current law, neither would be wrong. LD 1703 applies a uniform standard for everyone. Second, requiring judicial officers to put on the record why they are giving someone certain bail conditions. Right now, judicial officers don't have to say why they are imposing a bail condition. They can do it without justification. Defendants should be told why they are being given bail conditions. 3, establishing a standard for imposing cash bail. So the Maine Bail Code currently forbids imposing cash bail, quote, that either alone or in combination with other conditions of bail is in excess of what is reasonably necessary, unquote, to ensure compliance with the purposes of the bail code. But there is no metric by which a judicial officer should make this determination. LD 1703 applies the standard of clear and convincing evidence. Number 4, removing a select few of the conditions that can currently be placed on a defendant in exchange for their release from jail pretrial. So, for example, the bill removes the ability of police to randomly search someone who has not been convicted of a crime solely based on a bail condition prohibiting use or possession of alcohol or drugs. A random search of this kind violates the principles of the Fourth Amendment because it allows police to search people who are legally presumed innocent anytime and anywhere. And because violating any bail condition is a crime in our state, so the violation of any bail condition is a crime in our state. If a single beer is found in the refrigerator during a bail sweep, that can be the basis of new criminal charges even if not drinking a beer was not part of the conditions. So to be clear, the amended bill only removes the ability for random searches, and it does leave intact the ability to order police to search people if they can provide an articulable suspicion. Number 5, adding these factors that a judge or bail commissioner must consider when deciding whether to keep someone in jail before their trial. So judges and bail commissioners should take full account of a person's circumstances before they take away their liberty. I know you all agree to that. The kinds of things a judge or bail commissioner should take into account include the potential ripple effects of incarceration. This includes whether that person is the primary caretaker for a child. And so keeping this person in jail would also put those children in jeopardy. They should also take into some consideration, whether a person has mental health needs or substance use issues that are better treated in the community than in jail, and whether a person is likely to lose their job if they are held awaiting trial. Only with this full picture can judicial officers determine whether the conditions that they are imposing are appropriate for the given defendant and serve the goals of the bail code. So finally, this bill removes the ability of judges and bail commissioners to impose a money bail condition for most people charged with a Class E crime, except for certain crimes of sexual assault and domestic violence and the failure to appear in court. So it removes the money bail condition for Class E crimes with some exceptions. It's important to remember the purpose of the main bail code is limited to reasonably ensure the appearance of the defendant as required, to otherwise reasonably ensure the integrity of the judicial process, and when applicable, to reasonably ensure the safety of others in the community. That's it, right there. 15 MRSA subsection 1002. That's it right there. We should not be holding people who are neither dangerous nor a flight risk in jail simply because they can't afford to pay. Money bail is one of the most broken parts of our legal system. It lets the size of a person's wallet determine whether a legally innocent person accused of a crime can return home or will remain locked up in jail while awaiting their day in court. This unfair and unjust system punishes those without money or resources even before they've had a chance to defend themselves. This system also disproportionately harms people of color, especially Black and African Americans, who often have significantly higher cash bail set than do white people who commit the same crimes and who have less access to wealth in general. It is discriminatory, it is costly, and it doesn't work. In fact, research shows no evidence that people who pay cash bail are more likely to return to court than people released on their own recognizance. I know you join me in recognizing the inefficiencies and injustice in this bail code system, and I hope that you will join me in taking this significant step to improve our system for all Mainers by ending wealth-based discrimination through this system in our justice system. I really thank you for listening to me, particularly with my mask on. I'm not sure how clear it was, but I'd be happy to take any questions. And I'd be happy to work with the committee in trying to find a real solid place to land, because I hope that you agree that it's time for Maine to take a look at our bail code and reform it according to our Constitution, right? You are guaranteed equal protection of the law, and you are guaranteed that you are innocent until proven guilty. Thank you very much.
Thank you very much, Representative Talbot Ross, for bringing this bill forward. At this point, I will ask if there are any questions from committee members for the bill's sponsor, Representative Talbot Ross. And I see Representative Evangelos. Go ahead.
Thank you, Mr. Chair. Good morning, Representative Talbot Ross. Couple of questions. Rachel, do you have any idea what percentage of people that are currently held in our county jails pre-trial are there solely because they can't meet the conditions or terms of cash bail?
Thank you for the question, Representative. It's right on point. I don't have the exact percentage. I can get it for you, but I'm going to say an overwhelmingly amount of people.
And a follow-up. And I know this is probably hard to determine, but I just want your input on it, please. So you're in, you've been denied, release. You can't meet your cash bail. How many of these people, especially on lower level crimes that they've been accused of, there is a presumption of innocence. How many of these people end up just throwing the towel in and say, I might as well take the 30 days or the 66 months because I want to get it over with. It's a nightmare. It's a nightmare for my family. I can't work, the whole deal. So even if I'm innocent or have a good chance of be founding by reasonable doubt innocent, that they just throw the towel in and cave into it. You got any idea if those circumstances are going on?
Yeah, I will get you those exact figures, but you're right in, providing that question. I had family members experience this, and for being pulled over for a certain driving offense, they find themselves not able to make bail and said, just gave up. I mean, this is a young family member of mine, just gave up and said, no, I can't afford to miss work. I've got a young son I have to take care of. I'm the primary caretaker for my son. And I am not going to, I can't spend any time in jail. I just have to plead guilty and take it. And I've explained to family members, this creates a record. You now have a criminal record that cannot be, expunged here in the state of Maine. So many people, Representative Evangelos, end up taking that pathway because their lives will not exist if they, end up with spending any time in jail. So no money to bail out, just plead guilty to get it over with and move on.
I have one real quick follow-up, Mr. Chair, may I, and then I'll be done.
Yes, you may.
Thank you. So, Representative Talbot Ross, we heard from Justice Mead that we have up to 27,000 backlog in our courts, including, criminal, civil. So, because of the delay in having your case heard, has these circumstances exacerbated the length of time people are being held pre-trial, not being able to make bail because they weren't able to even make an appearance in court and have their case adjudicated?
Yeah, I mean, so many people, thank you, Representative, find themselves languishing in our county jails for weeks. It could be months, awaiting their opportunity. And, 70 to 80% of the folks who are in these correctional facilities, our jails, they haven't been proven guilty of anything. They're languishing there. And that is not what justice is all about. To keep someone who has not been proven guilty of any crime to languish in our jails for weeks and up to months.
So COVID has exacerbated that, the wait.
Well, COVID initially, to a different matter. Originally when we first started experiencing COVID, we had law enforcement officers really issuing more summons and not arresting because of the health, concerns. And that did not jeopardize public safety at all. There was no increase in crime. And we proved to ourselves, Representative, that we don't have to continue to arrest people in order to deal with any presumption of criminal activity or we do not have to rely on arrest and locking people up.
Thank you. All set, Mr. Chair. Thank you.
Thank you, Representative Evangelos. Representative Moriarty.
Thank you, Mr. Chair, and good morning, Representative Talbot Ross. Good to see you this morning. I appreciated your point on the ripple effect of incarceration, and you made reference to those with mental health and substance abuse issues. So how do you see this working? If someone is released on their own recognizance, clearly with these problems, clearly they need counseling and treatment, but is there any method of compelling that?
I'm sure, Representative, you are familiar with Maine pretrial services. And so there is, a contractual way in which to, get that treatment or get some of those kinds of services written into a condition for release. But I'm not necessarily for putting demands on people who've not actually committed any criminal activity, but have certain healthcare needs that must be met that have landed them in that situation. I'm not a proponent of compelling a person to take certain pathways that could be eventual setups for that person. It's a setup because the people are not ready for that step.
Yep. But I guess there's a risk, though, that someone with some of these health problems could go out and continue to commit offenses if the underlying problem is not addressed.
I think that what this is asking is for some consideration for those factors to be put into any decisions. It is not, we have found that risk assessments, these kinds of tools that have been used are failed. They have real problems. They're not an accurate assessment of someone's potential to commit any kind of crime or any criminogenic risk. So I'm not a big fan of using any kind of a formal risk assessment in what you're talking about, Representative. But I do think what the bill is asking is for those conditions to be considered when setting any bail conditions on an individual.
Okay, I just have one final question, and that is as I recall, if someone does in fact fail to appear in court on the date scheduled, an arrest warrant issues. If you have any data on the number of arrest warrants for, in fact, failure to have appeared, that would be very helpful to me and perhaps to others as well.
Thank you, Representative. We'll make sure that you have that for the work session.
Okay, thank you then.
Thank you, Representative Moriarty. Representative Babbage.
Thank you, Mr. Chair. Welcome, Representative Talbot Ross, and thank you so much for bringing this particular bill forward, addressing such a significant inequity in our justice system that has ramifications well beyond the individual that's incarcerated. I wanted to ask you the 30,000-foot question that maybe you could help me to understand. The bail reform movement is in what status across the country? Are there leaders out there as far as other states that are moving forward with this? And I was wondering who we might look to as we examine this. Thank you.
Yeah, thank you, Representative. I know that there are folks who are coming after me that have a lot of that national data, but there are a number of states that have reconsidered bail and cash bail as the method. This bill is asking us to consider that for our lowest level of crime, our Class E crimes that carry up to a maximum of 1 year in jail and $1,000 fine. These are offenses that can easily find a different means in which to for them to be addressed. And I think a number of states across the country have either reduced the reliance on the monetary bail system or have gotten rid of it. And Maine needs to learn from all of it. This bill is kind of a happy medium
Thank you.
when compared to other states.
Thank you very much, Representative Babbage. Representative Thorne.
Thank you, Mr. Chair. Welcome, Representative Talbot Ross. Yeah, it's funny because I looked up. Are you familiar with the term blind justice?
Representative, I'd like to hear your definition of that.
Well, I'll read it so I don't get it wrong. If you trust Wikipedia, the ideal that justice should be applied without regard to wealth, power, or other status. Earlier depictions showed Lady Liberty with a blindfold on. And I guess my question is to you, if this places conditions and factors on bail conditions, how is it impartial? How is it impartial if there's a different conditions for different people instead of what's the crime you're charged with and justice is equal for all?
So Representative Thorne, that's what this bill is trying to accomplish. Exactly what you just said. I mean, the randomness and the unequal ways in which we apply these conditions and set the monetary amounts is not consistent across the state. And so it is not justice when it's arbitrarily decided. We haven't talked about who can become a bail commissioner. We haven't talked about the training that's necessary to uphold, to be a bail commissioner. There are no standards around this. So it is quite subjective. And I believe that all Mainers should have access to a system that's transparent, number one. And number two, that they know whether they're the same rules apply in South Portland as they do in Fort Kent. The same rules apply if you're a white male or a Black female. I believe that this bill takes a significant step forward, Representative, in trying to accomplish what you said. Thank you.
A follow-up question, if I may, Mr. Chair?
Yes, Representative Thorne, go ahead.
And I appreciate what you're trying to say, but I fail to understand how this standardizes the bail system. I didn't hear that this makes it, whether you're making $300,000 a year and you get bail set, or you're making $50,000 a year and you get bail set and you can't afford bail. Somehow I heard that you're looking at adjusting bail conditions based on the ability to pay bail. Am I wrong there?
Representative Thorne, what we're trying to do in the bill, there's a number of things that we're trying to do in the bill, but we're trying to equalize this across the board so that it doesn't matter if you can pay the cash bail or not. This bill, with certain exceptions, with a number of exceptions still in place, says that there's no cash bail on the lowest level of crime, which we consider a misdemeanor, a Class E crime in this state. There's no cash bail on this set of quote unquote crimes in order to equalize the system. You shouldn't have to languish in jail or plead out simply because you cannot pay a bail amount that a bail commissioner set arbitrarily, maybe not with all of the conditions that should be considered, or you couldn't afford the bail commissioner fee. So your case has been resolved, but you still can't afford the fee. That could still keep you in jail. So this is a bill that's trying to take money out of all of this equation so that we are not holding people who have not been proven guilty, holding up their lives, incarcerating them because they don't have $60. That's what we're attempting to do in this bill.
So do you think we should ask the defendant how much they can afford and then set bail conditions for that?
That is already current law. We're supposed to be thinking about this, but it has not had an impact. And so, you know, we're supposed to be considering those types of things.
Okay. Thank you.
Yeah.
Thank you, Representative Thorne. Representative Babbage, do you have an additional question?
Apologize. No, I didn't take it down. Thank you, Mr. Chair.
Thank you very much, Representative Babbage. Are there additional questions for the bill sponsor from committee members? Seeing none, thank you very much, Representative Talbot Ross, for being here today. As the bill sponsor, you are welcome to remain through the remainder of the public hearing as a panelist if you would like to.
Yeah, I will, in all likelihood, stay on for a little bit and then I'll hop on over to another committee. I thank each and every one of you for your time this morning.
Thank you. Now, as per usual, I will take testimony from those people speaking in favor of LD 1685, and then those opposed, and then those neither for nor against. So I would ask those in the attendee room who wish to speak in support of the bill, I'm sorry, LD 1703, to please raise your electronic hand, and the committee clerk will move you over in the order those hands go up, and I will call on you if you are made a panelist. I will remind everyone testifying other than the bill sponsor that this we limit people to 3 minutes of testimony. I will be keeping time. When there's about 20 seconds left, you'll see me hold up my phone. That's an indication to wrap up. And when the 3 minutes is hit, I will let you know that it is time to include your testimony. So with that, I welcome our first person testifying, and welcome Peter Lehman to the Judiciary Committee. Nice to see you again, sir. Please begin your testimony when you feel comfortable.
Good morning, Representative Arnett and distinguished members of the committee. My name's Peter Lehman. I live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. I'm testifying on behalf of the Maine Prisoner Advocacy Coalition, whose goal is to promote restorative practices in order to increase public safety and the health of our community. I'd like to remind you of 3 important characteristics of our bail system currently. First, it costs us a lot of money. Second, it damages lives. And 3, it really doesn't work all that well. Other systems work better without the costs. Primarily because of our current bail system, most of the people in our jails, 2/3 of them, are awaiting trial. Most of them are there because they can't afford bail. Approximately 3/4 of those in jail pre-trial are there for misdemeanor offenses affected by this bill. So the current bail system costs us to spend lots of money to maintain considerably larger jails. This means higher property taxes. When people are detained in jail pre-trial, their children and families suffer as well. Jail means lost income, lost childcare, lost community connections, and dangerous untreated medical conditions.
Mary Bonato is going to testify in favor.
These are both individual and societal costs.
No, she does raise it. Don't call on her.
Number 3, bail isn't all that effective, even at assuring appearance. In fact, other jurisdictions have found that sending a reminder text or a phone call about a court appearance results in better attendance. On the recommendation of this committee, the Maine legislature funded a court notification system that's set to go into effect this fall. This bill calls for cash bail for most misdemeanors only when there is an imminent risk of willful flight, and institutes explicit consideration of issues such as childcare, medical needs, and employment. This bill will save us money, save lives, enhance justice, and enhance the equity, which is the notion of blind justice, and the inequity, which is the heart and basis of our system. We urge you to vote ought to pass on LD 1703. Thank you very much for your attention and support, and I'll be happy to answer any questions you have.
Thank you very much, Mr. Lehman, and I apologize. I needed to call our committee clerk on a matter. I did manage to stop my video, but did not shut off my audio. So
it certainly happens to all of us these days.
Thank you to our committee analyst for muting me. Are there questions from committee members for Mr. Lehman? Seeing none, thank you very much for taking the time to provide your testimony today and for submitting it online.
Thank you very much and have a terrific day.
Thank you. The next person that we will hear from, welcome back, Mr. Dunbar, is Doug Dunbar. Please begin your testimony when you are comfortable. And you know the drill about me holding up my phone when there's about 20 seconds left.
Thank you, Representative Harnett, and all the members of the committee. My name is Doug Dunbar. I live in Herman, outside of Bangor. And as most of you know, I had the good fortune of working in the legislature, the governor's office. I was Maine's Chief Deputy Secretary of State. I worked 8 years in Congress as John Baldacci's communications director. The last 10 years of my career in government, I was in a deputy commissioner position as the legislative liaison for the Department of Professional and Financial Regulation. During those 30 years in government, I thought I knew a thing or two about our criminal legal system, but not until I ended up in jail because I eventually self-medicated to treat my mental illnesses, and that led to terrible decision-making, 5 arrests, and 4.5 months in jail. Not until that time did I realize the problems. And I may have told this committee before, if you went to jail for just 2 weeks, and I encourage everyone to go to jail for 2 weeks, if you went to jail for 2 weeks, you would race back, you would fall over, trip over each other, trying to get to the revisor's office to submit legislation to make significant changes. The bill before you today makes very, very minor changes. I'm going to show you a couple of things. This is a news clipping from 2 years ago. A gentleman in Bangor shot another person outside of a bar. And there's no question he did that. There were many, many witnesses. This person posted $200,000 in property surety and got out of jail. Now I'm going to show you a list from the same time period 2 years ago of people in jail and how long they've been there and what their bail is. A young man named Caleb. He's been in jail for 107 days. 107 days. His bail, $100. And I could go on and on. I only have a couple more minutes. That's the problem with our system. And Representative Evangelos, you asked an excellent question about being incarcerated during COVID. Someone asked me not long ago what it's like to be in jail. And I said, do you have a large bathroom in your house? I said, go into that bathroom and lock the door. And because of COVID now, every time you ask when you're going to get out, people tell you, we have no idea. We have no idea. That's what it's like being in jail, particularly now. Remember, this bill makes only minor changes. Secondly, it's for people who have not been convicted of a crime. They're presumed innocent. Remember, this gentleman, $200,000, posted it, got out. Remember Caleb and the other people on this list, $100, $500, and they're in jail for 30, 60, 90, 100 days, and their life unravels. Thank you.
Thank you, Mr. Dunbar. Are there questions for Mr. Dunbar from committee members? Representative Thorne.
Thank you, Mr. Chair. Good morning, Mr. Dunbar.
Good morning.
Curious, I don't know if you know, you may know, where you seem to be well versed on it, on the number of people that are incarcerated pretrial that end up being exonerated?
Well, I appreciate the question. No, I don't have that information, but this is a key point. You've raised an issue, whether you realize it or not, that's really key. And that is, well, two things. First, we're talking about people who have not been convicted of anything. They are there in jail pre-trial, and they can't get out because they can't come up with a modest amount of money. And the other point that you raise, the other point that you raise, yeah, but the other point that you raise that's really important is that people, because they're in jail for 107 days because they can't come up with $100, what do? They don't wait. Usually, they take the deal, whether they're guilty or not. Mm-hmm. They take the deal because they've got to get out. They have a family. They've got to keep their lives together. So what we're talking about is making the system equal and fair. It is completely unfair right now. If you're poor, you are punished exponentially more than if you're wealthy. That's wrong. That's not equal justice under the law. It's completely wrong. And if you went to jail, Representative Thorne, for 2 weeks, you would be as passionate as I am, because I bet you're a caring, decent person. You would be equally as passionate as I am. It is wrong what we do. There is no question. Thank you.
Thank you, Mr. Dunbar. Are there additional questions for Mr. Dunbar? Seeing none, thank you very much for your time and testimony today. We always appreciate your input, sir.
Thank you. Take care.
You as well. I will next call upon Megan Sway. Ms. Sway, welcome back to the Judiciary Committee. Please begin your 3-minute testimony when you're comfortable.
Good morning, Representative Harnett and members of the committee. My name is Megan Sway, and I'm Policy Director at the ACLU of Maine. On behalf of our members, I'm here today to testify in support of this bill in its entirety. I submitted written testimony that's way longer than 3 minutes long, so I'm going to try to take a few of the points that have been raised so far, and then I'm happy to answer any questions. The first is around how this bill would equalize justice. And what we have now in the pretrial system, because of cash bail, because of many factors, is that when you have more money, you get better justice. And that is not something that the Constitution provides for. The Constitution, our founders tried to protect against that. And as Representative Thorne read in the Wikipedia page, you know, the concept underlying the system is this blind justice. But unfortunately, the way it's set up right now is that we don't have blind justice. And so this bill is trying to chip away at that. This leads to another point, which was, I believe, Representative Babbage's question about where is this happening across the country? This has been a movement across the country for a few years now, and we have seen different jurisdictions try different things. And there have been, in an effort to get rid of cash bail, there have been efforts to institute risk assessments and other things that try to get at how risky is someone's behavior and trying to get at predictive measures, as Representative Moriarty was talking about, which was, you know, what if someone goes out and does something dangerous? And what we've seen is that those risk assessments actually have been leading in a lot of places to even bigger incarceration pre-trial than cash bail. So what we're trying to do in Maine is go slowly, go carefully, and starting with Class E crimes. Not all Class E crimes, domestic violence, sexual assault, those crimes are exempted. Failure to appear in court. If you fail to appear in court, cash bail can still be imposed, because we heard from district attorneys that they needed that ability. So we tried to respond to some of the questions and concerns we got last session and implement compromises in this law. There's a standard set for what kind of how much evidence do you need to be convinced to put certain bail conditions on someone? And across the board, there's no standards, as Representative Talbot Ross said. So someone up in Aroostook, the bail commissioner could need, a book worth of evidence to let you out on bail, whereas someone down in York could just get your say-so. And we're trying to make that equal. We're trying to say everybody should have the same amount of evidence in order for conditions to apply. I'm out of time. I could talk about this for hours and I will spare you. I'm happy to take any questions.
Thank you very much, Ms. Sway. We appreciate your time and testimony. And I'm now going to turn to committee members to see if there are any questions for you. Representative Moriarty.
Thank you, Mr. Chair. Good morning, Ms. Sway. I've got a question that's been nagging at me for some time. It's a little bit peripheral, but it is part of the bill. And you may not be the one to answer it, but can you explain to us the role of the bail commissioner and why such a role is necessary and why it costs so much?
Sure. So when you're arrested in Maine for most crimes, a bail commissioner decides whether or not you get released. A bail commissioner is someone who's hired by the judicial branch as an independent contractor. They're usually former police officers, or occasionally there's a social worker, but these are contract employees. They get paid every time someone pays cash bail. There's a $60 surcharge. And so the state does not pay bail commissioners, defendants do. And so that is a way that the state government at some point offloaded the cost to defendants, but it means whatever cash bail you get, add $60 to that, and that's your real cash bail. They're supposed to have a yearly training. But there's no standards as to how long that training is. And then they go out and assess bail and give conditions. And so it's a system of independent contractors making these decisions across the state.
So how long does it take them to do their paperwork? Do you have any idea why?
I mean, my understanding is that they make the assessment based on anywhere from a 30-second to 3-minute conversation, usually with the arresting officer. And I don't know about the paperwork, but basically, oftentimes they have to go into the jail to do the paperwork. And so it's not a very efficient system.
So this is their job as independent contractors. They're self-employed and they make a living by processing bail. And
a lot of them are retired and this is a supplemental income.
Right, okay.
A lot of them are on rosters, and so the jails will call one person, then the next person, then the next person. There'll be maybe 3 bail commissioners in a county and smaller counties. And so they'll get a call from the jail. We have someone here, set the bail. But it is not it's not a regular income in that you don't know how many people are going to be arrested.
Right.
Yeah.
All right, good, thank you. That helps. Thank you.
Thank you, Representative Moriarty. Representative Sheehan.
Thanks, Mr. Chair, and welcome, Ms. Sway. Just so I understand, kind of following on Representative Moriarty's question, is a bail commissioner paid if bail is not imposed?
So, well, if bail is the release of someone. We often think of bail as cash,
right? But
it's the release. And conditions other than bail, or other than cash, are often bail. So especially under this bill, if a bail commissioner, say for a Class E crime, puts conditions other than cash. So for Class E crimes here, it's only cash bail that we're saying cannot be imposed. All of the other 19 conditions can be imposed. So it's not that people are just let go, it's that there are other conditions. If someone can afford the $60, they will still pay the bail commissioner to sign the forms. If they cannot pay, the bill says no one should be held in jail because they cannot afford the $60 fee.
Got it. So a $60 fee would still apply even if the bail conditions do not include cash or money. Okay, thank you.
Yes. And we did that because we heard concerns from the judicial branch last year that they didn't want to ask bail commissioners to work for free. And so this was a way of getting around that.
Thank you.
Thank you, Representative Sheehan. Are there additional questions from committee members for Ms. Sway?
Thank you all so much.
Seeing none, thank you very much for your time and testimony today. Next, I welcome to the panel Whitney Parrish. Ms. Parrish, nice to see you again. Please begin your 3-minute testimony as soon as you feel comfortable.
Thank you. Good morning, Representative Harnett and distinguished members of the committee. My name is Whitney Parrish. I'm the Policy and Advocacy Director for Health Equity Alliance. We're a nonpartisan, nonprofit public health and harm reduction organization that works for a world where health justice is realized for all Mainers. And I'm here speaking in strong favor of LD 1703. If I asked the distinguished members of this committee if it should be a crime to be poor, I'm certain none of you would suggest it should be. It would be difficult to find a single person who believes that any Mainer should go to jail because of a lack of money in their bank account. And yet, despite causing exactly this to happen, our antiquated bail system, as you've heard, persists. Too many poorer residents of this state often languish in jail awaiting trial, while others who are accused of exactly the same crimes walk free, solely because of their access to money. This is unfair, inequitable, and it most definitely isn't what any reasonable person would consider justice. Further, lack of money should never, ever drive incarceration rates. Many of the folks Heal serves have experienced the very real consequences of our unjust money bail system. For example, people experiencing houselessness are far more likely to be charged with the kinds of classy misdemeanors LD 1703 would address. As we've argued before, these are often the kinds of infractions that criminalize the very act of being unhoused, public intoxication, public trespassing, and other quote unquote nuisance charges. Likewise, when it comes to our clients who are people who use drugs, we know that often, even when a drug charge is not leveled, summonses are written for lesser tangentially related offenses. The end result is that vulnerable people with limited resources who are already struggling to get by, face the devastating prospect of spending time in jail while they wait for a hearing. Contrary to much of public perception, though, the people we serve do not all live lives of isolation. They have families who depend on them, jobs they need to show up for, and bills to pay, just like everyone does. Faced with a desperate need to return to work or care for a child or maintain housing, we know that folks without resources are more likely to simply accept plea deals and never truly get their day in court. This discrepancy alone should be enough to convince you that the current bail system is unjust. We believe the 3 additional factors to be considered by the judicial officer are reasonable and critical. This is not in my testimony, but I want to offer something to color this a bit. So on the date of statutory adjournment last session, I get a call from a loved one who is in Kennebec County jail, who was there on a low-level driving offense. And I rushed over as soon as I could to post bail. Luckily, I had the money to do that. It was just before a holiday weekend. I see my time is almost up. And we waited 3 hours for the bail commissioner to drive down from Oxford County because he covers Kennebec, Oxford, and I believe a few others he shared with me. That person would have stayed in jail 3 additional days had I not had the privilege of showing up and having the money to help them. So I just want to offer that as well, that just by virtue of how far it takes to travel to get to certain carceral settings, folks are spending longer time in jail than they should be.
Thank you, Ms.
So
Parrish.
thank you, and I'm very happy to answer questions and encourage you to vote ought to pass.
Thank you very much for you taking the time to testify before us.
Thank you.
Are there questions from committee members for Ms. Parrish? Representative Sheehan?
Sorry, I forgot to lower my hand.
Okay, not a problem. Are there other committee members with questions for Ms. Parrish? Seeing none, again, we appreciate you appearing before us this morning. Thank you.
287-1505.
The next person who will be testifying, I welcome back to the Judiciary Committee, Robert Ruffner. Mr. Ruffner, as soon as you are comfortable, please begin your 3-minute testimony. You will need to unmute your microphone and activate your video.
Hello, my name is Robert Ruffner. I am from Yarmouth, Maine, though I am coming to you from Tanner Ridge in Utah. I apologize for the setting, though I do take your work seriously. Usually camping equipment does not include a shirt, tie, and jacket. I am testifying in favor of this bill and hope that you vote ought to pass. I am a criminal defense attorney for the last 20 years, but before that I was a prosecutor both in Portland, Maine and in St. Louis, Missouri. In the questions that have been asked about this bill, there's a couple of things that have come up. First of all, the reason I believe that we have the $60 bail commissioner fee is because, like many things in the legislature, it is easy to pass bills that do not have fiscal notes. And the cost of bail commissioners would have caused problems for the legislation that created bail commissioners. But by relying on a self-funding mechanism, it eliminated a fiscal note. Like many legislature that eliminate fiscal notes, it has unintended consequences, such as individuals stuck in jail because of the $60 bail commissioner fee. I have seen that personally in my time as an attorney. Oftentimes, I am told that if someone says they cannot pay the bail commissioner fee, while they're supposed to be released, the jail oftentimes will wait to see if they really cannot come up with the money before releasing them without the bail commissioner's fee. I also have seen individuals plead guilty at their first day in court if bail is set at some amount that they cannot make, just for the various reasons that other people have testified to, because of their loved ones, their jobs, their apartment, and how those would be lost or devastated if they stayed in jail. And so they take a plea, sometimes with viable defenses. There was a question about the percentage of individuals who are exonerated after being stuck in jail. What I can tell you is that everyone who is in jail pre-trial, 100% of them is presumed by the US and our Maine Constitution to be innocent, and all of them are in jail. Finally, I would point out that Maine is one of the few states that criminalizes violations of bail. The vast majority rely on motions to revoke bail or enforce bail where appropriate. Maine, you can have a minor charge, violate a technical portion of possessing car keys or living in an apartment where there's alcohol in the fridge because your roommate has alcohol. And while you may win the underlying charge, you still end up with a criminal record. Thank you very much for your time. I hope that you will vote ought to pass in the work session.
Thank you very much, Mr. Ruffner. And I'm going to imagine you're the only person standing on Tanner Ridge wearing a suit and a tie.
I'm the only one standing on the ridge.
Okay. That makes it easier. Are there questions from committee members for Mr. Ruffner? Representative Babich.
Thank you, Mr. Chair. I don't want to prolong this unnecessarily, but I just want to make sure I understand you clearly, Mr. Ruffner. Thank you for testifying and taking that effort today. You are familiar with people who have remained incarcerated, not because they were imposed a cash bail, but because they're unable to pay the $60 fee?
Yes, it has happened. It's not supposed to happen. I believe that no one is supposed to be held under the regulations and the statute if they cannot pay it. But I have had individuals calling where that hasn't happened and they've stayed in jail for a few more days. But I have many times heard of individuals who were prolonged by several hours. I've received calls from clients at the jail saying they won't let me go because I don't have the $60. And what I have been told is that they like to wait a few hours to see if somebody can come up with the $60 before they decide that they really can't. Again, this is a externality of our funding mechanism in Maine, and it wouldn't exist if we just paid bail commissioners the same way we paid clerks and judges and prosecutors. So it's an unnecessary complication.
Is that addressed in this bill? Do you know?
I don't know that it is, though it is something that I see far too often in various aspects of our laws.
I appreciate your testimony. Thank you.
Thank you, Representative Babbage. And if you could lower your hand, that would be great. Are there additional questions for Mr. Ruffner? Seeing none, thank you very much for your time.
Thank you.
This morning. I will now bring our next panelist over, and that is Winifred Tate. Ms. Tate, as soon as you are comfortable, please speak. First of all, welcome to the Judiciary Committee. And as soon as you are comfortable, please begin your 3-minute testimony.
Thank you so much, esteemed members of the Judiciary Committee. My name is Winifred Tate. I'm coming to you from my beautiful attic office in Waterville. I'm an associate professor of anthropology at Colby and director of the Maine Drug Policy Lab at Colby College. We are researching the impact of drug policies in local communities and the experiences of people who use drugs and are in recovery. I'm here to testify in support of this bill because it disproportionately harms people with substance use disorder, and I think is a critical step as part of the many efforts ongoing in the state to ensure that people with substance use disorder can get access to treatment rather than incarceration. So this bill is a critical step in increasing fairness overall, ensuring that poverty does not condemn people to jail time. But I want to highlight the disproportionate effect on people with substance use disorder. To date, our research team has completed 20 interviews with incarcerated women in Aroostook and Kennebec County jails, 36 life history interviews with people in recovery or active use, 16 interviews with law enforcement personnel, and 28 interviews with healthcare providers and recovery personnel. And I'm here because I've heard stories of the devastating impact of being incarcerated while awaiting trial because of the inability to pay for bail has had on people with substance use disorder. We know the pillars of recovery are home, health, purpose, and community. Being incarcerated pretrial because you cannot pay bail is devastating in all 4 realms to people who are seeking to reach and maintain recovery. And people on medically assisted treatment often cannot continue their treatment while incarcerated, even for a few days, which really ruptures the critical nature of ongoing sustained treatment. We know that the majority of women incarcerated in Maine have substance use disorder, whether or not they're directly charged with drug-related crimes. And when I interviewed women in the Aroostook County Jail in the fall of 2019, every single woman reported experiencing significant trauma and that substance use disorder contributed to their charge. Most were awaiting trial. I've heard stories of women spending weeks away from their families, threatening their housing stability, employment, and custody situation. And finally, ending incarceration because of poverty is fiscally sound. In one case, and I'm going to just offer 2 examples, a woman was jailed for 5 days because she was unable to pay $60 in bail, plus the $60 fee for the bail commissioner. Because the arrest occurred on a holiday weekend, she ended up in jail for 5 days at a cost of approximately $500 to Maine taxpayers. We interviewed another young woman who told us her story. She was lucky enough to be born with wealthy parents. When she was arrested, her mother came to the jail within hours to bail her out, saving her job and taxpayers' money. Ending pretrial incarceration because of poverty will help people struggling with substance use disorder, Maine families, and especially Maine women and the children they care for. Thank you.
Thank you very much, Professor Tate. It appears you had your own timer.
I did.
Well. I like that approach. Are there questions from committee members for Professor Tate? Seeing none, again, thank you very much for taking the time and testifying today. We appreciate hearing your input. I will now turn to Ms. Netto. Nice to see you again. Please, welcome to the Judiciary Committee, and please begin your testimony as soon as you're comfortable.
Thank you, Representative Harnett, and good morning. My name is Tina Nato, and I am testifying today on behalf of the Maine Association of Criminal Defense Lawyers, of which I am the Executive Director, and we are testifying in support of LD 1703. I would note that apart from Mr. Ruffner, I am the only practitioner who is testifying today. So if you have questions about how this actually applies in court, I'd be happy to take those during the question period. I'm reading testimony that Walt McKee prepared on behalf of the organization, but I will start with this. From Brian Stevenson, our criminal justice system treats you better if you are rich and guilty than if you are poor and innocent. That's what we're talking about today. People in jail being held on bail on very low level offenses are, without exception, poor. That's exactly why they're in jail. I have never represented a rich client who has been held because they can't afford cash bail. I've never represented a middle-class person who has been held because they can't pay cash bail. They somehow scrape it together. But by and large, my indigent clients have nothing to post for cash bail, and that is exactly why they're held. This bill would help address it. I would also note that there have been, in the past 6 years, I believe, 2 wide-sweeping, wide-ranging task force on pretrial justice reform in Maine. This bill comes from those conversations. This has been studied and discussed with stakeholders over and over and over again. And what's proposed today is, I would say, rather modest in light of the great problem we have holding people pre-trial. I would also note that during COVID, I think it was mentioned before, perhaps by Representative Talbot Ross, that COVID has taught us a lot of lessons, namely that incarcerating more people doesn't keep us safer. Issuing summons in lieu of arrest didn't increase the crime rate, but the problem we're having now is that the jails are filling again. We're at capacity again, and people are awaiting trial. Not all for the low-level offenses that are the target of this bill, but we are reaching capacity, and the system is very strained. So as Mr. McKee notes in his testimony, this is definitive reform, finally, of our system for bail. This should be automatic for low-level crimes. People should be released on their own recognizance. That should be the presumption. This is a fair, reasonable, and appropriate response to the issue of, okay, thank you, 10 seconds, great. Walt's testimony is very short, so I hope you read it, but I am here to answer questions about the practical realities of bail and how it's used in Maine.
Thank you very much, Ms. Nato. Are there questions from committee members? Representative Sheehan?
Thanks, Mr. Chair, and thanks for being here, Ms. Neto. And thanks for offering some insight into actual courtroom procedure and how this might work. So I was perusing some of the posted testimony this morning and wanted to ask you a little bit about how, if a clear and convincing burden is imposed, how will this actually play out in criminal court? Andrea Mancuso raised a concern that this could force victims of domestic violence to appear in the initial bail hearings, and I just wanted to get a practitioner's understanding.
Sure, and thank you for the question. I glanced at Ms. Mancuso's testimony very briefly this morning in preparing for today. My understanding is that she, on behalf of her organization, is concerned about the creation of a standard of proof for establishing, for overcoming the presumption against cash bail or restrictive conditions. So I should note that bail hearings are not bound by the rules of evidence, and that's important. I know there are some practitioners and former attorneys on the call right now, but for those of you who aren't, the reason why that matters is in bail hearings, hearsay is admissible. police reports, affidavits, witness statements, things like that are all admissible without compliance with the rules of evidence. Now, they have to have some measure of reliability, but the way it works now is in bail arguments, the prosecutor typically will read, say, the witness statement in court, or it will be from the police report. The police noted this. I've seen a couple times video evidence used in particularly egregious circumstances. So even though there is now going to be a standard of proof as proposed by the bill, which I think is important, it does not change the actual practice of what is admissible in these hearings. It will not require the sworn testimony or the appearance of an alleged victim of domestic violence in order for a judge to make a determination about whether or not there's a significant, bunch of evidence to kind of hold somebody or at least put cash bail on them pre-trial. So I think that needs to be clarified. So I think conceptually I understand Ms. Mancuso's concern, but in practical reality, because of the way bail hearings are actually done and because they are not bound by the rules of evidence, we are not going to see people who might, just recently have been in crisis, in the past 24, 48 hours, dragged into court against their will to make the case. The case can be made with the same evidence that's always been used.
Thanks so much. That was helpful.
All right, thank you.
Representative Sheehan. Representative Moriarty.
Thank you, Mr. Chair. Good morning, Ms. Netto. You invited some practical questions, so I've got a couple of them. Personal recognizance is basically a promise to appear in court on the date indicated. Is that fair to say?
Yes, yes.
And so is a bail commissioner required in a case in which personal recognizance bail is afforded?
I'm sorry, I think you cut out right at the essential part of the question.
The question is the presence of a bail commissioner required for the issuance of personal recognizance bail?
Under our current law, yes. If somebody's arrested and there's a determination that they're going to be released, at that point, the police can't just, kind of release them. They have to be released on some sort of bond. So my understanding is that goes to the bail commissioner at first instance. And then a judge ultimately at initial appearance can also change the bail amount to PR.
So if you promise to come to court and that's okay with the judge and the prosecution, you still have to pay a $60 fee?
So I want to be very clear about this. Attorney Ruffner mentioned it, and it was an example of what it shouldn't be doing. If somebody is truly indigent without funds, they should not be charged that $60 fee. That is supposed to be waived. There are holdups and hangups with that make the process a little messy, but that kind of reform has already been implemented. But until you've come to court, really, unless somebody has been truly found indigent, it's hard to just waive that fee. I mean, I think bail commissioners do at times, particularly in Portland. A lot of the Class E crimes are relatively low-level crimes in which our unhoused citizens, gonna get trapped in. Some of the bail commissioners recognize that and will waive the fee. But a lot of these people get hauled into court because they can't pay any money.
Yeah. The second practical question is this. We're dealing in this bill with only Class E crimes. Are bail hearings held in connection with every Class E offense?
Bail hearings are only held when bail is set or if the prosecutor is seeking for bail to be set.
You mean actual cash bail, cash or property bail?
No, as I think Ms. Sway reminded us, bail is actually like the release part. When we talk about cash bail is a component of that, but it's actually even the setting of PR bail, which happens for a lot of the clients who actually ultimately come to court on these Class E. If they couldn't pay it at jail, if they couldn't afford what the bail commissioner initially set or the fee, they'll come to jail after 48, 72 hours, and the bail will be set at PR. The person will be found indigent, likely appointed counsel. It's an enormously expensive and inefficient process.
Thank you.
Thank you, Representative Moriarty. Representative Thorne.
Thank you, Mr. Chair, and welcome, Ms. Nadeau. And I'm trying to understand it because I'm not familiar with the court process. I'm not familiar with jail, and I admit it. I'm not familiar with the processes because I don't, like a previous person providing testimony, I've never experienced it, so I don't know. When you say that there are a lot of low-level crimes committed by indigent people, that's what is clogging up the jails. If I don't mean to use the word clogging in a derogatory way, but those are the majority of the people in the jails incarcerated. Is bail for the crime a deterrent for them? If they're repeat offenders, that they maybe don't want to do that, or does that not even enter into the equation? If they have a drug issue dependency, the deterrent of a bail they can't afford and spending time incarcerated is not enough of a deterrent for them. I'm just wondering if we change this to PR and they know, hey, I'm just going to be released on PR, at what point does PR not work on them anymore? And the judge says, we've released you on PR. Now we're going to, is there a process there that you think in your mind that will work to deter these incarcerated people from reoccurring their crime, or is it a lost cause?
Okay. So there's a lot to unpack there.
I know
There's
a
about three
lot
questions
in here, but
no, and I appreciate that, and I appreciate.
Yeah.
And I appreciate you're not a practitioner in the court, so you might not, conceptualize how this kind of goes down regularly. But the first thing I want to say is, you said something about indigent people having committed all these crimes. No, they have been accused of committing low-level offenses. Okay, so we need to keep that clear, just because the Constitution does presume these folks innocent, right?
And that goes back to anybody having the numbers of how many end up being exonerated of their crimes that were incarcerated unjustly.
And I heard your question earlier, and I think that confuses the issues here. When we're talking about exoneration, that's a not guilty finding by a jury. That's an extremely small proportion. The vast majority of cases are resolved by plea agreement and or resolution that does not result in a conviction. So those people, if they don't result in a conviction, are actually innocent, and the people who are in jail awaiting trial are also actually innocent under our Constitution. So I don't want to get those points confused. Okay. 80% of the crimes charged in Maine are misdemeanors. A significant portion of those are Class E misdemeanors. And those are the crimes for which poor people particularly are the ones caught up, because everyone else can pay $200, $300, $500. They'll find it somehow. But for Class E's, for the poorest people, that might as well be 5,000, 5 million. It doesn't matter. Right? That's the group of people we're talking about right here. So,
and I guess I don't mean for you to go on and on. I'm just trying to say I should have rephrased my question.
Please do, and I'll try to answer it.
Do you think it's a deterrent?
Oh, okay.
To have a bail condition set, and spend. In other words, I'm trying to put myself there, saying, if I didn't have any money, how hard would I try not to put myself in a position to be incarcerated versus I don't care what the penalty is, I'm still going to commit this crime because I have a drug dependency and no deterrent's going to be good enough for me. That's what I meant.
Okay, so I'm glad you asked that. I think that's a great question, because it gets us back to the broader issue of, does the criminal justice system, does the classification of crime, the possibility of prison time even, or in this instance, cash bail, deter people generally from committing crime? And the answer is no. The states with the highest murder rates are the states with the death penalty. The death penalty doesn't deter crime. So no, people are not, especially these low-level crimes that might be the result of substance use disorder or mental illness or a variety of things. People are not going through that analysis when they are caught, allegedly committing crimes. That's not part of the calculus, because it's still the possibility, even if they're released on PR bail, that case is still open. They could still be facing the possibility of jail time. That still doesn't deter people, because that assumes that people are making rational, reasoned decisions about cost benefit day to day, hour to hour, and that is not the case. So I would say no, it does not deter.
And a follow-up question, if I may, Mr. Chair.
Yes, Representative.
And I guess my curiosity is, when I play this through in my head, is I'm wondering why there aren't correctional facilities people here or sheriff's people advocating for this to lower the population in their jails. That's what I'm trying to figure out, is if this is something that is needed all over for everybody. I'm just wondering why they're not here trying to advocate, because I've seen them advocate for other bills, and if this helps their situation, I'm just trying to figure out why they're not here.
So I want to call back to the pretrial task.
My mind.
The sheriffs were very much involved in the pretrial justice task reform, the task force that we had, 2 of them, to try to address these problems. And the sheriffs have talked to us repeatedly about this revolving door for these low-level offenses and reaching out to us when people are being held on very low cash bail. Is there any way to get them back in court? Is there any way to get that bail reduced? They don't want to keep these people locked up. That costs a lot for them too, right? So even though they're not here, they've definitely been intimately involved in this process throughout the past several years.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions for Ms. Nato? Seeing none, we appreciate your time and testimony today, and it looks like we'll be seeing you later on.
Yeah, thank you very much, everyone.
I will now turn to Alicia Melnick. Ms. Melnick, welcome back to the Judiciary Committee. Please begin your testimony as soon as you feel comfortable.
Thank you. And it seems like some others before me did some pretty heavy lifting, so it looks like I got a good place in the lineup. Thank you all for hearing from me today. Chair Harnett, members of the Judiciary Committee. My name is Alicia Melnick. I'm an attorney at Bernstein Scher, and I'm here today on behalf of Equality Maine. Equality Maine supports LD 1703, an act to amend the bail code. Simply put, cash bail hurts the poor the most, and LGBTQ people are more likely to be poor. While incarcerated, LGBTQ people are also more likely to experience inhumane treatment. Eliminating cash bail for Class C misdemeanors would help keep LGBTQ people out of jails and at their home in their communities where they have the resources and support to thrive. Justice should not depend on one's wealth. Cash bail burdens the poor most of all, forcing those people to remain incarcerated while awaiting their trial before they have been convicted of any crime. The majority of people incarcerated in Maine jails are awaiting a trial. And given that LGBTQ people are more likely to be poor, cash bail is disproportionately burdensome to members of our community. Collectively, the rate of poverty amongst lesbian, gay, bisexual, and transgender people exceeds the rate for cisgender and heterosexual individuals. And transgender individuals experience poverty at an even higher rate. Given that LGBTQ people are more likely to be poor and therefore less likely to be able to pay bail, it should come as no surprise that persons incarcerated in jails are more likely to be LGBTQ. In one period studied, 6.2% of men and 35.7% of women in American prisons were sexual minorities, relative to 3.3% and 3.6% of the general population, respectively. Why such a large number of incarcerated women are sexual minorities is not perfectly clear, but this figure is consistent with LGBTQ poverty trends. Bisexual women also experience poverty at significantly higher rates than lesbians and gay men. This is particularly notable because a plurality of LGBTQ people are bisexual women. In addition to poverty, sexual minority women in general and bisexual women in particular experience sexual violence at higher rates than the rest of the population. Adding incarceration into the mix due to one's inability to pay bail would only compound these existing difficulties. While incarcerated LGBTQ people are also more likely to experience inhumane treatment relative to the general population in jails and prisons, LGBTQ people are more likely to be placed in solitary confinement, and transgender people are dramatically more likely to experience sexual assault. Transphobia and assault are not part of the punishment associated with incarceration, and experiences of discrimination are counterproductive to rehabilitation. Curtailing cash bail for Class C offenses and therefore limiting the amount of time an individual LGBTQ person spends in jail may help them avoid the most inhumane aspects of incarceration. As an organization that seeks to protect members of the LGBTQ community from discrimination and harm, we believe LD 1703 is consistent with our goals. Keeping LGBTQ people out of an unnecessary incarceration and at home in their communities allows them to remain close to the social support and resources needed for their well-being. While it may take many years for the economic gap between LGBTQ Americans and the general population to close, this bill will ensure that those experiencing poverty are not punished simply for their inability to pay bail. Thank you for your time, and please vote ought to pass.
Thank you, Ms. Melnick. Are there questions for Ms. Melnick from committee members? Seeing none, I actually have one, Ms. Melnick.
Sure.
I realize I may have missed my opportunity since we had more criminal defense attorneys up, but we keep talking about Class C crimes, Class C misdemeanor crimes. Could you give us some examples of what those charges are? What are the most common charges that have people in jail for bail on Class C misdemeanors?
Sure. I would have to pull that up for you. I apologize, but we can certainly get you drinking in public is one of those. It's a lot of these kind of what are sometimes seen as status offenses. And again, that's, I think, in part why these sorts of offenses are much more likely to impact low-income people. And those folks are also, again, less likely to be able to pay that cash bail petty theft, trespass on a beach. Getting some of these sent in to me as we're talking, but they're, again, these are not crimes that I think pose significant public safety concerns. And that's why they're a part of this list.
So if you're homeless, you might be drinking in public because you don't have a living room to sit in to have. Yeah,
that's absolutely right. And in response to Representative Thorne's questions, which I think, there was a lot in those questions, and I really, appreciate that. But I would just mention that it's particularly for folks who are experiencing struggles with substance use disorder. Kind of by definition, addiction is continuing that behavior, even when faced with very, very detrimental personal, professional, economic, and even criminal justice consequences. That's just kind of the nature of addiction. So even though I think part of the defined goals of our criminal justice system is to act as a deterrent, it's very difficult for it to have that sort of an impact for people who are engaging in these behaviors due to mental illness or substance use addiction.
Thank you, Ms. Melnick. Sure. Seeing no additional questions from committee members, I thank you very much for your time and testimony today.
Thank you for your time.
Appreciate it. Next, I would call upon Larry Dansinger. Larry, welcome back to the Judiciary Committee. Please begin your testimony as soon as you feel comfortable.
Thank you very much. Good morning, members of the Judiciary Committee. I'm Larry Dansinger. I live in Bangor, and I submitted some written testimony that I won't go through much of right now. However, I do want to echo what I think Tina Nato said earlier about the fact that in my experience and readings, being jailed actually contributes to further crime because people see themselves as criminals when they're jailed, rather than being let out of jail and seeing themselves as members of the community that can contribute something to the community. I want to emphasize 3 points. One is that there are other states and locations. New Jersey is one, District of Columbia is another, that have reduced or eliminated use of cash bail. Please look at their experiences as a sense of how well that idea has worked. Second of all, I have done a report which I will send to the committee regarding bail for people in Penobscot County Jail. I did this study of 143 people in the jail in August of 2019. And it breaks down by the amount of bail and the number of people with who were not given bail at all, et cetera, et cetera. So I think it's an interesting breakdown if you want to get a sense of what was going on before the pandemic. And the third thing is that when I think of bail, it just doesn't make sense. It seems illogical to me. If somebody is arrested for supposedly a crime, violation of the law, they are generally in two categories. One is that they are held, detained in some way because they're a danger to somebody in the community, or they're a flight risk. Other than that, they should be released because they're innocent until proven guilty. And what we've done is we've created this third animal, this third category that makes no sense, that only is there to determine whether somebody has enough money or not to get out. And it just does not make sense to me to have a simple system. Either you're held for some reason or you're released until you come to trial or appear before a judge. And then we throw in this third category that just discriminates based on how much money a person has. So I want to leave it at that. And I hope people will also look at the testimony I provided and the study that I will send to the committee. Thanks.
Thank you very much, sir. Are there questions for Larry? Seeing none, thank you very much for your time and testimony today. We greatly appreciate it, and we'll look towards your written testimony that you filed. Thank you. I will next recognize and welcome back to the Judiciary Committee, Mary Bonato. Ms. Bonato, please begin your 3-minute testimony as soon as you feel comfortable. You're muted. You're muted, Ms. Bonato. We can't hear you. Now
good morning, Representative Harnett, members of the Judiciary Committee. I apologize for the background. It's not supposed to be here. Speaking on behalf of GLBTQ legal advocates and defenders in support of 1703. And I'm doing so, as you've already heard today, on first principles grounds. You know, you've heard about we presume innocence. We presume innocence, not just delayed findings of guilt. In our system, we prize liberty and freedom and try to attempt to control the state's ability to incarcerate and restrict people's liberty and freedom. This bill is, in my mind, a very carefully structured path forward that does not eliminate cash bail, does not make sweeping reforms, but makes very targeted and important reforms on issues that are resulting in, as the judicial branch and others have reported, the majority of people in our jails being filled with people who have not been convicted of any crime, and the most serious crime they've alleged to have been able to commit was a Class E crime. So this is clearly a problem. You know this. I know you've all heard about this before, but from our perspective, some of the great things about this bill is that with respect to cash bail, again, you've already heard that cash bail will generally not be required for people, and that there is going to be more examination of an individual's ability to pay. It is not justice when you set a condition for freedom that you know someone cannot afford. And that's part of what this bill is trying to get at, is eliminating that current situation. In addition, the bill is clear that when financial conditions must be set, they have to be set under a clear and convincing evidence standard, or it is clear that the amount set is no more than necessary to ensure that an individual does not willfully flee the jurisdiction. Again, that's a reasonable reform because currently the situation is, under the statutes is, is this, we set these conditions to make sure that it's reasonable that the person is going to appear. And under that standard, this is helpful to make sure the person appears. We really have found that the default is to include people, to set these conditions. So the reorientation of the system we think is very important. And in addition, on personal recognizance, again, the standard is changed from reasonable assurance to imminent risk of flight. So in sum, I guess I would just say, my grandfather used to say to me sometimes in our spirited discussions, Mary, you need to slice the bologna more thinly. This bill does that across the board on bail. Thank you so much for your time.
Thank you very much, Ms. Bonato, for your time and testimony this morning. Are there questions from committee members for Ms. Bonato? Seeing none, again, we appreciate you taking the time to appear before us this morning. I see no additional hands raised for persons wishing to testify in support of LD 1703, but I will check the attendee room to make sure I didn't miss anybody. And it looks like we have Robert Cummins. If the committee clerk could move over Mr. Cummins to a panelist status so that we can hear his testimony. Welcome back to the Judiciary Committee, Mr. Cummins. As soon as you are comfortable, please unmute yourself, activate your video, and begin your 3-minute testimony.
I think I'm unmuted now.
Well, you're not muted anymore, but we cannot see you.
Well, I'm here, and I did not anticipate speaking to this issue. I would just respond.
Mr. Cummins, I don't know if you're far away from your mic, but I'm having difficulty hearing you. If you could move closer or speak a little louder.
I shall. Can you hear me now?
It's better. Thank you.
Hold on one second, see if this helps. Here we go. Hopefully you can hear me. I was not intending to speak on this issue. As you know, I'm a lawyer who practiced largely in Chicago for several decades, doing criminal work there. My first encounter with the bail system here in Maine educated me to the point that I was left with the irrevocable conclusion that it's entirely wrong-headed. But that's beyond the purview of your issue today. I support this bill because it's at least a step in the right direction. But in response to some questions, I think Steve asked a question about what's going on around the country. Illinois recently passed a criminal justice reform bill that is the only state in the United States now that has completely eliminated cash bail for all offenses. Bail hearings are now replaced with release hearings that I believe are the step in the right direction. In any case, I would encourage folks to consider and look at what Illinois has done, as well as what's happened in other jurisdictions. For all the reasons those in favor of this bill have articulated, the notion of cash bail is of the bygone era. It is prejudicial, it is unjust, and it is constitutionally impaired. That's it. I would encourage you to look at the Illinois experience. Thank you.
Thank you very much, Mr. Cummins. Are there questions from committee members for Mr. Cummins? I have one, sir. You mentioned the criminal justice reform in your old home state of Illinois. When did that occur?
Governor Pritzker has recently enacted the bill. I can send it to you, Representative Harnett, and it includes the reform of the bail system to a cashless bail system.
The reason I asked is I was wondering what their experience has been since that has been enacted, but it sounds like it was very recent.
Well, it's very recent, and in fact, it will not take place. It will not be finally and fully implemented until 2022 or 2023, I think.
Okay, thank you. Thank you, sir. Are there additional questions from committee members? Seeing none, thank you very much for taking the time to testify before us today.
Thank you, sir.
I will now go back to the attendee room to make sure there are no persons that still wish to testify in support of LD 1703, and seeing no electronic hands, excuse me, I will go to persons who wish to testify in opposition to LD 1703. If you could please raise your electronic hand so we can move you over as a panelist. And I will have the committee clerk move over. I believe it's Major Ross from the Department of Public Safety. And Major Ross, welcome back to the Judiciary Committee. It's good to see you again. Please begin your 3-minute testimony when you feel comfortable.
Thank you and good morning. Senator Carney, Representative Harnett, distinguished members of the Judiciary Committee. My name is Major William Ross. I'm here to represent the Department of Public Safety and the Maine State Police to testify against LD 1703, an act to amend the bail code. The bill as written would have a detrimental impact on public safety and officer safety, leading to repeat calls for service without the ability to impose bail for the offender. Bail is intended to ensure one's appearance in court and to protect the greater public. The law enforcement officer's ability is also hamstringed when these conditions are removed. There are instances where an arrest and not a summons would be the better choice for law enforcement to handle the situation. But when a summons is not the solution to the problem, an arrest may be the last resort to instill peace into an unfortunate situation. Currently, law enforcement officers have discretion with the ability to issue a summons in lieu of an arrest. There are times where a summons is more appropriate than an arrest and vice versa. Law enforcement encounter multiple incidents where taking someone into custody and deciding not to issue a summons is the more appropriate course of action regarding public safety. When a law enforcement officer is unable to take an offender into custody and no bail exists, essentially removing the problem from the area, these incidents, which usually start as a nuisance complaints, can quickly escalate, leading to more serious incidents and crimes. The bill would narrow the discretion of bail commissioners and judicial officers in setting bail, while prohibiting a financial condition from being imposed in some circumstances might make sense in a matter of public policy. Narrowing the discretion of judicial officers in setting bail in other ways the bill proposes would be a positive change as public policy matter. The bill requires the pretrial release on personal recognizance upon an unsecured appearance bond for a person charged with a Class C offense. Having the problem or offender return to the area after an arrest would most likely escalate the situation, would create more issues for the responding officers, further victimization, and put the community at greater risk. Secured bail and conditional release safeguard the victims of the initial crime and the community at large. Bail reform is an important topic for discussion. The Department of Public Safety and the state police are committed to constructive conversations related to the safety and well-being of all people. For these reasons, I strongly urge the committee to vote ought not to pass on this bill. On behalf of the Department of Public Safety and the Maine State Police, I thank you for your time. We'd be happy to try and answer any questions at this time.
Thank you very much, Major Ross. Are there questions from committee members for Major Ross? Representative Thorne.
Thank you, Mr. Chair, and welcome back, Major Ross, to Judiciary. We appreciate you being here today and helping us understand this bill. If you were king for the day, what would you do that would be a happy compromise to this bill and the bail overhaul that you alluded to?
Well, thank you for the question. If I were king for a day with this bill, I think I'd like, first of all, I think compromise is the key here. I think there are things that can be done. I think there are some issues around bail reform. And I think there can be some positive changes. From the law enforcement side, we would like to protect some of the Class E crimes, such as disorderly conduct, failure to disperse, harassment, criminal trespass. And I know these sound like, more nuisance type calls. These are the types of things that can escalate into bigger problems. And I think addressing them early on and frequently is much better than kind of letting them like snowball into bigger problems where now you have people assaulting each other, where before the problem could have been removed with one of these lesser crimes. With respect to the cash bail part of it, I think there's a lot of work that can be done there. I understand that Indigenous people are having a very difficult time, with this portion of it, but it's also to ensure their appearance in court. One of the problems we come up with is when people don't report to court as they've promised to do so, then there's a warrant for failure to appear, or or further down the road, a warrant for failure to pay a fine, and that just kind of starts this cycle all over again. Law enforcement's tasked with then tracking down these types of warrants, and sometimes people come peacefully, sometimes people don't. But I think that's unnecessary if those types of situations kind of morph into a bigger problem than they are now, because there's a lot of warrants out there for failure to appear or failure to pay fines. We'd like to keep that down and not escalate those potential conflicts. And we certainly agree with the gross sexual assault, domestic violence language. There was some failure to appear language that was in the bill that we thought was good. There also needs to be other stakeholders involved, certainly the sheriff's department and the judicial branch, with respect to, what are bail commissioners, how are they trained? What are they going to be doing? How are they paid? Should it be a more permanent part of either the court system or the correctional system? Those are questions more for, I think, administratively in those departments, something that law enforcement probably won't put our hands on, but certainly would like to weigh in if those opportunities present itself.
Yeah, a follow-up question, if I may, Mr. Chair.
Yes, you may, Representative. Go ahead.
Thank you. Major Ross, would you agree that most of the lower crime offenders are repeat offenders? And I have a follow-up to that. If that is the case, which I think I've heard people testify as such, would that be a condition on their future bail conditions as possibly a deterrent for those non-drug related issues, those lower crimes that you've mentioned?
Well, I think it's a mix. You certainly have repeat offenders, and you certainly have your first time offenders, particularly with this Class E category. Someone had mentioned the public intoxication, the disorderly conduct. You see young people typically get involved in that type of stuff, and hopefully they learn later on in their life that those aren't the things that you should be doing. But with respect to it being a deterrent, I believe already in the main bail code that that's built into some of the discretion the bail commissioners have with respect to people that are maybe not repeat offenders, but have maybe not held true to their bail conditions in the past. I'd like to think that a lot of this is a deterrent. I think it's a pretty complicated subject. For some people, it is. You don't have a problem with them again. And then for other people, certainly substance abuse, it becomes a little bit more complicated. There needs to be more resources as part of the fix than just bail reform.
Thank you for that. Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Moriarty.
Thank you, Mr. Chair. Major Ross, one of the issues we haven't touched on at great length is that of whether the violation of a condition of bail should be a separate crime in and of itself. What is your opinion on that point?
I believe, and I think the Department of Public Safety believes, that it should be a separate crime, violation of a conditional release. Those conditions are set as part of the bail, and they're expected to be followed. And when they're violated, then that should become another crime.
Okay, thank you for sharing that with us. Thank you.
Thank you, Representative Moriarty. Representative Babbage.
Thank you, Mr. Chair. Major Ross, thank you for testifying. And I wanted to pursue and understand your thinking regarding the equity issue, which the bill tries to address. When you're talking about not having a situation escalate by removing them from the situation and that period of incarceration that allows for that de-escalation, I guess is what you're saying. How does that relate to the person that makes bail? I mean, because what we're seeing here obviously is different consequences and length of incarceration depending on the ability to make bail.
Thank you for the question.
How long does the bail process take? And is escalation a concern for those that do make bail?
I'll take that in two parts. For the people that are bailed, what's the likelihood of them going right back? Because how long does bail take? Depends how far you are from the jail. Portland's very different than, say, Parsonsfield. That's different from Caratunk. That's different from any other, further remote area. So all of that will come into play. But once you're actually at the jail and a bail commissioner is there, it doesn't take very long to process an individual, 45 minutes to an hour tops. If the person makes bail, then they're out. So they're released from jail. They either need a ride, get a cab. Unfortunately, sometimes people start walking. So that's what that looks like. And an individual that is bailed can certainly go back to right where the problem area was and start all over again. Fortunately, they would have conditions of their release, which if law enforcement had to go back to that scene, instead of looking for that separate crime to occur, they may be able to arrest on the violation of the conditional release. One might be not to return to a certain residence. Obviously, if it's their residence, that maybe not be the case. But if it was a party or, some type of neighborhood gathering or something like that. So there's protections there, and that helps law enforcement de-escalate and not let the other parties say, well, if the police aren't going to do something, we're going to get involved now. And then we're not talking about Class E crimes, we're D crimes, C crimes, where we move up to like assault and criminal threatening and that type of stuff. In terms of the equity portion of this, when law enforcement are involved, we're looking at the situation. We're down on the ground, and I understand what it looks like from 30,000 feet, but when you get down on the ground, it's about handling the problem that's right in front of you the most efficient way. And if that means making the decision to arrest someone instead of summons them, of course, you've probably given a couple of warnings. Then at that point, we want to take them to jail after they've been arrested. And we turn it over to the bail commissioner. I think this is where the equity issue comes into play. What is the bail commissioner doing? They're having a conversation with the law enforcement officer, and they're determining whether or not, what's going to ensure that this person's going to show up for their court date, and what type of a risk they are if they're released. So that's the conversation, and that's kind of the extent of the law enforcement's role at that point in time. Obviously, they come back in with respect to the criminal case as it moves forward in the courts. So in terms of that type of equity, that question of equity, the dollar amount, I think there's room for discussion there. And I don't know exactly what the answer is for that, other than I know that it helps in terms of ensuring that people are going to be responding to those conditions to return back and go to court.
Thank you for the response, Major Ross, and thank you, Mr. Chair.
Thank you, Representative Babbage. Are there additional questions from committee members? If not, thank you very much for your time and testimony today, Major Ross.
Thank you.
I'm sorry, I did see an additional hand come up. Representative Sheehan, sorry I missed you.
It's okay. Thank you, Mr. Chair, and thank you so much, Major Ross. I would love for the work session to have some numbers to what you were just talking about. I think we're hearing a lot about the deterrent effect that cash bail conditions actually play. And I would like to see some numbers on this for sure. If you are the right person to ask for that. And I also just wanted to follow up on a couple of things. You mentioned that you think there should be a broader representation of stakeholders in considering amendments to the bail code. And my understanding is that this has been looked at by the Pretrial Justice Task Force. And I'm wondering who you think is missing from the conversation.
Thank you for the question. I don't know if anyone's missing. Well, for instance, today we didn't hear testimony from some of the stakeholders that I think would have been, more in line to answer questions about bail commissioners, maybe a bail commissioner, maybe someone from the sheriff's department, certainly about their process and some of the issues that they have with this. Possibly an administrator from the judicial branch. They can talk about more on how the bail process works through their system. We've heard from people that were defense attorneys or one-time prosecutors. You've heard from law enforcement, other concerned groups, all of which I think are important. But I think there's other people that have probably been to the table. But in terms of discussing this bill today, I didn't see that.
Thanks so much. And then the other question that I had was just a point of clarification. Within your testimony, you indicated that the changes proposed here could compromise an officer's ability to take an offender into custody. And I just wanted to hear more about why that is.
That's about, thank you for the question. That's about the Class E crime. And in other similar bills, there's been talk of removing Class E crimes or not making Class E crimes an arrestable offense. My concern is in all of these bail reform bills is to safeguard other crimes in addition to domestic violence, gross sexual assault, failure to appear, the disorderly conducts, the unlawful assemblies, the failure to disperse, the criminal trespasses. Those are all nuisance crimes, and on their face value, they may not seem like they're a big deal, but they are a big deal. These are how some of these really bad incidents start off, as just these small kind of nuisance crimes, and they snowball into something much bigger. So that's what I was referring to in that comment in my testimony. I want to make sure that there's safeguards and carve-outs for things additionally than domestic violence, gross sexual assault, and failure to appear.
But to be clear, law enforcement officers can still take alleged offenders into custody for these alleged crimes and can still offer bail conditions, just not cash bail.
As it stands right now, yes, we can still arrest, we can summons, we can do a number of things, and I'm concerned that if we lose the ability to bring people into custody for some of these Class E crimes, or lose the ability to a bail commissioner to issue cash bail in certain conditions, that it could lead to bigger problems and an escalation of problems when that individual goes back to the area where the problem initially existed.
Thanks so much for your patience. I'm sure I'll have more questions, but I'll follow up with our analysts. Thank you so much, Major Ross.
Thank you.
Representative Thorne, do you have an additional question for Major Ross?
Thank you, Mr. Chair. I'll make it very brief. Major Ross, I asked two of the other proponents if they knew how many people were currently incarcerated that apply to what this bill seeks to overturn. In other words, do you know how many people are incarcerated today in Maine jails solely because they can't post bail?
I do not have an answer for that.
Okay. Thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Senator Keim.
Thank you. Thank you for being here, Major Ross. I following up, I had two questions, and one was actually sparked by Representative Sheehan's question about the voices that are maybe missing from the conversation, and not only today, but in other bills that we hear. What seems to be missing to me is the voice of victims as we consider bills. And except for domestic violence, victims of domestic violence are well represented in our committee, but victims often are not. I wonder if you have anything that you could suggest where we would be making sure that we're hearing from them, and if victims are in fact have any way for them to be more represented as we consider the changes.
Thank you for the question. Great question and great observation too. Victims of the group of Class E crimes that I was referring to, disorderly conduct, they're certainly not going to be looked at as domestic violence victims and gross sexual assault victims, people that need more resources, more services, certainly more severe crimes are occurring in those two areas. To get victims of these other types of crimes in here to discuss this, I think would be a benefit when you talk about people that are having neighborhood disputes and other types of issues, criminal trespass on private property, harassment, everything right down to something as simple as noise complaints in a neighborhood. But when they don't stop and they continue and people are up at 3 o'clock in the morning, if the police don't have an intervention, and they do, multiple warnings before some type of action is taken, if that never occurs, it's going to escalate. It almost always does. So having that voice out and that voice heard, but I think a lot of those people, once the problem goes away, once it's taken care of, I think they're fine with just the activity stopping. And I think the court does a pretty good job of processing those types of crimes. Stopping the action as it's unfolding is one thing, and how it works its way through the criminal justice system is another.
Thank you. Yeah, so I think that it just solidifies that we're not hearing from those other types of victims, and maybe there isn't a good way to capture that. But if you had further insight on that, I would appreciate you offering it at another time if you thought on that. The other question I had for you was, in New York, they did create changes in the bail system, and it seemed to have really bad effects, just increased crime. And I know that the changes there were larger than what we're proposing here. They got rid of cash bail altogether. But how do you see the overlap between what we're proposing here and what happened in New York? And if you're not familiar with that, that's fine. You don't need to answer the question.
I'm not overly familiar with New York, even though I'm a native New Yorker. I do know that they've made changes to what they've initially done. I don't think what Representative Talbot Ross is proposing here is anywhere near the level of what that bail reform was in New York State and New York City.
Thank you.
Thank you, Senator Keim. Are there additional questions for Major Ross from committee members? Seeing none, thank you very much for your appearance today. We appreciate your time and testimony, Major Ross.
Thank you.
I will go back to the attendee room to make certain that I've captured all persons who wish to testify in opposition to LD 1703. If I missed anyone, please raise your electronic hand. Seeing none, I will turn to those persons who wish to testify neither for nor against LD 1703. And I would ask to have those persons moved over onto the panel. And I would begin with Andrea Mancuso. Ms. Mancuso, nice to see you again in front of the Judiciary Committee. Please begin your 3-minute testimony as soon as you're comfortable.
Thank you. Good morning, Senator Kearney, Representative Harnett, members of the committee. My name is Andrea Mancuso. I'm here today on behalf of the Maine Coalition to End Domestic Violence and our network of programs regarding LD 1703. To be clear, MCDV supports 11 of the 13 proposed sections in this bill, and the entirety of the bill as it applies to financial conditions, the cash bail that has been frequently referred to. I would echo the comments you've heard earlier about cash bail. It's a rare occasion in our experience that an abuser with wealth is held pretrial beyond the initial catch and release, absent a homicide or an attempted homicide, regardless of the risk they pose to their partner. Our cash bail system is broken, inequitable, largely ineffective, and reforms to cash bail that are proposed here move that ball forward. However, we are very concerned with the language in parts in sections 5 and 6, in part, that would require a clear and convincing evidence standard in order to issue any conditions of release on a defendant, including all non-financial conditions, and believe that will have impact on victim participation in the process and the ability of the criminal courts to attend to short-term safety concerns. 3 minutes is a hard ask to fully engage in the nuance of why we're taking that position. I've submitted written testimony that attempts to outline these concerns more completely. The pretrial task force has been mentioned this morning. I would really encourage you to engage in that report as you consider this bill. We participated extensively in that task force. I would agree with Attorney Nadeau that the bill is largely reflective of the recommendations of that task force, with the notable exception of the 2 pieces that we stand here before you today expressing concerns about. I'd urge you to keep in mind that Maine, unlike many other states, does not have a separate order of protection or a no contact order for domestic abuse victims that is issued out of the criminal court at the initial appearance. These orders are imposed via bail conditions, and a clear and convincing evidence standard to impose any non-financial condition of release would change the ability of our criminal courts to issue these conditions. It would act to put a burden on victims of crime to participate by way of testimony at a stage in the criminal prosecution that is typically far beyond the point at which many will have assessed that it is safe for them to do so. It is our understanding that in states where the preponderance standard is adopted for non-financial conditions in domestic abuse cases, reliable hearsay that Attorney Nadeau discussed with you this morning is successful in keeping victims out of court for the reasons that she's articulated. It is our understanding that in states that use a clear and convincing evidence standard, even with the lax rules of evidence, that does result in victims being asked to appear in court for bail hearings. And we have significant concerns about adopting that process in Maine. Under current law, it's rare that the court ever needs to hear from a victim at the initial appearance. There are some pieces of our bail code that speak directly to these cases. The court is presented with an incident report, the results of a validated risk assessment tool, the ODARA, and other statutorily required information that is specific to what needs to be collected and presented to people considering pre-conviction bail in domestic violence cases. I'd ask you to consider there's no good data available to demonstrate that judges are making inappropriate decisions when it comes to the issuance of non-financial conditions that are designed to protect victims.
I'm going to stop you for a second. Okay, that's been muted. Somebody had another mic on. So it's not going to count against your time. Sorry to not.
All right. It may be that we need to entirely rethink the processes and types of orders that are issued as part of bail and the initial appearance process. The task force, the pretrial task force did convene several meetings to attempt to find a solution to these issues. There's not a simple one that's identified. It would require a thoughtful overhaul of several sections of the bail code and processes, and the task force ran out of time to do this. It's a conversation we would enthusiastically re-engage in, but I would submit to you that the inclusion of the 4 words by clear and convincing evidence into the bail code is not a thoughtful way to accomplish this and could have unintended consequences and harm. So thank you for the ability to share this perspective. I'm happy to take any questions and happy to work with interested stakeholders as the process continues.
Thank you very much, Ms. Mancuso. Are there questions from committee members for Ms. Mancuso? Representative Moriarty.
Thank you, Mr. Chair. Ms. Mancuso, I've got to ask you a really trivial question. The bill repeatedly uses the phrase judicial officer. Is this just a way of avoiding the constant repetition of judge and justice, or does it refer to some other official?
I am not the best person to answer that. I think there are after hours processes in place that might include someone other than a judge or a justice, and that might actually refer to a bail commissioner. So I would lean on someone with more technical expertise than I do for that definition. And I suspect Ann Jordan from the judicial branch could give it to you off the top of her head.
Very good. Thank you.
Thank you, Representative Moriarty. Are there additional questions for Ms. Mancuso from committee members? Seeing none, thank you very much for your time and testimony this morning. We appreciate you appearing before the committee.
Thank you.
And I now welcome back to the Judiciary Committee, District Attorney Sarbeck. You may begin your testimony as soon as you feel comfortable. It's good to see you again.
Good morning, Representative Harnett and members of the committee. Thank you very much for having me. I'm Jonathan Sarbeck. I'm the district attorney here in Cumberland County. I'm here to testify neither for nor against LD 1703. I recognize many of the issues that have been brought up by the proponents for it, including the sponsor, Representative Talbot Ross. She makes some very good points. To me, a wealth-based bail system is not the perfect system. It's actually very imperfect. When we consider who the most dangerous people are, those people might have those means that are going to get them out of jail. And I've seen it happen. I've seen individuals who have posted $50,000 cash bail on elevated aggravated assault charges. To me, that person should be behind bars because of the dangerousness. And if a judge would find that person to be dangerous, they should be held until the trial. I would recognize that Washington, D.C. has had a system in place since the 90s, and I've found out some good information about what they do. And the system is so incorporated that the prosecutors very easily maneuver around that system. And I think if Maine really wants to adopt or look at a place where this has been working for a long time, Washington, D.C. might be a key part. One of the big aspects, though, that Washington, D.C. has that Maine doesn't have is a very robust pretrial system. Maine does have a great organization, Maine Pretrial Services, that helps out. At the same time, though, their capacity is limited, and so those resources are limited. But they do some great services to provide somebody with conditions of release and that supervision that's going to ensure the safety of the community. With regards to the bill itself, the Class E crimes, I would just point out is that oftentimes you have individuals who are being held pre-trial because they have numerous cases open, numerous dockets. And sometimes if they're on a no bail hold because of a probation violation or a motion to revoke, they might have some Class E misdemeanors that go along with it. From the practical side of it, we actually put cash bail on those Class E misdemeanors only so that that person can get jail credit time. Because if there's no bail during that time that somebody's incarcerated on another offense, at the end of, if they do decide to plea out that case, they are not going to get that time credit on those particular cases. So just from a practical standpoint, I think that might be something that we would want to look at, because I think there'd be a lot of defense attorneys that would agree that they would want their client to get that time credit if they are behind bars. That's not to say, though, that we can't rework this, because numerous Class E offenses don't get bail. They are people who walk in on a summons arraignment, and the state is not asking for bail in those types of situations. And then the other concerns are just basically sort of what Ms. Mancuso just talked about, the clear and convincing evidence standard. If for people who aren't familiar, basically you have probable cause, which is almost that lowest threshold for police officers, then preponderance of the evidence, clear and convincing evidence, and then the proof beyond a reasonable doubt, which is our trial burden. Yes, I'll be really quick. When I practiced in Massachusetts, which has that dangerousness hearing as a bail condition, the standard down there was clear and convincing evidence, which made it so a judge would actually have to hear that evidence and find by clear and convincing evidence that that person is a danger. And in those cases, we would have to call live testimony. Attorney Nader was completely right that the state can make a case. However, there's just one point out that sometimes it's whether or not we can sustain the burden. But I'd be happy to answer any questions.
Thank you. I will now turn to the committee for questions of District Attorney Sarbeck. Representative Thorne.
Thank you, Mr. Chair. Welcome, District Attorney Sarbeck. We're trying to hear all kinds of different aspects of how the bail system is broken, I guess, in Maine that needs to be fixed. Do you have a relief valve? I know that bail commissioners and judicial officers have the ability to either set no bail, being held on no bail, being held on certain bail amounts, or PR, personal recognizance. Do you find that Cumberland County's, your colleagues in correctional facilities and sheriff's department and so forth are handcuffed with no ability to manipulate the system to control the level and the severity and the ability to release defendants that pose no harm, but yet can't provide their own bail?
So what we try to do in Cumberland County is, one, we definitely consider the financial capacities of a person. And if somebody is experiencing homelessness, then that's something that we need to consider when it comes to if bail is necessary. We do have situations where people fail to appear to court. And in those situations, we have to take that step, possibly to request cash bail in order to get the judicial process going. In Cumberland County, we have about 200 inmates being held pretrial right now, and about 2/3 of those individuals have 2 or more open cases in Cumberland County. And I'd say probably from an estimate, about 3/4 of that 2/3 are on no bail holds, meaning that they've either been held on a probation violation that a judge has said there's not going to be bail, or there's been a motion to revoke their bail that was filed by my office with the idea that this person is a danger to the community. That's the standard that I've asked my prosecutors to look at when there is somebody who has an open case and then they pick up a new criminal case, whether or not they're posing a danger. Because I don't think that if somebody has 2 misdemeanors that they should automatically be held without bail. But if you do have somebody that's being held on a misdemeanor domestic violence case, and then they contact the victim in that case, then that's a situation where we may be asking for that person to be held without bail. So I think what we try to do is I periodically try to get
Appears we have some technical difficulty with District Attorney Sarbeck's internet right now. I'm going to give it a couple of seconds. But what I will do now is
$500 cash. I reached out to the prosecutor and said, can you look into this? And sometimes that person's being held on $500 cash in Cumberland County, but they're also being held on another docket in another county. So they're just basically being housed in Cumberland County.
Quick follow-up, Mr. Chair.
Yes, Representative Thorne.
Thank you. District Attorney Sarbeck, I've asked a couple different folks providing testimony to this question. Didn't know if you might be able to answer. You said roughly 2/3 of the 200 incarcerated right now.
Did we lose Representative Thorne, or did I lose?
And ironically, we lost you just before, so it must be something you two are doing.
I think I actually kind of knew what his question was going to be, so I'll try to answer it. Because I've heard him ask some other people. I would say, quite frankly, that everybody who's being held, unless you're being held on no bail, if there's a cash component to your bail, you can't afford that bail if you were in jail right now. Because I don't know of many individuals who would want to be in jail if they could afford that bail. So unless there's a no bail hold connected to one of your cases, I would say, quite frankly, that any individuals who's being held on cash bail can't make that cash bail. But I just, in reference though, I also have a case, a home invasion case that we're prosecuting in Cumberland County, where the individual is being held on $250,000 cash bail. And I know that person probably can't make that bail, but there's a reason that the bail is that high, given the danger that I believe, and the court agreed with me, that person poses to the community.
Thank you, District Attorney Sarbeck. And if Representative Thorne returns, we will let him know that you responded to what you thought was his question, and I believe you did get it accurately.
And I might have been wrong on that, but I'm trying to keep things moving.
Are there additional questions for District Attorney Sarbeck from committee members? Seeing none, thank you very much for your time and testimony today. We always appreciate your input.
All right, thank you, sir. Have a good day, everybody.
Thank you. The next person I have registered to testify neither for nor against is Julia Finn from the Judicial Department. Welcome back to the committee, Ms. Finn. Please begin your testimony as soon as you feel comfortable.
Thank you very much. And you will not even need to set your timer because my testimony is quite brief. Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. My name is Julie Finn, and I am here representing the judicial branch this morning. I appear to testify neither for nor against LD 1703. The judicial branch takes no position on the proposed amendments to the main bail code because those modifications reflect policy decisions upon which the judicial branch does not comment. The judicial branch commends the hard work and effort undertaken by the sponsor and other proponents of this bill. The modifications will require the reprogramming of bail forms for use within our existing and future case management systems, but we do not foresee any necessity for a fiscal note at this time. And if I could, since I have extra time, I just wanted to, Representative Moriarty asked earlier about the definition of the term judicial officer. And I just wanted to add that for purposes of this bill, the bail commissioners are considered judicial officers. So that's it. Thank you very much. I'll answer any questions if you have any.
Thank you, Ms. Finn. And I did not even strike the clock. I trusted you. I appreciate your brief testimony. Are there questions for Ms. Finn from committee members? And seeing none, again, thank you very much for your time and testimony today. And as you know, brevity is always appreciated.
Thank you.
And with that, I will check the attendee room to see if there are any other persons wishing to testify neither for nor against LD 1703. And seeing none, I will now close the public hearing on LD 1703. And I thank the committee members and all those who came and testified before the committee this morning. And at this point, I want to do two things. One, we had two committee members join us who did not have the opportunity to introduce themselves this morning. Representative Evangelos, if you would like to introduce yourself to those in attendance.
Good morning, Mr. Chair. Thank you. Jeffrey Evangelos, House District 91, and I live in Friendship.
Thank you, Representative. And Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County and two communities in Androscoggin.
Thank you and welcome. At this point, I'm about to turn the gavel over to my Senate co-chair, Senator Carney, but I know that I need a 5-minute break. So I am going to put us into recess until 11:35. And when we come back, Senator Carney will be chairing as I will be presenting some bills. So see everybody in 5 minutes. Please mute yourselves and shut off your cameras.
Hello, committee members. It is 11:35, and so if you are back at your desks, could you please activate your cameras? Thank you.
Senator Carney, would you like me to time for you when you are chairing?
I'm going to try multitasking since you'll be introducing the bills.
That's fine.
But thank you for offering. I was sorry to miss that really interesting discussion about the bail code this morning. I was in ENR and I caught some of it when I returned, but I would have liked, I'll go back and watch the early part. It was very interesting. Okay, it looks like there are quite a number of committee members back. Excuse me. So we'll resume our public hearings today. And I think we're taking these in order. Just check our list here. Yep. Okay, so we'll welcome back, everyone. We are resuming our public hearings, and I'm going to start by opening the public hearing on LD 1685. That's an act to protect the constitutional rights of indigent defendants. It is being presented by our co-chair, Representative Harnett, and it is actually a committee bill. We are authorized by statute to report out legislation in response to a report that we received from the Commission on Indigent Legal Services. And with that, the floor is yours, Representative Harnett.
Thank you very much, Madam Co-Chair. Senator Carney and esteemed colleagues of the Judiciary Committee, my name is Tom Harnett, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside. And I'm here today to introduce LD 1685, a committee bill, an act to protect the constitutional rights of indigent defendants. This bill accomplishes three major things. First, it gives the judicial branch the ability to financially screen individuals in order to determine whether they qualify for indigent legal services. This function is currently carried out by the Maine Commission on Indigent Legal Services. Second, it repeals current requirements of the Maine Commission on Indigent Legal Services in indigency determinations and collection efforts. Those requirements are transferred to the Supreme Judicial Court. This move is designed to help eliminate any possible or perceived conflicts of interest in the determination of these decisions. Finally, this bill prohibits prosecutors from communicating with unrepresented defendants. There is an exception to this, and in order to meet the requirements of that exception, a defendant must waive their right to counsel in writing after they have been informed of their right to appointed counsel, and the court has provided them with the required statement of rights, including the substance of the charges against them, their right to counsel, their right to remain silent, the maximum sentence they face, and their right to a jury trial. This ensures that a defendant's waiver of the right to counsel is knowing, voluntary, and intelligent. Just yesterday, I was contacted by District Attorney for Cumberland County, Jonathan Sarbeck, to entertain an amendment to create an exception to allow a member of the District Attorney's Office to communicate with an unrepresented defendant if the purpose of that communication is for the District Attorney's Office to offer the defendant the option to participate in a pre-arraignment diversion program in which the successful completion of that program results in a dismissal or non-prosecution of the charges without a guilty plea. His request is to make certain that the extraordinarily successful program of restorative justice and diversion programs can continue. I have assured District Attorney Sarbeck that I will work with him and other stakeholders in advance of the work session on this bill to do all that we can do to keep as many people as we are able from never entering the criminal justice system, if at all possible. I thank the committee for their time and would be happy to answer any questions you might have for me. But as I will tell you on this bill and the next two that I will introduce, you're going to hear from people with a lot more knowledge of the nuts and bolts of the workings of the indigent criminal legal system. So you might want to hold your questions until that time. But again, thank you for your time and consideration.
Thank you so much, Representative Harnett. Committee members, are there any questions for our colleague? I am not seeing any, so we appreciate you presenting this committee bill, Representative Harnett. And I will now turn to the attendee portion of the meeting and ask everyone who is here who wishes to speak in support of LD 1685 to please raise your electronic hand and keep your electronic hand raised until after you've had an opportunity to testify. Okay, I'm seeing one person, and that is a couple people. Jan Collins, you are coming over first. Welcome, Jan Collins. Please proceed with your testimony.
Thank you so much. And you might have seen two of me. That's maybe why you hesitated there for a minute. I've been having terrible problems with my internet, so I had a backup. Greetings, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Jan Collins. I am Assistant Director of Maine Prisoner Advocacy Coalition, and I am writing to support LD 1685, an act to protect the constitutional rights of indigent defendants. And I do thank everyone for bringing this bill forward and the next two, because they are so important and much needed. The Sixth Amendment of the U.S. Constitution guarantees a right to adequate legal counsel for the accused. The provision was included to correct the wrongs experienced by their revolutionary compatriots, incarceration and sometimes death without a trial or by trial without defense. As with many constitutional provisions, the Sixth Amendment protections serve as a check on the overwhelming power of the state. Without it, the powerless are at the mercy of the government, and the innocent may easily find themselves behind bars. The protections of the Sixth Amendment must be robust if they are to be effective. For years pre-pandemic, I attended monthly meetings of the Maine State Prison NAACP. As a result, I'm one of a small number of citizens outside of corrections professionals or attorneys who have a broad perspective on who gets incarcerated in Maine. At one meeting at Maine State Prison, those who had hired their own attorney, as opposed to having one assigned, were asked to raise their hand. In a room with more than 40 residents in attendance, only 3 people raised their hands. The remainder had been deemed indigent. I do not think that the poor are inherently more prone to criminal behavior. I grew up in poverty, as I'm sure others in this room have, and I have not been involved in the criminal justice system. So why do the indigent have such poor outcomes in Maine's courts? Although I am sure that there is more than one answer to that question, I'm equally sure that some of the answers can be found in the 2019 report by the Sixth Amendment Center evaluating the Maine Commission on Indigent Legal Services. The transfer of responsibility for determination of indigence to the impartial judicial branch and the prohibition against prosecutors communicating with an unrepresented defendant are long overdue. It was unimaginable to me that such a practice had ever been accepted in Maine. Thank you so much for bringing this bill forward and for your support of LD 1685, an act to protect the constitutional rights of indigent defendants.
Thank you, Jan Collins. Community members, are there any questions for Jan Collins? Not seeing any. We appreciate you being here today.
Thank you so much.
Next, we'll hear from Robert Ruffner. I'm going to bring over the other individuals who asked to speak in support of this bill. And Robert Ruffner, you can go ahead when you're ready and activate your audio and video and begin.
Hello, my name is Robert Ruffner. I'm from Yarmouth, Maine. I'm in the wilds.
We're not able to hear you.
Did I not?
There you
Do
go.
you hear me now? Okay. My name is Robert Ruffner. I'm from Yarmouth, Maine, and I'm testifying in favor of this bill. I think that I've already spoken about the issues of prosecutors talking to unrepresented individuals last session. I won't repeat that. I believe that the steps moving the screening function to the judicial branch are appropriate and will go a long way to ensuring impartiality of those determinations. In effect, in large parts of the state and during the pandemic, it's a function that has already been done by the judicial branch. And ultimately, it is a judge that decides whether an individual is indigent, not any commission or administrator. Again, I thank you for the time in this bill. I hope you will vote ought to pass. Thank you.
Thank you very much. Committee members, are there any questions for Robert Ruffner? I'm not seeing any. We appreciate you being here today and thank you for your testimony.
Thank you. I'll be on some of the other bills and we'll try to have better service at that time.
Great, appreciate it. Next, we'll hear from Doug Dunbar. You can go ahead and present your testimony.
Thank you, Senator Carney and members of the committee. I didn't intend to testify until I heard Representative Harnett talk about the amendment from District Attorney Sarbeck, who I have great respect for, and I know the amendment concept is very well intentioned, and you folks may decide it makes perfect sense. I would be concerned about what those conversations turn into if the intent initially is to talk about a diversion program, which I'm all in favor for. You talk with the folks here in Penobscot County, Doug Dunbar talks about diversion all the time, keeping people out of jail. So I appreciate that the amendment would allow unrepresented people to engage in conversations with someone from a district attorney's office if the focus is supposed to be on talking about a diversion program. But I do wonder, what does that lead to? That may be the original intent. It may not even be the intent, but it might be used to get to something else, not a diversion program. That would be my concern. So I wanted to mention that, and I'll appear on, and hopefully that made sense. I'll be back for another bill, but I just want to say I'm glad you're taking both the bail bill and the bills regarding the indigent legal service systems up on the same day, because I view them, since I went to jail. And by the way, we don't hear, as Senator Keim mentioned, the victims. People who go to jail and spend time, and their families and their employers and their landlords, they're also the victims in the system if they're there unfairly, unjustly, if they're held too long, unfairly, unjustly. They too are victims, and we don't hear from them. So I'm here to speak for them in a way. But I view bail, cash bail, the current system, and the indigent legal services systems as the great 1-2 punch to the poor and the ill in the state. It's the great 1-2 punch. You go to jail, you can't get out because you can't come up with $500. Your life unravels. Did you have an apartment? It's gone. Did you have a job? It's gone. And on and on and on. And then you're assigned an attorney who's paid $60 an hour. And too often, too many of them don't pay attention to your case. You see that attorney for maybe 2 minutes, 5 minutes if you're lucky, before you go into jail. I mean, before you go into court, That's what happens. And I remember Representative Babbage used to come to the Secretary of State's office with your students. And we used to have a program called the Citizen Bee. And we talked about civics and government and the way things are. We were wrong, Representative Babbage. I'm sorry, we were wrong. They don't play out that way. There is not equal justice under the law. Thank you.
Mr. Dunbar, thank you so much. Appreciate your testimony this morning still. Committee members, are there any questions for Doug Dunbar? I'm not seeing any. Again, many thanks. And next we will hear from Megan Sway. And Megan Sway, if you can activate your audio and video and begin, please.
Thank you. Good morning, Senator Carney, Representative Harnett, and members of the committee. Again, my name is Megan Sway, and I'm Policy Director at the ACLU of Maine. On behalf of our members, I'm here in support of LD 1685. The Sixth Amendment Center, a national organization with expertise on the right to counsel, was hired by the legislature to do an investigation, and it issued its findings and recommendations more than 2 years ago. The report's second finding was that although the court's advice of rights video has many admirable qualities, few courts follow up with a colloquy to ensure that defendants saw the video and comprehend their rights before waiving counsel. Some prosecutors and some jurisdictions engage in plea discussions with uncounseled defendants, and some courts actively encourage such negotiations. This makes sense because misdemeanors, which are charges that have as a potential penalty less than a year in jail time, make up approximately 80% of state criminal court dockets nationwide, and the numbers in Maine are similar. The increase in misdemeanor cases over the past several decades has created an increasing administrative burden on courts and prosecutors. Most misdemeanor charges are resolved by plea deals, and first appearance days are incredibly busy, time-pressured situations where prosecutors, judges, and defendants are all incentivized to get through the docket as quickly as possible. These days, a criminal record can prevent a person from getting housing or employment, or sometimes even education. The collateral consequences of a conviction are serious and wide-reaching, but they're not often on the forefront of most people's minds as they're trying to get through a long and trying docket call as efficiently as possible. LD 1685 would allow a little space for defendants to stop and consider the ramifications of proceeding without a lawyer, and perhaps to avoid the criminal conviction altogether. The stakes of an ill-considered plea are high, and the waiver that this bill provides is not unduly long or burdensome. For those reasons, we urge you ought to pass. Thank you.
Thank you very much. Committee members, are there any questions for Megan Sway? Not seeing any. Appreciate you being here this morning. Next, we will hear from Tina Nato. Go ahead.
Good morning, Senator Carney, and good morning, everyone again. I'm here today on behalf of the Maine Association of Criminal Defense Lawyers to provide testimony in support of LD 1685. I can also provide some practitioner context about how Lawyer of the Day arraignments go and any questions the committee might have about the practical realities of this. MACDL supports first that the financial screening function be transferred back over to the judiciary. There's a conflict inherent that was made clear in the Sixth Amendment report about financial screeners being employees of the commission and screening people and attempting to collect money from them, who are ostensibly all of our clients. Additionally, at this point, screeners only provide an advisory function to the judiciary, so they're doing a lot of work for the judiciary, but ultimately the judges can overrule that decision and appoint counsel and find indigents regardless. So it makes sense to have that back under the purview of the judiciary. Regarding the second portion of the bill, we do support a prohibition against prosecutors speaking with unrepresented defendants who have not knowingly or intelligently waived their right to counsel. I understand there might be some sort of amendment or proposed amendment by Attorney Sarbeck floating around. I have not seen it. I kind of anticipated some of the hesitance or pushback on this part of the bill by Attorney Sarbeck because we've discussed it previously in other contexts. But essentially, I believe the position is without the ability to speak with unrepresented defendants. They can't go about with their diversion program that they've tried to implement or are working on implementing. I think there's ways of getting around that, including waiting on charging people formally until they've had the opportunity to engage with that program. But I haven't seen the amendment. Happy to look at it and see how it could improve the system as it currently functions. But I can tell you that if people are being forced into pleas or think they're being forced into pleas because they don't understand that they have the right to speak to a defense attorney, that's a problem we should all be concerned about. So for those reasons, Maxwell supports this bill, and I'm happy to answer any questions the committee may have.
Thank you very much. Committee members, are there any questions for Tina Nato? I'm not seeing any. We appreciate you being here today.
Thank you.
And I think that we have heard from everybody who signed up to testify. Well, let me just check again. For those in the attendee space, if you're here to testify in support of 1685, please raise your electronic hand. And I'm not seeing any. Is there anyone here to testify in opposition to 1685? If so, please raise your electronic hand. Not seeing. And finally, if there's anybody who wishes to be heard neither for nor against on LD 1685, please raise your electronic hand. And I see that Jonathan Sarbeck has rejoined us, as has Julia Finn. And so I'm going to bring them both to the panel. And welcome, DA Sarbeck. You can go ahead and proceed with your testimony if you'd like.
Great, thank you. I wasn't sure if it was going to be me or Ms. Finn before because I was being redirected into the room. So thank you very much for hearing from me again. Again, I'm Jonathan Sarbeck. I'm the Cumberland County District Attorney. I appreciate Representative Harnett bringing up the suggested exception that I put in front of him yesterday. He articulated very well on what my thoughts are on that. Just to give the court or give the committee a sort of some information about a diversion program that we've been doing in Cumberland County for about a year, which I checked with Bar Council. It's under our ethical rules. It is allowed. And what we do is pre-arraignment, meaning pre-coming into court for an individual, we reach out to them and to give them an opportunity to participate in a restorative justice program, both a young adult from 18 to 26 and then 26 and older. And during this dialogue, which is done outside of anybody with my office being involved, no prosecutors present, no law enforcement's present, it doesn't cost anything to the defendant. They have a dialogue, and the only information we receive from those from the people who are putting on the dialogue is whether or not that person attended and completed. And if they did, then that case is dismissed if there's been a complaint, or we simply don't go forward with the charges. However, if there was a complete prohibition from contacting this individual, then we would not have that opportunity to do that. I can tell you there is a very large backload in the district attorney's offices throughout the state of Maine. Cumberland County, we're doing okay with the backlog. We have about 40% more active cases than we did this time last year, but there are other parts of the state that are struggling. And speaking to a police chief in York County, about 2 weeks ago, he was telling me that his officers are now summonsing people for a year out at this point because of the restrictions being put on with the availability of the summons dates that are coming in. So if you had a situation like that where you had somebody who was summoned and their return to court date isn't for a year, and that person is saying, well, I'm having this hang over my head, I want to contact the DA's office to try to take care of this, to take responsibility, to be accountable for what I did, they would call, and the district attorney's office would not be able to speak to them if this was in this manner. So I think there is some things that we should probably work around. I understand the concept of it. I applaud the Sixth Amendment report. Being somebody who prosecuted in Massachusetts, which this is the regular business that an individual has to sign a document if they're going to represent themselves, I can see the practicality behind it, and I can definitely understand the constitutional concerns that people have that this isn't happening. So that's why I'm neither for nor against. However, I would just say a blanket prohibition on this might have some unintended consequences for individuals who do want to represent themselves, and for the diversion programs that we put together, not just in Cumberland County, but in other parts of the state. and I'd be happy to answer any questions.
Thank you so much. And I do see we have a committee question. Go ahead, Representative Moriarty. We're not able to hear you.
Thank you, Madam Chair. Mr. Sarbeck, your pre-arraignment restorative justice program sounds excellent, as the goal is to keep people out of the system. If I understood Mr. Dunbar's comments correctly, his concern seemed to be that the conversation between a district attorney and a defendant could digress into other areas, and presumably there could be, in effect, informal discovery between the prosecutor and the defendant. Do you have any controls in place that would prevent that from happening?
We do. We actually put together sort of an agreement, a dialogue agreement that we send out to the individuals, and we urge them to contact a defense attorney so that they can go about this process and understand it a little bit better. But it basically is sort of an off the record information given. So anything that they talk about during this dialogue, which we really don't know about, because like I said, that nobody from the district attorney's office is there. One of the key parts of restorative justice is keeping that third party neutrality. And so we respect those bounds as much as we can. But we do have to be the person who refers the case to them. And I know there's been many defense attorneys who have referred people to our program, including Attorney Nadeau, that have had their clients participate in the program, resulting in a dismissal. Two very key aspects of it, though, that address Mr. Dunbar's very legitimate concerns. One, we want to make sure that these individuals know when they participate that these statements won't be used against them. And then another, and I think this is very important, is that the results of this dialogue do not result in a guilty plea, meaning that we are not requesting that somebody participates in this and then has to give up their right to counsel and plead to a $500 fine. The results of this are a dismissal, no admission. We're not even doing these on deferred dispositions pre-arraignment. That might change if somebody has come into court, been arraigned, gotten the information from the court about their right to counsel. Then we might use our diversion program in a different capacity. But pre-arraignment, without speaking to an attorney, we make it very clear that they're not going to give up their rights. There's not going to be a guilty plea, and that we want to make sure that those conversations are off the record. And we have an agreement that we've sent out, and I've sent it along to many defense attorneys, and I have not heard an objection to it. And like I said, I checked with bar counsel too to make sure that I was being ethical with going along with this road, and they did say it was ethical under our guidelines.
Good. Well, that's a great answer. Thanks very much.
Thank you for the question.
Representative Babbage, go ahead with your question, please.
Thank you, Madam Chair. Thank you, DA Sarbeck again. Just to review and be clear, there is not a guilty plea initially to participate in the diversion program?
Sometimes one of the concerns that was brought up when I met with the committee last session, I think over last summer, I think it was LR 3300. I'm not sure if everyone was here, but one of the concerns that was brought up by then Senator Bellows was these letters that go out from the DA's office saying, here's the offer, it's a guilty plea, this is the fine, or this is whatever the jail time is. And if you don't accept it, then it's off the table when you come in for an arraignment. And that was one of the concerns. So I'm steering very far clear of that, especially when it's pre-arraignment, pre-court, and that person hasn't had the opportunity to go in front of the court and see that video that really explains their rights to them, because I don't want to have anybody I don't want to get a guilty plea or anything along those lines if that person hasn't had their due process rights explained to them.
And so can you explain to me once again the consequences of successful completion of the diversion program versus unsuccessful?
Well, we haven't had any unsuccessful. We've done about 200 and they've all resulted in a dismissal. But basically, if somebody did, let's say they said, I want to participate, and then they never got in touch with the individual who's putting on the diversion program, or the diversion coordinator couldn't get in touch with them, all that happens is that they come to court because they already have a summons date, And so if they don't participate, then they're still under the obligations of the summons that was issued by the law enforcement agency. And then they just come into the court sort of in the normal path.
Thank you. And if I may, Madam Chair, Mr. DA Sarbeck, what is the permanent record after a successful completion?
Well, if we never file a complaint, and that case is either dismissed or we don't go forward on the complaint, they don't have a record. There's no guilty plea. There's nothing. That's not to say that under the CJIS system, once an ATN number, meaning an arrest tracking number, is issued by the police officer or the law enforcement agency, we would still see that might come up on their criminal history. But for all intents and purposes of regarding that I've pled guilty, that doesn't exist because they never came into court.
And lastly, would a written invitation to participate in a diversion program delivered by a court officer that's not part of the prosecutorial team be feasible?
Well, I think under how the statute's written, unless that person actually has heard from the court and signed a waiver, I don't know if it would be. That's a good question. So yeah, I think if it was a third party that did it, but at the same time though, since I'm making the referral, I don't know if I sent it to the judiciary to then send to the defendant, that might actually make the judiciary sort of a state actor in a way. Maybe I'm kind of thinking too much about this, but this is why when I sent the language to Representative Harnett, I specifically put in there that the diversion program would result in, or that would not result in a guilty plea. Just so you didn't have diversion programs said, hey, you participate in this, you'll get a $100 fine after a guilty plea, something along those lines.
Thank you very much, DA Sarbeck, and thank you, Madam Chair.
You're welcome. And don't think there are any other questions for you, DA Sarbeck. Thank you once again for being before the committee today.
Great. Thank you for having me. Have a good afternoon.
You too. And next we'll hear from Julia Finn from the Judicial Branch.
Hello.
Hello, welcome back.
Thank you. I guess it's afternoon now, so I'll say good afternoon. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. I'm Julie Finn and I represent the Judicial Branch. And I would like to express some concerns only about Section 1 of this bill, which moves the financial screeners from MCILS to the Judicial Branch. 13 years ago, in 2008, all functions regarding the assignment of counsel to indigent defendants and parents in child protective cases resided in the Judicial Branch. On the recommendation of the Judicial Branch, a commission was formed to study this system of providing legal services and to examine ways of ensuring quality representation and establishing a sustainable funding mechanism. So a commission was formed to look at that. And I'm gonna paraphrase a little bit to make sure I have enough time. But that commission essentially found that having all of the functions of assignment and the administrative parts of assignment of counsel residing in the Judicial Branch created a pretty serious conflict of interest. And that included the financial screeners at that time. And even though they do not represent the defendants per se, they do question individuals about their income and expenses, and they make a recommendation to the judge. And as has been stated, they also are involved in collecting partial payments from defendants. Then about a decade later, as you know, the Sixth Amendment Center performed another detailed study of this time of MCILS and issued a report a couple of years ago with recommendations. One of those recommendations was to move the financial screeners out of MCILS. The report identified a conflict of interest when they said MCILS cannot assure that MCILS attorneys fight against the imposition of fees related to the cost of defense while simultaneously trying to collect those fees. We do not disagree with this premise, but point out that both MCILS and the Judicial Branch have conflicts of interest vis-a-vis the financial screeners. An analogous conflict of interest for the judicial branch exists because the courts, which are primarily adjudicative organizations, are also closely involved in the collections process. David Carroll, the author of the Sixth Amendment report, acknowledged to this committee earlier in this session that both entities have conflicts, and that the gold standard is for the screening function to take place at a neutral agency that is not involved in the provision of legal services. Ideally, the screening and investigative functions should neither be housed at the judicial branch nor at MCILS. Currently, in Maine courts, there is a two-step process that involves both entities. MCILS screeners gather information and make recommendations, and judicial officers review the recommendation and either approve or deny the request. Because there is not a neutral agency to house financial screening, splitting the process between the judicial branch and MCILS decreases the potential for conflicts. Recognizing that the entire system of providing legal counsel to indigent citizens of Maine is under review, we would urge you to consider where and how to create a fair and effective screening system as part of that larger project. Other recommended reforms still under discussion may well inform a solution to the screener issue. We respectfully suggest that the current placement of the financial screeners, while not ideal, does not have a significant negative impact on the provision of legal services to those who qualify. The proposed change will be somewhat difficult and expensive and comes with no guarantee of improved outcomes. Thank you for your time. I'd be happy to answer any questions if I can.
Thank you so much for your testimony. I see Representative Babbage, did you have a question or is your hand up from a prior? Okay,
Thank you.
Senator Keim, you may proceed with your question.
Thank you. Thank you for being here, Ms. Finn. So I want to ask you about the first part of the bill, but also the second. So to begin with the financial screeners, I understand and do remember that there is a conflict of interest for both the judicial branch and for them being housed at MCILS. But the court already is in the business of collecting fines. So they have a collections process. And help me understand again why I think what you're saying is that it's a greater conflict of interest for the courts than for MCILS.
I'm not sure if we're saying greater. I think we're saying it's at least equal to, and may not be worth what it would take to move them. They were with us, 13 years ago, so they'd be kind of going back and forth. So I wouldn't say necessarily that it's greater, and I'm sorry if I may be not remembering the first part of your question, if you could repeat it.
No, it seems like there's already a collection process there at the courts. So that would, but I mean, you're right, they were there and we moved them out. But I think the cost is the biggest impact of making a separate standalone for the screeners, which is why we were looking for the best alternative that maybe doesn't cost as much. And so I guess I was trying to weigh what you felt was the strongest negative for the courts having the financial screeners.
Well, I do think it's the conflict of interest issue. And you also mentioned the cost, Senator Keim, and last year when this was considered, there was a cost involved. The judicial branch functions, which are included in this bill, expand upon what the screeners are currently doing because it includes screening for civil indigent folks in civil cases, and also for collecting fines and such. So it's an expanded role. It's an addition perhaps of a position or two. I know that you're hearing another bill this morning that adds some staff to the MCILS, and I won't be commenting on that, but there will be a cost also to moving them over. And I don't know if it has to be a standalone agency with respect to another place. It's not my place, and I haven't considered a third alternative, but there may be others. Just pointing that out.
So you just said something that I didn't quite catch. You said something about expanding it to civil.
Yes, because we have a process, it's called an application to proceed in forma pauperis, which is just a Latin term for not having enough money to pay filing fees. And so people do that in civil cases where they don't get assigned counsel, and that is also included in the description of this position in the bill.
So you already have someone doing those positions, and we're saying that they would be combined in this bill?
No one really does the positions. It's a form that's handed to someone. It's a similar analysis in terms of what is your income, what are your expenses. So it makes sense if the positions were to come to the judicial branch for these folks to handle those aspects as well, because it's a very similar function that's now really no one's doing it.
So then if no one's doing it, how is the determination being made?
Well, a clerk hands a form to someone who fills it out, and then ultimately the judge, as with the criminal cases, the judge has to make the decision.
Oh,
sorry if I wasn't clear about that.
Yeah, gotcha. Okay, good. I understand that. And then I have a separate question, as if that's all right, Madam Chair.
Yes, go ahead.
So then, walk me, if this is an appropriate question for you, walk me through the process of a person entering the court, because so now going on to the other section of the bill that prohibits prosecutors from communicating with unrepresented defendants. And so I just need to walk through what this looks like in court now, what this would look like if this change was made, because someone walks in, and I know that the idea of offering, meeting with the defendant ahead of time is a way of streamlining court process and helping people kind of move out of there as fast as possible, which I can imagine is uppermost in their mind. But who meets with them, and just walk me through what happens when a person goes into court and what it would look like in both ways, if you can.
Yeah, I'm sorry, Senator Kime, after that long, very well-phrased question, I really don't think I'm probably the best person to answer that. Perhaps DA Sarbeck is still listening. I think that might be more his bailiwick. Sorry about that.
No worries.
Thank you both. Any other questions for Julia Finn, committee members? Go ahead, Representative Babbage.
Thank you, Madam Chair. Just a quick one. Ms. Finn, could you restate for us the destination of fines collected by the judiciary?
That would be the general fund.
It would be. It is not kept by the judicial branch.
It is not.
Thank you very much.
Any other questions, committee members? I'm not seeing any. Thank you very much, Julie Finn, for being before the committee today.
Thank you.
And next we will hear from Josh Tardy. Go ahead and you can proceed with your testimony.
Okay, thank you. Good afternoon, Senator Carney, Representative Harnett, and distinguished committee members. I'm Joshua Tardy. I'm a resident of Newport, and I'm the chair of the Maine Commission on Indigent Legal Services. I'm here in the neither for nor against, but to be clear, myself and the commission is very appreciative of the work that the Judiciary Committee has done, your support for the mission of the delivery of indigent legal services. And with respect to this particular bill, although we are neither for nor against on where financial screeners are ultimately placed, I tend to agree with the sentiments of Ms. Neto's testimony, and certainly can see the benefits of these screeners going back to the judicial system, and also seeing if they have a role in screening the applications to proceed in forma pauperis on the civil side of things. I think that there may be a way to avoid redundant tasks, and I think that could create an efficiency. I certainly recognize the judicial branch's concern about money following this assignment of roles, but we are, as a commission, willing to take it or leave it as far as the financial screening process. As far as the other component, we are very much supportive of the the statutory prohibition on prosecutor contact. But I do think that I'm encouraged by Ms. Neto and her suggestion that there is a way to accommodate the need and sort of what the legislator said about moving towards pretrial diversion programs. And certainly we're supportive of the concept and would be willing to be a resource as this committee goes and works at. And if I may, Madam Chair, in the event that I am not around for the next two, to be clear, the commission supports both of those bills. As you are well aware, the hard work that's been done on the budget by your committee and commission and our staff will continue to be a resource to you and your committee members and the legislature on whole as you work this bill and you go through a very difficult supplemental budget. So I'm happy to answer any questions, Madam Chair.
Thank you so much. Committee members, are there questions for Josh Tardy? Representative Babbage, is your hand up anew? No. Okay. Representative Evangelos, go ahead with your question.
Thank you, Madam Chair. Quick question, Mr. Tardy. I usually call you Josh, but you know how it goes. That'd be formal.
Nice to see you.
Nice to see you too. Josh, the three bills we're hearing today, were they drafted basically by the commission or by the executive director?
I believe the executive director had input, and I'll really defer to the bill sponsor on who he attributes the bulk of the draftsmanship to.
Okay, because these are bills reported out, but not sponsored by, sort of. But
sure.
Okay, but more or less they came from your agency.
Yeah, I think it's a product that we certainly, as far as the budget process, and we've worked with your committee on initiatives and recommendations to the appropriations committee and the chief executive. And so the body of work in which we ultimately have recommended the implementation of a geographically limited public defender office and an appellate office. These are our ideas. Who actually generated the actual the typewritten statutory language? I'm not sure right now.
So I'll check with Representative Harnett. So the ideas.
Representative Evangelos,
this is important. Let me finish. So the ideas would have been submitted to the reviser's office. Then.
Again, I think Representative Harnett can answer that question if you'd like.
And I believe that these bills, yes, they came from the reviser's office. They reflect the votes taken by the committee that we presented to the Appropriations and Financial Affairs Committee earlier this year. So they reflect those initiatives that were supported by the committee, sometimes unanimously, sometimes on split vote.
Yeah, I understand that on the financial side, but some of the policy pieces that are coming up later, and I won't belabor it until we get there, but they weren't discussed with the Appropriations Committee, so they were recommendations that came out of the commission itself and then kind of got sent over to us.
I think they were recommendations that came out of the commission that they presented to us and also came out of the Sixth Amendment Center report.
Okay, that's what I wanted. Thank you.
Yeah, and I think that we did see some of them in conjunction with the budget initiatives that we voted on. And I think we had a discussion about whether we were going to try to attach them to the initiatives or not, and then decided to treat them separately. I think that's kind of where they came from, Representative.
Well, I'll have some questions later on the last of the three bills because some of the language in there didn't have anything to do with the initiatives we discussed previously.
It includes the language.
Okay.
I'll take it up on that bill, okay?
Perfect, thank you. Senator Keim, go ahead.
Thank you. Nice to see you, Mr. Tardy. I was wondering if you could answer the question that I was asking Ms. Finn. I wanted to kind of get more of a handle on the practical side of when a person walks into the courtroom, who is talking to them. And, you know, if we say that a prosecutor cannot, how are we allowing them to hear their options? Would you be a good person to discuss this with me, or should I be asking someone else?
Well, I can certainly attempt, and I can answer based on my own personal experiences in the courtrooms that have been in. If defendants are summoned to court or in court for their first appearance, we call it sometimes arraignment day or first appearance day. There is right now the practice is some DAs and assistant DAs will say, is there anybody here that would like to speak to a member of the district attorney's office? And that's the sometimes problematic communications that can occur. So let's say there's hypothetically a 9 o'clock, a 9 o'clock call of the docket with 25 or 30 cases that might be called. You have this population of defendants that are in there. Way I would envision it is the prosecutors would not have any conversations with defendants until they are advised of their rights by the court, and there's a colloquy with the presiding judge or justice in which a defendant knowingly waives the right or acknowledges that they have a right to court-appointed counsel, a right to be represented by an attorney, and ultimately they would waive that right in some form, whether it's in writing or in open court, and then the prosecutor would then have leave to have those communications. And so it would make for a little bit more work at the beginning of a court process, but it's absolutely worth the social cost.
So then with the amendment that DA Sarbat put forward, and I don't have that in writing. I don't know, Representative Harnett, if you passed that out, but I didn't see it. How does that change this process? And do you think that it's helpful?
I'd have to look at the language. I'm also would be interested in Ms. Neto's comments in her testimony about the DA making a decision to delay a charging decision, and whether, what impact that would have on a statutory prohibition of DA communication.
So you're saying we should think further about what it looks like for the DA to look to make the decision to delay a charge?
Well, I mean, I don't want to speak for the people that were offering some type of solution, but I think, for work session, Senator, certainly I could touch base with the parties that have spoken about some accommodation, DA Sarbuck and Ms. Neto.
Okay. I will say honestly that I don't think I really understand the problem here, but I do understand that I need to look further into this. So I thank you for that.
Sorry, I couldn't be more help.
Representative Harnett, go ahead, please.
Thank you. I just wanted to respond to Senator Kimes' question about the amendment. There is no amendment at this point. Late yesterday afternoon, I received an email from District Attorney Sarbeck expressing his concern that this might derail his diversion program, and would I be open to considering some way to retain this important program. And I told him that I would be willing to work with him and other stakeholders. I don't want to do anything that interferes with the constitutional right to have an attorney present with discussions with the district attorney. But I also didn't want to lose a program that has successfully resulted in 200 cases being dismissed. So I was trying to figure out a way if we could strike some balance.
Okay, thank you.
Thank you both. Committee members, are there any additional questions? Oh, Mr. Tardy, did you wish to speak to that?
No, okay. No, I thought you were saying goodbye. I'm just saying thank you for the time.
I think we are. Hang on one moment. Any other questions for Josh Tardy? And I am not seeing any. Thank you for being here today.
Thank you.
I am so sorry for the interruption. And so with that, I believe we have heard from everybody who wished to speak on 1685. We just check the attendees. If there's anybody in the attendee space who has not spoken on 1685 who wishes to be heard, could you please raise your electronic hand? And I am not seeing any, so we'll close the work session on 1685 and open the work session on 1686 and welcome back our chair, Tom Harnett, to present that legislation.
Thank you, Madam Co-Chair, Senator Carney, colleagues on the Judiciary Committee. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside. I am here today to introduce LD 1686, an act to implement a geographically limited public defender office. This proposal creates a public defender office in Kennebec County. The concept here is to establish an office to provide indigent legal services through a public defender office in a single county to study and determine whether such a system is feasible in other areas of Maine. This bill provides funding to the Maine Commission on Indigent Legal Services to establish and fill positions of that office. The bill spells out what positions would be created and filled, including public service manager positions, public service coordinator positions, clinical positions, clinical social worker positions, paralegal positions, and an office specialist provision. This proposal would create a total of 17 positions. This public defender office would have the ability to employ attorneys, to use appointed private attorneys, and to contract with individual attorneys or groups of attorneys. The genesis of this proposal is a study that was conducted by the Sixth Amendment Center at the request of the state of Maine, and that report may be accessed online. In my testimony, which has not yet been formally submitted through the portal, there will be citations and links to both of those, to both the Sixth Amendment Center and to the report. I do want to make a comment, and this is not in my testimony, but I am concerned to make it clear that this bill is not making a statement about the good private attorneys who have been doing indigent legal services. It is not meant to be critical of the service that they provide to the state of Maine and that many provide at a very high level to indigent legal defendants. The bill and the subsequent bill that we will hear are both designed to deal with flaws, system-wide flaws that were identified by and explained to us by Mr. Carroll of the Sixth Amendment Center and detailed in his report. Concerns about whether or not Maine is meeting its constitutional obligations when it comes to providing defense to indigent criminal defendants and those in matters where they could lose the right to their children. So it's not a criticism of the attorneys, it's dealing with flaws that were identified in the system in a report that this committee requested before I was even on the committee. So again, I thank you for your time. Happy to answer any questions, but you will be hearing again from others that have more familiarity with the commission than I do. So thank you.
Thank you very much, Chair Harnett. Committee members, are there any questions for our colleague? And not seeing any. I actually, I have one, and it's more of a clarifying question for the public. This legislative measure relates to the portion of our budget initiative that passed with a three-way divided report. Is that correct?
That is correct, Madam Chair.
Thank you. And so not seeing any additional questions, I am going to turn to the attendees and everyone who wishes to speak in favor of 1685, please raise your electronic hands. So I'm seeing Doug Dunbar and Robert Ruffner. I will bring over all those who have raised their hands to save time. And Doug Dunbar, you can go ahead and begin your testimony, and welcome back.
Thank you, Senator Carney and Representative Harnett and everyone. Way too much Doug Dunbar today. But I've waited for this day for 3.5 years since I went to jail. When I was in jail, several things occurred to me. One, bail is punishing the poor, and bail was never meant for that purpose. Number two, our indigent legal services system is deeply, deeply flawed. When I worked in the legislature in the governor's office, when I presented to committees with a fancy title at the Department of Professional and Financial Regulation, when I worked in Congress, folks like you heard from lots of experts and so-called experts. But you don't hear from the poor. You don't hear from the ill. You don't hear from the people who languish in those jail cells. When they get out, they try to keep their lives together. They try to move on. They want to forget what happened to them. They don't know, so many of them, the work that you do. But I do. And so I'm determined to do everything I can to help people like you realize we are not hearing the voices of the victims of crime, but we're also not hearing the voices of the victims who end up in jail and languish and stay there, and they can't get out because they're poor and ill. Now, in terms of the indigent legal services system, it's desperately, desperately broken. There are many good attorneys, many good attorneys. I had one. But there are so many attorneys in the system that don't pay adequate attention to their clients, and that harms them. Again, bail and the indigent legal service system are the great 1-2 punch to the poor and the ill. And that's who you find in our jails. Please, please go visit jails. Talk with people. I recommend that my friends who are judges, my friends who are district attorneys, my friends who are defense attorneys, go to jail for 2 weeks. It'll change your life. It'll completely change your perspective. And so I won't go on. You get where I'm coming from, but the indigent legal service system must change. We need something. And by the way, if you'll indulge me, going back to the last point, we need diversion programs. We need many more people in them. We need them everywhere in Maine. But we need a firewall between district attorney's offices and those people. Lastly, go to court. Spend a lot of time in court. What you've got there, you've got district attorney's offices, 10 seconds to go, 10 seconds, 9, 8, 7, 6. You've got district attorney office staff who want those cases resolved. And you've got poor and ill people who want to get on with their life. Without a firewall, it'll be a problem.
Thank you so much, Mr. Dunbar, and thank you for hitting the timing just perfectly. Committee members, any questions for Doug Dunbar? Not seeing any. We appreciate your testimony today. And next we'll hear from Robert Ruffner.
Hello again. Can you hear me?
Hello again. Yes,
my name is Robert Ruffner, still from Yarmouth, in a different location in Utah. I'm here to testify in favor of the LD 1686. And what Maine has is many, many great attorneys who work very hard to represent individuals who cannot afford their own attorneys in Maine courts where they have the constitutional or statutory right to counsel. What Maine doesn't have is a great way to support those attorneys. The hourly rate does not allow an attorney barely to even have an office, let alone any support staff. Also, we don't have the ability to work with a large entity such as a public defender's office, either as an employee or as outside counsel representing our own clients, but in concert with the overall efforts made by the public defender's office. The ABA, when it talks about systems for a good indigent defense system, talks about both, and how a healthy system has both a mix of the private bar through assigned counsel, as well as a brick and mortar full-time employee public defender's office. They are both necessary for a robust and healthy indigent defense system. This bill will start a small step down that process through a single public defender's office that will help enhance the level of representation, not just by the attorneys that work there, but also the attorneys that work in that county. These attorneys can do great work and do great work. However, they can do even better work. Just no one criticized doctors who were providing good work for years and years when they suddenly started also working in hospitals. No one said, oh, that was a criticism of the doctors and that's why we need hospitals. The hospitals provided efficiency, nurses, orderlies, all sorts of things that enhance the ability for doctors to do their work. A public defender's office can do the same thing. I hope that you will support this bill and vote on to pass in your work session. Thank you very much.
Thank you very much. Committee members, are there any questions for Robert Ruffner? Not seeing any. Appreciate you providing testimony today.
Thank you.
Next, we'll hear from Megan Sway.
Good afternoon, Senator Carney, Representative Harnett, distinguished members of the committee. My name is Megan Sway, and I'm Public Policy Director at the ACLU of Maine. On behalf of our members, I'm here to support LD 1686, even though it does not go far enough. Maine is not living up to its constitutional obligations to guarantee the assistance of counsel to people who have been accused of crimes but who cannot afford an attorney. While there is much room for respectful disagreement among people of goodwill on a wide range of public policy questions, there is no room for disagreement about the state's obligation to follow the Constitution. The Sixth Amendment Center, a national organization with expertise on the right to counsel, was hired by the legislature to do an investigation. It issued its findings and recommendations more than 2 years ago. These findings made it clear that Maine is not meeting its constitutional obligation to guarantee the assistance of counsel to people who are accused of crimes and who cannot afford an attorney. The Sixth Amendment Center found that the attorney qualification standards are too lenient, that training is inadequate, and that oversight is practically non-existent. And the Sixth Amendment Center provided a list of recommendations for the state to pursue to come into compliance with the law and the Constitution. After more than 2 years, none of the most important recommendations have been adopted. None. In United States versus Chronic, the Supreme Court held that the right to assistance of counsel means the right to an effective assistance of counsel. Fundamentally, that means ensuring that only qualified attorneys are permitted to represent defendants, that those attorneys are well trained, that they are appropriately compensated, and that they are supervised. No other state in the country relies solely on private attorneys to fulfill this important public role, and for good reason. It is much more challenging to supervise private attorneys scattered throughout the state as compared to a public defenders housed in a few well-resourced offices. Many lawyers in Maine who serve as appointed counsel do in fact provide excellent assistance despite the absence of support, adequate compensation, oversight, and training from the state. But too many lawyers are unable to overcome these system-wide challenges. And Maine is experiencing a severe criminal defense attorney shortage in rural parts of the state because pay is so low and because Maine does not contribute to overhead expenses for defense attorneys as it does for prosecutors. Last year, MCILS requested money in the biennial budget to establish the state's first trial-level public defender office right down the street from the State House in Kennebec County. We supported that proposal, and we support this bill as yet another attempt to provide funding for that proposal. But we should not pretend that this is sufficient to bring the state into compliance with the Constitution. Only establishing one public defender office over the course of the biennium is not enough, especially when there's a chronic lawyer shortage in some of our rural counties, which could be mitigated by the establishment of appropriately funded public defender offices with respectable salaries, benefits, and support staff. We understand the need to start slow, but the budget process requires the MCILS and the legislature have a clear vision about what steps will follow this first one. Public defenders' offices in larger cities, in rural counties, a combination of the two. Maine should have as its goal the establishment of at least 6 public defender offices across the state within the next 2 years, not just one. We support this bill because it is such an important, long overdue step and urge you to do more. Thank you.
Thank you very much for your testimony. Committee members, are there any questions for Megan Sway? Go ahead, Senator Kime.
Thank you for being here, Ms. Sway. I was wondering, the ACLU, obviously nationwide, deals with these types of issues, and your testimony today leads me to believe that you're suggesting that the only way we can fulfill our constitutional obligation is to have a statewide office. Is that am I understanding that correctly? That ACLU's position is that we'd have to have a statewide public defender office in order to meet our constitutional obligation?
I don't believe that that is our position, but I do believe that more than one public defender pilot program would be necessary to remedy. I think the issues that are at stake about the training, the supervision, and all of that, I don't believe the Constitution requires a public defender's office for those to be fulfilled, but it may be that a public defender's office is the most convenient and cost-effective way to do that. I think our point is more that just one office and not dealing with the other overarching issues is not enough to address everyone in the state's constitutional rights, as opposed to just people in Kennebec County.
Mm-hmm. Okay, because I think, does ACLU also have lawsuits against, in other states where there are public defenders offices and they're not fulfilling their constitutional obligation?
I have to check if we have any current ones, but we have in the past had others, but I don't know off the top of my head if they're currently ongoing.
Right. Okay, thank you.
Thank you. I will get that for you, though.
Committee members, are there any other questions for Megan Sway? I am not seeing any. Thank you for presenting testimony.
Thank you so much.
And next we'll turn to Robert Cummins. Please proceed.
Thanks, everybody, and esteemed colleagues. You've heard me make my pitch before, and I'll try not to proselytize too much. I want to commend Tom Hartnett for his willingness to jump into this abyss of underfunding with these proposals, each of which 1685, 1686, and 1687, I fully support for all kinds of reasons that have been articulated in the past in connection with other hearings in support of the MCILS initiatives. I don't speak in my capacity as a member of the Maine Commission. I speak personally and as a somewhat tenured trial lawyer. As many of you may know, on May 18th, our president articulated a call for expanded resources to provide justice to the poor. And in that presentation, here's what President Biden said. Timely and affordable access to the legal system can make the difference in a person's life. I know that Representative Evangelos has articulated this in a number of forums and in many ways. I'm disappointed as a lawyer who believes in his oath to the profession and to the courts, and indeed my oath as a commissioner, not to be seeing real progress in this manifest need to comply with the Sixth Amendment. I know I've made some in authority not so happy with my views that Maine is deficient. But when I was mentored by John Paul Stevens, he taught me one thing, And that is when in doubt, do right. It'll gratify some and astonish the rest. If we don't respond, even in the piecemeal fashion that Representative Harnett has suggested, if we do not come to grips with the need for additional competent, well-trained legal services for the poor, particularly in the criminal context, each and every one of us as citizens of Maine should be ashamed. These pieces of legislation are critical, at least as a beginning step. I just hope they're not running into a dead end that could easily be predicted at this point based upon what I understand from the powers that be. That's it. God bless. I hope we get something started on this important subject.
Thank you very much. Committee members, are there any questions for Robert Cummins? I am not seeing any. We appreciate you providing testimony today. And with that, I think that's everyone who wished to speak in support of 1686. So I'll turn to the attendee space and ask those who wish to speak in opposition to 1686 to please raise your electronic hand and keep it raised. And I will bring over Tina Netto. I think that's it for folks who wanted to speak in opposition. And so if you're here to speak neither for nor against, please raise your electronic hand and I'll bring you over to the panel in a moment. And Tina Netto, you may proceed.
Good afternoon, and thank you, Senator Carney. I am here on behalf of the Maine Association of Criminal Defense Lawyers to speak in opposition to LD 1686. There may be some in this room or some listening in who say, well, of course, MACDL opposes this legislation. Defense attorneys cannot be trusted to support change in this system. I believe one of the commissioners earlier this year actually said as much to the Judiciary Committee. Nothing could be further from the truth. We support a system to provide indigent defense that is well-funded, well-structured, and thoughtfully put together. The proposal before you is unfortunately none of these things. As one of my colleagues recently wrote to me about this issue, we need a system designed to develop better lawyers. We need training, we need mentors, and we need a system that supports those lawyers who are willing and able to carry out the job as negotiators and trial lawyers. Until this becomes the system's goal, whatever system they choose is going to be inadequate. Creating an office staffed by state employees we're going to call public defenders instead of appointed counsel does not align with the variety of recommendations made by the Sixth Amendment Center. It does not ensure better quality representation. It does ensure some level of financial stability, but at what cost? We feel this is underfunded. The proponents of this project, to my knowledge, have made no effort to explain or defend the budget as proposed or explain how this office would function in a way to embody the needed changes that have been identified by the Sixth Amendment Center report and this own committee, which we feel is wholly inadequate. The Sixth Amendment Center and David Carroll has told this committee over and over again, it is not the model that matters, whether it's public defender, appointed counsel, contract counsel, et cetera. It is standards, oversight, funding, and implementation that make the difference. The proposal in this bill is insufficient to ensure quality, both in that office and more broadly for Maine's indigent defense system at large. The Sixth Amendment Center actually recommended Cumberland County. Where did Kennebec County come from? Well, they have state offices, so I guess we save some money there, but nowhere else in the state. And the chief prosecutor and one of the judges seem to be in favor of it being in Kennebec County. Pardon me if I'm not overwhelmed by that as a reason to place this proposal in Kennebec County. It's not appropriate. We don't believe the fiscal note that's been attached actually reflects the true cost of what indigent defense will cost in Kennebec County. Aside from the public defender system, there's also the issue of conflict counsel and perhaps juvenile defense. And I will say that no one in this state cares more about the constitutional right to counsel than our members. We have devoted our practices and our lives to ensuring that our clients receive high quality representation. We need systemic support and funding to do right by our clients. And this bill does not get us there. Thank you very much.
Thank you. Committee members, are there any questions for Tina Nato? Go ahead, Representative Babbage.
Thank you, Madam Chair. Just a quick one. Ms. Neto, can you please help me to understand whether or not the availability of and efficiency of indigent legal services it varies significantly between urban and rural counties? We did hear about Cumberland and York being a potential site for public defender's office. Kennebec has been chosen, but we also heard testimony today about the unavailability of lawyers in rural areas. And I wondered if you could comment on the effectiveness of indigent defense and the availability of indigent defense in small communities in Maine versus large.
Sure. I think that's definitely an issue that the commission is going to have to address head on. The bar is extremely, compared to other states, old. So more people are going to be retiring. So the crisis in our rural areas for access to counsel in criminal defense and otherwise is going to become more marked. This bill does not address that issue and will not affect that issue, unfortunately. I think there is definitely movement towards a larger discussion to funnel people into the rural areas to practice, to support them getting there through apprenticeships, mentorships, internships, all the ships. So hopefully, we do get people who are committed to rural practice, who are well-trained and supported to be there. Because if we're just letting law graduates go out in a field and open your practice, like that's not ensuring quality representation. We need to do better. And I know the commission is dedicated to making that better for
okay, that's the beginning. Thank you.
practitioners.
Appreciate that. Right. Thank you.
Thank you. Committee members, any other questions? Not seeing any. Again, Tina Nato, thank you so much for being here this afternoon.
Thank you.
And with that, we have our last person speaking on 1686, Jan Collins, who is neither for nor against, and you can go ahead with your testimony, please.
Greetings, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Jan Collins. I'm Assistant Director of the Maine Prisoner Advocacy Coalition, and I'm neither for nor against LD 1686, an act to implement a geographically limited public defender office. LD 1686 would address two of the findings of the 2019 report by the Sixth Amendment Center evaluating the Maine Commission on Indigent Legal Services. One of those findings was that MCILS attorney qualification standards are too lenient, and there are no attorney recertification requirements. MCILS has only limited new attorney training and lacks requirements that ongoing attorney training relate to defense-specific subject areas. MCILS lacks appropriate supervision of attorneys. Finding 4 said that MCILS lawyer of the day system primarily serves the need to move court dockets, while resulting in a lack of continuous representation to the detriment of defendants. There's often a critical gap in representation while a substantive lawyer is identified and appointed. Additionally, the lawyer of the day practices under the Somerset contract in particular result in a direct conflict of interest. This bill creates a Kennebec County Public Defender Office beginning in January as a first step in providing indigent legal services through an Office of a Public Defender. The bill provides funding to the Maine Commission on Indigent Legal Services for positions to establish the office, and it authorizes the Commission's system for providing indigent legal services to employ attorneys. Although this pilot project would address 2 of the flaws in the current system, it would not address the greatest barrier to adequate defense for the indigent: sufficient funding. Neither this pilot project nor the current system of indigent defense are funded at a level that would meet the demands of a robust defense. We need well-trained, committed attorneys, enough to adequately cover caseload, and we need attorney pay comparable with the remuneration found in private practice. Thank you for your consideration, and I'm willing to answer any questions I can.
Thank you very much. Committee members, are there any questions for Jan Collins? Not seeing any. We thank you very much for your testimony today.
Thank you.
And with that, I'm turning to the attendee space. I believe that we have heard from everyone who wished to speak on 1686. If you are here to speak on 1686 and you have not spoken, please raise your electronic hand. I'm not seeing any raised hands, so we'll close the public hearing on 1686. Committee members, we have one more in this series of bills to go. That's 1687. There are 6 people signed up to testify in support of it and no opponents. Is the committee okay going forward and completing that before we take a little break? Everybody okay? I'm seeing nodding heads. Thank you very much. Appreciate you hanging in there with us. And with that, we'll open the public hearing on 1687 and welcome our colleague, Chair Harnett.
Thank you, Madam Chair. Senator Carney and esteemed colleagues of the Judiciary Committee, my name is still Tom Harnett, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside. I'm here today to introduce the third committee bill, to introduce LD 1687, an act to improve the provision of indigent legal services. I will briefly cover the proposed changes to the Commission on Indigent Legal Services that this bill puts forth. As with the prior bills I've introduced this morning, the genesis of this proposal is the study that's been referred to that was conducted by the Sixth Amendment Center at the request of the state of Maine. And that study can be found online, and in my testimony, there are links to the testimony as well as citations. The bill makes the following changes to the provisions governing the Maine Commission on Indigent Legal Services. First, it changes the salary range of the executive director of the commission from 52 to 37, resulting in a higher top salary to make it more appropriate given the responsibilities of and skills needed for the position. Second, it authorizes the commission to directly employ attorneys to provide legal services to indigent clients. It also requires the commission to establish an audit system and allows for the recoupment of payments when necessary and appropriate. The commission is given subpoena power enforceable by the Superior Court to conduct the audits. It directs the executive director to carry out the audits and seek recoupment again when it is necessary and appropriate. It also authorizes the executive director to exercise the subpoena power on behalf of the commission. Third, the current law provides that rules governing standards and training for attorneys are major substantive rules. This bill changes those rules to be routine technical and also corrects the cross-reference to the commission's rulemaking authority. Fourth, it provides that any remaining balance in the Maine Commission on Indigent Legal Services Program General Fund in fiscal year 2020-2021 be carried into 2021-22, and any remaining balance for fiscal year 2021-22 be carried into 2022-23. Fifth, it provides funding to the commission to fully staff the commission, including the aforementioned salary of the executive director. It also increases the hourly rate for contract attorneys from $60 per hour to $80 per hour for those attorneys providing legal services. It also establishes an appellate public defender office, which includes 1 attorney and 1 paralegal in fiscal year 2021-2022, and 2 additional attorneys in fiscal year 2022 and 23. And it provides further funding. Finally, this bill allows for the commission to directly employ attorneys to provide legal services and it provides funding to the commission so that it can be fully staffed and finally better able to carry out its constitutionally required functions to protect the constitutional rights of indigent defendants. Understanding that concerns discussed earlier regarding attorneys possibly misusing the reimbursement process for services, the bill requires the commission to establish an audit system and allows for that recruitment again when necessary. And I fear I was a bit redundant there. I thank you for your time. And again, while I'm happy to answer questions, there are others testifying with more direct knowledge than I have. But my primary point here, excuse me, is I know there are some people that will feel that these bills do not go far enough. I'm one of those people. But it is an opportunity for the state to make significant progress in trying to meet our constitutional obligations. And I would ask for this committee's support. Thank you for your time and attention. And I'm sorry that my voice is no longer working.
Thank you so much, Representative Harnett. And committee members, I'm going to open up the floor to questions, and we'll start with you, Representative Evangelos.
Thank you, Madam Chair, and Representative Harnett. This is a great, good faith effort to get a really good start on all three of these things. And I won't elaborate on the struggles we've had, but this is the moment. We've got the legislation in front of us to make it happen, and it's been a long time coming. So I do have a bunch of questions on 1687. I noticed that this particular bill has an emergency clause. Is that because of we need the money to get going?
Yes, that is correct. We consider this to be an emergency situation.
Okay, so I guess I want to know, would it be possible for section 3 through section 9A come forward to us in a separate bill then? I don't see that as an emergency.
Can I just ask what your thought process is behind that, Representative Evangelos? I want to know what your goals are so that we can see what the best way is to try to achieve them.
Well, it'll come out in my questioning where I'm heading, but I wanted to know, we have a financial emergency, which is well recognized, and we're supporting 10.5 million and 10.7 million, but this additional non-emergency language has been shoehorned into this bill. So I want to know if it's possible if we could separate the two so that we could bring a bill forward that includes section 3 through section 9A in a non-emergency bill. Because I don't think that language constitutes an emergency, but I do think the rest of the language does.
That is not something that I have considered until you have raised the point. It's something we can think about at a work session. You know, the bill I presented is the committee bill that I thought most appropriate, but I recognize I take your question seriously and your observation seriously.
So I want to elaborate on.
I'm sorry.
Go ahead, sir.
You know, as you have stated many times and as others have stated, I think that we are dealing with an emergency situation, and this is our effort to try to correct that. But I take those concerns seriously, Representative.
So I have some questions that I wanted to elaborate on that would make it clear why I'm concerned about this piece of it.
Okay. Well, the chair would.
Go ahead with your questions, Representative. Thank you.
So it appears that sections 3 through sections 9A are empowering powers of the executive director. In conjunction with the issuance of a subpoena, which paragraph 9A says the executive director may exercise a subpoena power. Do you know if the commission would have conducted a vote? Because I know, like, for instance, in OPEGA, the commission, OPEGA people vote, the members of the legislature serve on the committee, they vote, and then the executive director
issues the subpoena, because I know that for a fact, because I was involved in filing a complaint there under the previous administration, and they had to subpoena 2 of the officials in the Page administration because they refused to appear. But they had to vote. Do you know if the Indigent Legal Commission would vote on this, or whether this language would empower the executive director to issue subpoenas without a vote of the full commission?
I do not know the answer to that. Reading this language, I do not see a requirement that the commission vote, but I've not analyzed it to that extent, Representative.
Because that's a very, very important piece of my concerns about this piece of the bill. As you know, I had a previous bill which didn't make it, but I was concerned about allowing the commission to have proper oversight over the executive director. And now a bill comes forward greatly expanding the executive director's powers. You know, when they're discussing whether they're going to issue a subpoena, if the commission is involved in it, if there's a due process allowed for the attorney they're targeting, so that they get a fair hearing before the issue of a subpoena gets that far.
Representative Harnett, I'm just going to interject here. I sense that you have a significant number of questions, Representative Evangelos, and I'm just going to suggest that because we can all speak with each other and answer these questions in the context of next week's work session. We do have 6 members of the public who are here to present public testimony. Would you be comfortable perhaps even outlining the questions so that either the chairs can or our analysts can get those answers for you for the work session? Would that be the way to go forward?
I mean, I don't want to get into this with you again today, Madam Chair, but I have a right to ask questions on a bill. I'm asking specific questions about language that's in the bill. And I don't understand why you're trying to impose standards on me when you don't impose them on other members of the committee. I'm not out on left field in these questions. I'm specifically asking regarding paragraph 9A and the other empowering language that's in this bill, which is clearly not an emergency. My concerns around it are questions that are outlined in the bill, and I want them on the record, and I'm going to pursue it. And
I have no objection to your questions. I was just thinking if we could ask them in a context where we could answer them rather than in this setting, we won't have the answers. But why don't you go ahead and ask them, and then I'll go back and watch the video. And so go ahead.
Well, that's why when a bill's brought forward in this method, Representative Harnett, as our chair, is presenting the bill for the committee, but he's not like sponsoring some of this language. This language came from a different source, and he's bringing it forward under a process that we use in the legislature. That's why I was trying to get at my earlier question with Mr. Tardy was, I have a grave concern that if the executive director of Indigent Legal participated in the drafting of this portion of the bill, vastly empowering his powers, I have grave concerns about that process, and that's why I'm raising it. That's a grave conflict of interest to allow the executive director to draft language that greatly expands his powers, including possibly subpoenaing an attorney without the consent of the commission. And so that's a serious question. And I'm not putting it on to Representative Harnett because he didn't draft the bill. He doesn't know, and I accept that. But he also said he knows my concerns are legitimate. So if there's somebody on the commission that would rather answer it, that's fine. I have several other questions. I'll come back to them with Representative Harnett if somebody on the commission is here today that can address them. But I want to reserve my right to continue my questions with the person who brought the bill forward, because I recognize the emergency on every single financial piece. I've been harping on it for 3 years, but I do not recognize the emergency of this language that's been shoehorned into this bill. And I would like it removed and another bill brought forward. The money is the emergency. That's been conceded. And this language isn't. And I'm particularly concerned, and I'm going to go on the record with this, that there is a case right now going on between the commission and a specific lawyer. And it's a very a very serious high-level case with a presumption of innocence. And I'm very concerned that this empowering language was entered in here for the advantage of the executive director over this attorney. That's inappropriate. And I want to have this language struck during the work session so we can pursue a second bill. Let's get the emergency through on the money. So that's a grave concern. I can elaborate in the work session, but there is a situation going on, and I'd be willing to tell you more off mic. But it's highly serious, and I'm highly concerned about the shoehorning of this language into a financial order. And I'll elaborate later on the work session. And if somebody is here today that can further answer the questions, I'm not sandbagging you, Representative Harnett. You brought the bill forward. I had to ask somebody the questions, and I didn't know if you knew. And your answer is you don't know because you didn't. It's not technically your bill, it's the commission's bill. Is that correct?
It's a committee bill reported out, but I do not have the answer to your question. That is correct.
Because the language came more or less from the commission, right?
I do not have the answer to that question. I'm sorry.
Okay.
I can try to track that down as well.
I will get you the answer.
I just can't do it now.
That question.
So to end this in work session, my concern is page 1, section 3 through page 2, section 9A is not an emergency and should not.
Do you mean through section 7, Representative Evangelist?
Section 7, 9A, right. Section 7, 9A.
Okay.
Correct.
Okay.
Are we on? You with me on that?
Yes, I am. I mean, because there's a section 9. I'm just
section 7, 9A. Yeah.
Okay.
So that's, my contention is, my questions were around. I don't want to risk the emergency status of getting this money through clouded by language that doesn't belong in this bill. So, and we can pursue the rest with another witness or in the work session. Thank you.
Noted.
Representative Evangelist, did you have additional questions?
My hand's going down.
Okay, I thought that you had questions beyond section 7, but
Nope.
I'm understanding now where you're going.
The bill, other than that, does everything we've been fighting for. But this other piece came out of left field on me, and I'm not supportive of it. And there may be another witness that can help. If not, we'll have to fresh it out in the work session. Thank you.
Thank you very much. Committee members, any other questions for our colleague, Representative Harnett? I am not seeing any. And now I'm turning to those who are in the attendee portion of the meeting. And could everybody who wishes to speak in support of LD 1687, please raise your hand, and I will bring you over to the panel. Welcome back. Tina Netto, you can go ahead and start your testimony.
Thank you very much. Good afternoon again. My name is Tina Netto, and I am the Executive Director of MACDL. And we are here today to testify largely in support of the bill before you. We support the change in salary range. This is an important job. We should pay the people well who step up to do it. We also, support the routine technical and to major substantive. A lot of this you all have talked about at length throughout the budget process. So I don't want to belabor that. We feel the 2 points of contention, I think, are in the funding section 10. We, of course, appreciate the proposed raise from $60 an hour to $80 an hour for the attorney rate. The original proposal is 100. We still feel that's the appropriate level, but we look forward to speaking further as we move on about different ways to structure any fee increase to reflect maybe other things like complexity of case or years of experience and things like that. We also support fully staffing the central office. That's been always something that's important to MACDL in order to effectuate the recommendations of the Sixth Amendment Center. we need people in place who can take on the roles of financial overseers and people who are interested in quality and training and oversight. We obviously appreciate finally getting some support from the legislature over the past session for really funding these proposals. To speak just briefly to the auditing, our concern is mostly that the auditing, as it's written now, is all financial vouchers, all financial requests are subject to auditing, which doesn't really make sense financially or from a staffing standpoint. MACDL does support a more robust ability for the executive director and the commission to investigate either issues concerning quality representation or financial oversight. Those are things that have been brought up again and again as issues that we are concerned about as a state. We are not opposed to that. We think it's appropriate that those positions be funded. We just don't think auditing should be the thing that eats up the budget. It should be used appropriately and narrowly to investigate either financial or other issues with rostered attorneys. So we do support that. We just want to make sure that with the appellate office, that it's not half funded, it's not a quarter funded, it needs to be fully funded. An appellate office, a statewide appellate defender office would be extremely important. Thank you, Senator Carney, for criminal defense throughout Maine and protecting people's rights across the state. So thank you. I'm happy to speak further if anyone has questions.
Thank you very much. Committee members, are there any questions? And not seeing any, we appreciate your being here today. Next, we will hear from Jan Collins. Go ahead, you may proceed.
Greetings, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Jan Collins. I'm Assistant Director of the Maine Prisoner Advocacy Coalition, and I'm writing in support of LD 1687, an act to improve the provision of indigent legal services. The bill would correct a number of the shortcomings in Maine's current system of indigent defense. It changes the salary range for the director and allows the commission to directly hire attorneys to provide legal services to indigent clients. In the last year, investigations by the Maine Monitor have confirmed many of the findings of the Sixth Amendment report and revealed a number of questionable practices at the MCILS. This bill would direct the commission to carry out regular audits and give it the authority to recoup payments. The change of standards of training for attorneys from major substantive to routine technical will allow for the commission to make timely additions to the training of attorneys qualified through its office. We thoroughly support the additions to the commission staffing. The commission has been overworked and short-staffed almost from its inception. As a result, it has been unable to meet the demands of the standards for public accountability and tracking. We have one disagreement with the bill. We need well-trained, committed attorneys, enough to adequately cover caseload. To do that, we need attorney pay comparable with the remuneration found in private practice. We believe the compensation to attorneys should be at least $120 per hour, $40 per hour higher than the bill suggests. This level of payment is necessary to meet the basic costs of running a law office with support staff. If we are to provide adequate defense for the indigent, we should show that we value defense attorneys as highly as we value prosecuting attorneys. We should not be asking defense attorneys to work at rates that do not allow them to meet the basic needs of their office. We are grateful to the sponsors of this bill and the other indigent services bills heard today. We hope you will consider our suggested amendment for compensation and pass this bill as amended.
Thank you very much for your testimony. Committee members, are there any questions for Jan Collins? Not seeing any. Thank you once again. And next we'll hear from Doug Dunbar. You may proceed.
Thank you, Senator, and everyone. If you didn't have too much of Doug Dunbar before, now you may. But I appreciate your time. And again, I'm here. This was a day I waited for 3.5 years, as I said before. Our indigent legal service system, as you all know, is badly broken. And I don't envy you. Your job is to try to figure out how to move forward. I don't envy you. I agree with Jan and Tina that resources, funding, is one of the key elements here. And I know that it's going to be difficult to achieve that. And that is so disappointing. And as someone said earlier, Mr. Cummings, I believe, that we should be ashamed. When I went to jail, I knew I was there because I was ill, and I was ashamed of the actions I had taken. But as someone who worked in government 30 years, what I was most ashamed about was the criminal legal system that we have created and perpetuated for decades and decades and decades. We don't realize, or we don't pay attention to, myself included before I went to jail, the ripple effects, the tentacles of problems that emanate from a badly broken criminal legal system. Think of all the people who are harmed when people stay in jail and languish, when we don't treat the underlying problems, when we don't have a criminal defense system that properly provides adequate defense. It ripples on and on throughout society. Taxpayers pay a heavy burden because of what we do wrong. And so I don't know all the answers to whether we should have an indigent legal service system that's properly funded, or the alternative, public defender office is properly funded, but they have to be properly funded, and your attorneys have to be oversight. When I was the Deputy Secretary of State, I helped run an organization that had hundreds of employees. You have to have proper oversight, and we don't now. We don't. These attorneys, so many of them are good, decent. A system that's better funded, has better oversight, will be better for them. And the attorneys who do a poor job, and there are plenty of them, partly because they're paid only $60 an hour, coming up on 10 seconds, it'll weed some of those people out. And there are so many of them. I wish you could talk to people who have been represented by the indigent legal services system. You need to talk to the people who have the lived experience. Thank you.
Thank you so much, Mr. Dunbar. Committee members, any questions? Not seeing any, and we do appreciate you being before the committee today. And next we will hear from Megan Sway.
Hi, good afternoon, Senator Carney, Representative Harnett, members of the committee. My name is Megan Sway, and I'm Policy Director at the ACLU of Maine. I will not repeat all the portions of my testimony from earlier, but just say again that these are constitutional issues that are not up for debate. We must provide constitutional rights. It's the state's obligation. In no other area of government would we think it's appropriate to outsource a critical public function to private contractors with no supervision or accountability. Yet for the constitutionally required government function of ensuring fair trials for people at risk of losing liberty or property, we are doing just that. Last year, the Maine Commission on Indigent Legal Services requested money in the biennial budget to expand its office staff to allow it to provide meaningful training and supervision. And earlier this year, this committee supported that request. MCILS also requested money in the biennial budget to add a statewide public defender appellate office to provide high quality representation and to help keep lawyers updated on the many developing areas of law. And MCILS requested money in the biennial budget to establish the state's first trial level public defender's office right down the street from the State House in Kennebec County. None of these proposals were funded in the biennial budget adopted by this legislature, a situation that this bill and others being heard today is attempting to remedy. All of these proposals are necessary, but are not sufficient. They're a start, but it has been 2 years since the Sixth Amendment Center issued its report and more than 10 years since the legislature required MCILS in statute to establish standards governing the evaluation of assigned counsel, caseload, and conflict management. as well as processes and procedures for properly training and evaluating counsel. Maine should be much further along in its journey since this has been going on so long. We have a long way to go. You all know about the OPEGA report that suggested that these standards are not being enforced even now, even 2 years after this report. I'm just here to put some urgency in the situation. Thank you guys. I know you all have been working really hard and this committee is really dedicated, and we urge you to take this important first step and help Maine on the road to complying with its obligations. Thank you.
Thank you very much. Committee members, are there any questions for Megan Sway? I am not seeing any.
Have a great afternoon, everyone.
You too. And I think that takes us through everybody who wished to speak in support of 1687. Just quickly turning to the attendee space, if you wished to speak in support and have not yet, please raise your electronic hand. If you wish to speak in opposition to 1687, please raise your electronic hand. And if you're neither for nor against 1687 and wish to testify, please raise your hand. We have one person, Robert Ruffner, who wishes to speak. Welcome once again, Robert Ruffner. You can proceed with your testimony.
Thank you. I am Robert Ruffner from Yarmouth, Maine. It's too windy to be outside to testify. I am a commission attorney, or I should say that the work I do is almost entirely commission work. I'm here to speak both for and against, which this seemed the best category. I think it's important that, as Representative Harnett said, that this bill does not go far enough. It is an important, long overdue step forward towards meeting many of the deficiencies in the system that will help ensure that Mainers get the best quality representation and that the good attorneys doing it have the support and resources they need to do that work. However, it should not be viewed as a final solution that will solve all of our problems, that we will not need to redress this issue in the future. Hopefully it will give the staff at the commission more time to more thoroughly present the needs that it has in greater detail, work to create the coalitions to build the backing so that those coalitions in initiatives can achieve success in legislature and with the executive. I do want to point out one part of this bill that does raise a question for me. I think, or I'm conflicted on. That is the first section dealing with the range of the executive director. On the one hand, I think it is entirely appropriate that it be adjusted to this level because of the very important work that that position does. It's the closest thing we have to a chief public defender. However, I'm conflicted for a couple of reasons. One is it fails to address the deputy director position, a very important position, one that for many months stepped in and performed all the duties of the executive director because they are still searching for a final executive director. That undermines not only that position, but also the transition planning if you don't have a deputy director that's in the same close to that range. And finally, that change being made as it's coming now at the end of a executive search does raise some issues. However, I think that overall this bill is an important first step, and I thank you all and hope that you will vote ought to pass.
Thank you very much. Committee members, are there any questions for Robert Ruffner? I am not seeing any. We appreciate you being here and appreciate your testimony today.
Have a good day.
And with that, I think we have heard from everyone who wished to speak on LD 1687. So I'll close the public hearing on LD 1687. The committee has been meeting since 9 o'clock this morning. We're about an hour behind our schedule. but I do think it's really important for committee members and our staff to take a break. And so is it acceptable to everyone if we resume at 2 o'clock? Thank you, everyone. We will see you back at 2.
And I can't start my video up because I must have left it running. Can you restart it for me?
I've been talking with my microphone off. Sorry, everybody. Welcome back, everyone, from our lunch break. It is 2 o'clock. We're going to get started with our final public hearing for the day. It's LD 1719, and Representative Sampson has joined the panel and is ready to present her bill, and you may proceed. And welcome to the judiciary.
Thank you, Senator Carney and Representative Harnett and members of the Committee of Judiciary. I am Heidi Sampson, representing the good people of House District 21, Alfred, Limerick, Shapley, Newfield, and Parsonsfield. I am pleased to present LD 1719, an act to prevent human trafficking and child exploitation. Allow me to put this bill in some context. Minors are currently prohibited by state law from buying an X-rated magazine from a retailer or watching an R-rated movie at a movie theater. However, for more than 2 decades, minors have been purchasing X-rated portal theaters from retailers of internet-enabled devices with no consequences. This creates a double standard in law that has generated a litany of secondary harmful effects on children and families. The United States Supreme Court in Ashcroft versus American Civil Liberties Union found that the legislative branch may undoubtedly act to encourage the use of filters. It could also take steps to promote their development by industry and their use by parents. This decision is the means by which the Supreme Court's signal to the state legislative branch that it could pass filter legislation such as this act. It will survive judicial review since filters are the least restrictive means for purposes of the First Amendment of the United States Constitution. The United States Constitution found in Ginsburg versus New York that a physical display statute, state requiring physical brick and mortar stores to put physical obscene material behind a physical blind rack was constitutional under the First Amendment, heightening scrutiny. Likewise, a digital blinder rack statute, such as in the Act to Prevent Human Trafficking and Child Exploitation, requires digital retailers to put digital obscene material behind a digital blinder rack, which is also constitutional on the same legal basis. The Supreme Court of the United States has repeatedly held that the states have a compelling interest to uphold community standards of decency, as reflected with this bill, is rationally related to a narrowly tailored compelling government interest. So the act to prevent human trafficking and child exploitation is not overly broad because the filters are not required to block by default all pieces of obscene content on the internet individually, but only certain stagnant websites that are known to facilitate human trafficking and prostitution, and websites that display X-rated material that is injurious to minors. Sex trafficking has substantially moved from the street corner to the smartphone. This means that making websites facilitating human trafficking and prostitution inaccessible by default, internet-enabled devices will do more to curb, it'll do more to curb the demand for such offenses, more so than any other means since the inception of the internet, having a positive impact on reducing incarceration. The state is generally opposed to online censorship unless the content is injurious to children or promotes human trafficking. Only then is the state for limited censorship that accords with the First Amendment burden shifting principles. For more than 2 decades, the retailers and manufacturers of internet-enabled devices have marketed their products as quote unquote family friendly in a manner that constitutes false advertising and indecent deceptive trade practices. The state is not anti-technology, but instead a scaling back the dark side of technology in a manner that accords with existing product liability laws enacted by the state. Over 20 states have resolved that pornography distributed through internet-enabled devices has created a public health crisis. And this act to prevent human trafficking and child exploitation is the best solution to the unresolved problem. In conclusion, I ask this committee to consider the hundreds of thousands of voiceless children who have become trapped in this rapidly growing, currently $150 billion industry of child trafficking. Shutting off the open conduits and snaring children is a logical step I ask each of you to seriously consider. And I thank you for your attention.
Thank you very much, Representative Sampson. And I see that we have some committee questions for you. Go ahead, Senator Kime.
Thank you. Thank you for being here, Representative Sampson. I'm wondering so are you picturing that when someone attempted to access this type of material that they would have to enter their birth date? Is that what this would accomplish?
Well, I think, that would be part of it. And, there could be paywalls that are put up. There are some options that could be done. I think that's, I had that initially in this bill, but we took some of that out to simplify the bill. And just if we can get this into statute, then we can be looking at some of the specifics on that level.
Okay, thank you.
Committee members, are there other questions for the bill sponsor? I'm not seeing any. Thank you so much, Representative Sampson. And it's the custom in this committee that we allow sponsors to stay on the panel. And so you're welcome to stay if you'd like.
Appreciate it. Thank you, Senator.
Okay. And I think there's a number of people who have signed up to testify in support of this legislation. And I believe that Representative Quint is here, and I'm going to recognize the representative first, and then ask those who are in the attendee space who would like to testify to please raise their electronic hands and keep them raised until you've been called to the panel. So that's in favor of 1719. Please raise your electronic hand. And Representative Quint, welcome to the Judiciary Committee. You can proceed with your testimony whenever you're ready.
Thank you so much. If you lose me, I'm sorry. I'm at an unstable area and I'm using someone else's internet, so I'm at someone else's house right now. My name is Tracy Quint. I represent House District 144, which includes Amity, Bancroft, Benedicta, Cary, Glenwood, Haynesville, Hodgdon, Holton, Macwahock, Orient, Reed, Weston, Molunkus, Silver Ridge, and South Aroostook. Senator Carney, Representative Harnett, and esteemed colleagues of the committee, I thank you for this opportunity to bring more awareness to an issue surrounding the exploitation of our children. This bill addresses the exposure of often dangerous and disturbing images to our children that once seen cannot be unseen. It is not just the exposure to the strong pornographic nature of the material that is detrimental, but also the dangers that often lurk within these sites where predators are waiting to pounce. As more children are given access to these sites, often by parents handing over a cell phone in the name of safety, we are seeing that this very thing is a dangerous, unintended consequence. Evil does exist, and it seeks out to harm the innocent. Children are targets of this exploitation. It is amazing to me that websites are able to find, edit, and delete content that does not fit narratives, but they claim they are unable to manage content surrounding child exploitation, abuse, and human trafficking. I'm a strong advocate for personal freedoms, but a filter on the most egregious sites does not take away from our First Amendment right, as it still allows for access to these sites and autonomy of thought. It would only require an additional step to gain that access, and this is where a layer of protection for our children comes into play. If there is any way to head off this type of early exposure for our children, it would be a step in the right direction. I strongly urge you to join Representative Sampson in her endeavor to protect our children and vote ought to pass on this bill. Thank you again for your consideration.
Thank you very much, Representative Quint. Committee members, are there any questions for Representative Quint? I'm not seeing any. We appreciate you providing testimony today. And at this point, I'll bring over Tiffany Marlar. Actually, I'll bring over all three who have signed up to provide testimony. And Tiffany Marlar, once you've joined the panel, could you please activate your audio and video and go ahead with your testimony?
Hi. Can you all see me okay? Can you hear me?
Yes. Yes.
All right. Hi, my name is Tiffany Marlar, and I'm the Director of Missouri for Special Forces of Liberty, and I'm also the federal champion for this bill and the SOCO bill for 2022. I am thank you for hearing me today, but I'm also very, very strongly testifying in approval for this bill. I'm very happy to hear that you guys are considering it for the 2021 session before the 2022 begins. I have heard a lot of strong points, so I'm not going to cover the points that I've already heard Heidi Sampson say. So I would like to cover something that I have not heard anybody say. The grant funding that will become available through the Attorney General's office in your state and every other state would provide wonderful benefits that we do not have in every single state that comes down through each state. This bill would provide equitable measures for your state that you do not have to provide monetary benefits for victim compensations, shelters for sex trafficking victims, child advocacy centers, family counseling centers, regional nonprofits for civil legal services to provide legal assistance for sexual victims, and grants for the students of survivors and victims themselves. This is a push and a movement that I have been personally working on for 5.5 years, and it is now finally coming to fruition. This is something that has not been heard of in 20 to 30 years. This is a research project that is an international broken down to a national, to a state level. And I am strongly, strongly asking, as not only a survivor leader, but a major, major component and supporter of this bill, that you strongly, please, I'm asking you to consider moving forward with this first part of this bill, because this is a long-standing movement, but this will help set the movement forward for the entire country. And that's all I can really say.
Thank you very much. I do have one preliminary question for you, which is that everyone who provides testimony before this committee is asked and is required by our committee rules to let us know where they reside. And I don't think you included that in your testimony. Go ahead.
I'm sorry, St. Louis, Missouri. Yes, ma'am.
Thank you so much. Committee members, any questions for Tiffany Marler? Go ahead, Representative Libby.
Thank you, Madam Chair. It's Friday, so I'm on alternative technology and don't have an electronic hand. Thank you for being here today, Ms. Marler. My question would be, I'm trying to figure out what the downside is here. What would the opposition to this bill even be?
We've had a little bit of opposition with the first writing of this bill, where I had some national opposition for the deactivation filter fee, but we've been able to get a workaround with that, where we're going to have another bill written after the SOCA bill. But the problem is with it, in all honesty, that's been from people who just honestly don't want their name written down. And I'm a researcher and I work with the federal government. And if you're wanting my honest opinion, this is something that we need to do to protect our children and our women and our men that are victims of sexual exploitation and human trafficking. Not only sexual trafficking, but labor trafficking, which is a huge problem in our country. If we do not start setting measures to protect our victims, then we have no accountability. And this ranges all the way down from low-level offenders all the way up to our elite offenders. And it's something that's not very much liked or talked about. We fight big billion-dollar corporations that don't want these measures set in place. They try to say that they have their deactivation filters set in place within their companies, but that's the type of money that we're fighting. They don't want to do it. And that's where we're at right now. So it's states upon states and the federal government fighting against the state governments. And that's where I see it happening right now, because it's a new movement, a new measure trying to fight the big oligarch companies.
Thank you.
Mm-hmm. I see that Senator Keim has a question for you as well. Go ahead, Senator Keim.
Thank you. Thank you for being here, Ms. Marler. I was wondering, Representative Sampson mentioned the health crisis and the impact of this on the population, especially on children. But I wonder if you could offer a little more insight into what that impact is, and also if there are any studies or anything that you could share and maybe give to the committee along with your testimony.
Actually, I just attended a symposium at the International Harvard University and the Christian academies. Sorry, I have a TBI, so please bear with me. We just found out that during COVID, we have a huge crisis coming about. I did a speech at the Biden's inauguration for healthcare workers for human trafficking as the survivor speaker. And the research studies that I'm involved in right now are kind of twofold with the COVID-19 crisis. We have a huge problem that we're getting ready to come into with domestic violence, sexual exploitation with the actual platforms of the internet. Something that that nobody's talking about except for us and our circles is how are we going to manage what we had a 30 to 40%, we're looking at a 60 to 80% increase into the prevalence of healthcare workers that we do not have, that we're going to need into a critical infrastructure of dealing with mental health workers. We're going to need them because we're going to have a new group of individuals that are coming out of lockdowns that have been held together in homes that we weren't able to track and trace and trap. And that's the term that we're using, because that's a term that we use to track and trace and trap criminals, but we're using that same term to build a database now to try to find these survivors and these victims, to build a national database for a healthcare system. Because coming out of COVID, we have a bunch of children that have been locked down with parents that have been witnessing events or been in events that are now going to come out and need help. We have never had a situation like this, and trying to figure out how to deal with this, it's something that on a federal level, we are not going to be able to accomplish unless all 50 states have a mainframe set up and set in place and start working together now, proactively, before this problem becomes a huge problem. And it's not just for any class, color, race, creed, gender, or anything. It's everybody, because we already have an epidemic. And this epidemic, I'm sorry to say it, but can turn into a pandemic of a mental health crisis in this case. And it's not just in our country. I've been around the world. We have it around the world already. So with me working on an international level and bringing it back to our country, and now trying to work it to where we're getting it in all of our states and the awareness in our states, that's why I've received some pushback, because trying to adhere to our international humanitarian laws and bringing that back into our country and adhering to the SPHERE guidelines with the UN, we have a crisis in our country that we have not been talking about and adhering to the guidelines. And that's where I've come in. We have a huge crisis on our hands. I'm sorry.
Thank you, Ms. Marler. Yes, thank you so much.
You all set, Senator Kine? Thank you. Committee members, are there any other questions for Tiffany Marler? Okie doke. Thank you very much. And we will hear next from Ernest Shell.
Can you hear me?
We can. Go ahead.
Thank you, guys. Thank you. And I appreciate the committee for having me on today. From Tennessee, I work around the United States. First and foremost, my name is Ernest Shell. I'm a former bounty hunter, fugitive recovery agent, private investigator, executive protection specialist. I am the operations director for Operation Rock, which is Rescue Our Children. I've had numerous rescues and helped with numerous rescues of children throughout the field, throughout all parts of the United States, including the Northeast. We formed Predator Hunter Nation on account of things of this nature. Being out on the street, you actually see it. You actually see what's going on. And it's like before, what was already mentioned, prostitution is not on the streets no more. It's on our cell phones, pretty much. As time goes by, criminals, they get smarter. We also get smarter. But what we forget is the different kind of crime it is. It's hard because there's really no advocacy for this. You have to be trained in a way that's not really teachable by handbooks. You have to see it by experience. I've been there. I've seen that. I know what goes on. And when you look in what's going on their websites and how it comes about, how these hotels and things go around and how they have the trafficking going on through the hotels and things of that nature, but it all leads up to the websites. So I hope you guys can consider and go in favor of LE 1719, because it's our children, and children are our future. They're God's gifts to us. And much respect, and God bless. I'll take any questions. Thank you.
Thank you very much, Mr. Shell. I have a preliminary question for you. Thank you for sharing with us that you're from Tennessee. Could you please give us the town in Tennessee where you reside? It's just one of our committee rules.
Newport, Tennessee.
Thank you very much. Committee members, any questions for Mr. Shell? I am not seeing any. Appreciate your testimony today.
Thank you.
You're welcome. And next we have Christopher Sevier. And Christopher Sevier, there's also somebody in the attendee space with your same name. Is that a duplicate or is that a different person using the same link? I just want to clarify process-wise. We're not able to hear you.
Thank you, Madam Chairwoman. It could have been me signing up twice.
Okay, great. All right, go ahead and proceed with your testimony, please.
Yes, Madam Chairman and members of the committee, thank you so much for having me. I'm going to talk very quick. Chris Sevier, de facto attorneys general. There's about 24 states that are running this bill. This is a bipartisan measure. This bill is a result of a lot of multi-state federal litigation against big tech. I worked with FBI and special forces do extractions in human trafficking. I've been shot at on human trafficking missions. I personally litigated against tech on this topic. And so I'm going to talk very quickly. So Representative Sampson's bill says this. It says, going forward in the state of Maine, any retailer of an internet-enabled device is going to have to ensure that the product comes with a filter that's automatically activated that blocks by default websites that are known to facilitate prostitution and human trafficking, and websites that display X-rated material that would be injurious to children. If the consumer is an adult, they want to have access to adult websites, they can. They just have to show proof of ID to the retailer and express an interest to have the filter removed. There is no database that's formed from this bill. And so what this means in plain English is when a member of your district goes to the Best Buy, a mother goes to buy a computer, or a school goes to buy computers for their schools, instead of making the mother or the schools have to go to Geek Squad to pay a lot of money to have a third-party filter installed, the product's going to go ahead and come with a filter already installed that just blocks the material by default. This is a common sense burden shifting scenario pursuant to the First Amendment, where consumers are going to have to choose to opt in. We've heard lots of bills today on criminal justice reform. This bill will do more to prevent human trafficking and crime than any other measure since the inception of the internet, period, full stop. 3 quick bullet points. Case law. Ashcroft versus the ACLU. It was the ACLU's idea that filters were the least restrictive means to this problem. The Supreme Court agreed and said Congress and Dowling may act to encourage the use of filters. It can encourage parents to use filters and the tech companies to develop better filter technology. Point number 2, Ginsburg versus New York. This is a very clean way to understand this bill. It's called the display statute, which Maine has. It's a statute that says if you live in Maine, you want a gas station or a newsstand, you can sell Playboys and Hustlers through your store, but the retailer is required to take that X-rated content and put it behind a blinder rack that can only be removed if the consumer is an adult. They show proof of ID and they pay for it. This is just the digital version of that existing display statute. There are all kinds of exceptions and so forth carved out in the bill. I'll be happy to address, but it basically, again, is designed to where the people of your district don't have immediate access to torture pornography websites or prostitution websites. Another point that Representative Sampson made. Why is it that a 12-year-old in the state of Maine can't go see they can't buy a Playboy from the gas station? They can't go see an R-rated movie, but they can walk around with an X-rated theater in the form of a filterless iPhone they got from the local Verizon store that happens to be located next to the theater and next to the gas station. It's a double standard. It's a crime now to distribute pornography to minors. As a former prosecutor myself, I'm all for criminal crime prevention. This really will do an enormous amount to protect law enforcement. As Ernest Shell said, sex trafficking has gone from the street corner to the smartphone. And so what this bill will do is it will do an enormous amount to proliferate human flourishing, protect children, and reduce the serious problem of human trafficking. Thank you so much for your time.
Thank you. And I'm sorry I didn't give you the 15-second warning. I got was not paying attention to my timer. I see that there are some committee questions. Go ahead, Senator Khan.
Thank you. Thank you for being here, Mr. Sevier. A couple of questions. So you mentioned that this filter would go on the product itself. It wouldn't be something that's online. So this bill seeks to make so that every product that's sold in Maine has to have a filter on it. Is that, do I understand you correctly on that?
Yeah, so basically it's internet-enabled devices, which means laptops, cell phones, internet service providers. This isn't a product that regulates the internet. It's not about providing your age or anything of this nature. This is a product liability issue where we're saying the current condition these products are sold in are dangerous and defective. And so we've worked a lot with the Retail Association and the ACLU exhaustively on this topic. And we put into the bill that the retailers have permission to charge their own separate filter deactivation fee for profit. So sometimes we just joke around and say we should call this a new tech revenue stream of 2021 because it's going to make them new revenue. But we're telling these tech retailers and manufacturers, listen, you guys are the superseding cause of this continuing problem. We have an explosion in domestic violence and human trafficking because they have not done stuff to block those websites by default. Now, we don't want to get rid of them, but we do want to make it more inconvenient to access. We want to make the objectively healthy choice the easy choice, if you will. So sorry to go on a tangent, but the answer to your question, yes, it's internet-enabled devices, laptops, cell phones, ISPs.
Okay.
By
Okay.
default, have to block the material, but like selling Apple would have to sell its products with
Thank-
parental controls activated. Yes,
Thank
ma'am.
you. So then you also mentioned that this is going to help protect law enforcement. I don't understand how that is. Could you explain that?
Yes, ma'am. So basically, in terms of, we're really focused on a lot of criminal justice reform. We're big advocates of trying to keep people out of jail, because once they've been accused of crimes, we've heard in other bills today, it's a big mess. And so law enforcement, we in the 1990s, in the 80s, we didn't have an explosion in human trafficking. It was only once we had the internet. And we're not against the internet. We're not against product. We have lots of friends that work at big tech. We're not for that, but we want them to scale back the dark side of their technology. Law enforcement has been overwhelmed by the fact that prostitution portals are above ground. And, you know, we deal with lots of Johns, people who've been arrested for prostitution, and they say that the problem, they didn't grow up wanting to become a person who hires prostitutes or engages in human trafficking activity. But what happens is it's just so easily accessible. These websites are above ground. Anyone can, in Maine, can do a search for this stuff and order up something online, and it wrecks communities. It brings in enormous drugs. Yes, ma'am.
So then just to get to my question though, so you're just saying it will protect law enforcement because it's going to reduce the availability of this, and so therefore reducing their workload. Is that, would I be understanding that correctly?
That would be an accurate characterization of what I'm trying to say, by basically saying, by closing this door by default, you have the power to do that. There are tens of thousands of men in Maine that will not take the affirmative steps to show proof of ID. Now, they don't have to put their name in a database, okay? They would have to show proof of ID, and they would have to request to have the filter removed. And there's just tens of thousands of guys that won't take that step. The door will be closed. I mean, when I'm in court and I'm before judges, I'm always telling the judges, Your Honor, there's just some doors in life that are better left unopened. We want the door closed, and we want people to have to take the affirmative step to open it. That then can expose them to an enormous amount of criminal liability. We're not just talking about human trafficking. We're talking about revenge pornography. We're talking about child pornography offenses. So
I understand. Thank you so much.
Yes, ma'am.
Committee members, are there any other questions? I just had one quick question for you. I think you probably heard me ask the other folks. We do require people to tell us their town and state of residence. So if you could do that for us before you sign off today.
So I'm living in Hollywood, California as of this week, but normally I'm living in New York City.
Thank you so much.
Yes, ma'am. Yes, ma'am.
All right, committee members. Appreciate you being here.
Thank you so much.
Thank you. And let's see, there is one other person still with a hand up, also named Christopher Sevier, and I'm just going to ask this person, could you please identify yourself?
Can everyone hear me?
Yes, can you just tell us who you are, please?
Can you see me?
We can see a picture of you, but I would like you first to just identify yourself, please.
Yes, I'm Reverend Shane Anthony. I'm a pastor in the Madison, Tennessee area, and I've been working.
Are you here to testify in favor of LD 1719?
Yes, I am.
Could you activate your video as well, please?
Yeah, I'm trying to figure that out, but I'm not sure how to do that. I don't see the
I can prompt you from this. Nope, I can't prompt you from the side. Okay, go ahead and provide your testimony, please.
All right, but you can hear me. So I'm a pastor in the Madison, Tennessee area, and I've been working on this bill here as well. And I can tell you as a pastor that I see firsthand pornography destroying families. Even just this week, dealing with a family whose father's leaving a wife and children, and he's been watching pornography. And this bill I just want to say simply, this bill would require internet-enabled devices such as a cell phone, a tablet, a computer, a laptop, to come with a filter activated by default. That's simple, just that simple. And you can't just enter your age and make it go away, because kids these days, they're smarter than the parents. And I have another friend, a good friend, a father, who tried to block his kid out of something on the computer, and the kid figured out his dad's password. And the father seemed like he was helpless in trying to block his kid out because the kid was so technologically minded. And all 50 states have the display statute. So I believe it's more than time that technology would catch up with this. A child can't just go buy a Playboy magazine, but any child can just turn on his phone and watch anything he wants. Any 8-year-old, 7-year-old, 6-year-old, 10-year-old can see any filthy thing. There's absolutely nothing to block them or stop them. And it's just a simple one-time activation fee. If you're an adult and you want access to X-rated obscene material, you buy this laptop, you pay your $20 activation fee, and the store unlocks it for you, and you take it home and you have that obscene material. And I want to just say lastly, I think this bill is a no-brainer. I don't see how there could be anything against it. The United States Supreme Court made it clear that the states have a compelling interest to uphold community standards of decency. So a statute requiring a filter deactivation fee would be such a thing. I vote in favor of this, and I just wanted to share those thoughts. Thank you for your time.
Thank you very much. And I didn't catch your name. You were quite clear about where you're from. Hang on a second. Go ahead and if you could spell your last name, please.
Sure, Anthony, Anthony. Shane Anthony.
All righty. Thank you so much. Committee members, are there any questions for Shane Anthony? I'm not seeing any. Thank you for providing testimony to the committee today.
All right, thank you.
And now I think that we have heard from everyone who was here, who had raised their hand to testify in support of 1719. Is there anyone in the attendee space who wishes to testify in opposition to 1719? Not seeing any. Whoops. Is there anyone who wishes to testify neither for nor against 1719? Again, not seeing anyone. And so with that, we close the public hearing on LD 1719 and thank Representative Sampson for being with us this afternoon. And now we have concluded our public hearings. And so we're going to move on to the work sessions for today. And I'll just quickly review the order in which we'll take up the work sessions. We're going to start with 1510 and then 1591, 1692, and conclude with 1688. And so we will open the work session on LD 1510.
Senator Carney, that one is mine.
Okay, great. It's wonderful to see you, Sam, and you can go ahead with your bill analysis.
Sure. So LD 1510 is an act concerning informed consent of minors' authority to release healthcare information. So this bill would amend the laws governing the confidentiality of healthcare information to provide that if a healthcare facility or healthcare practitioner maintains a minor's records electronically, the records must be provided electronically to any person authorized to access the minor's health records. The committee heard quite a bit of testimony, and there was quite a lot of written testimony on this bill. I did summarize all of the testimony in the written bill analysis, but I did want to point out just a couple things. So much of the testimony in favor of the bill was from folks who were testifying about their experiences trying to access electronic health information for their minor children. And a number of folks noted that at the time that their child turned 12, they were unable to access electronic healthcare information that they had previously been able to access electronically, although they were able to get written copies of records. Opponents of the bill noted that this is the reason for that difference is because electronic medical record systems aren't able to build a firewall between the records that are protected. So there are certain categories of procedures and services that a minor can specifically consent for under the law. And I did actually provide you a chart of a list of all of those citations under the main law, so you can see where they lie. There's kind of two categories. There's a category that describes something about the person. So if a minor is, for example, married or in the military or emancipated, they have the ability to consent themselves for all of their medical treatment. There are other very specific categories of services that any minor could consent for. So things like reproductive health care, abortion services. A minor has the ability to consent without the parent for those services. And as we heard in testimony, it seems that the reason that parents are not able to access medical records of kids once they turn 12 is because the medical record systems aren't there technologically to separate out and build a firewall between those two records. So as a matter of practice, what the health systems have done is to set a point, which appears to be 12, although another person commenting did reference the age 14. There's no statutory floor as to the low age of consent. So I think that what we heard from the healthcare organizations is they need to choose an age when they start separating this out or not. When they stop giving parents access because of the concern that they would release information that was not legally available to the parent that a minor had consented for themselves. Again, heard quite a bit of testimony regarding those challenges. We also did hear from OCFS, the Office of Child and Family Services. It was not taking no position on the bill, but expressing some concerns that this legislation could complicate their ability to direct who gets medical information if a parent has changing guardianship status or ability to access their child's records. I did also in your bill analysis, it was asked if folks could have a rundown of the current law as regards electronic records and healthcare record confidentiality generally. So I went through and included all of those relevant statutes and copied and pasted them for you. I also highlighted some of the more salient sections of those laws for you. So you will see statute does require that if a medical record exists in digital or electronic format, the hospital, if it's a hospital, shall provide an electronic copy of the record if an electronic copy is requested and it is reasonably possible to provide it. And I'm guessing that it's that last clause that is the challenge here, that it is not, that it is difficult to provide it because of the challenges presented by the electronic medical record. I didn't identify any other issues with the bill. This does seem to be a bill where it is the ability of the providers to do this seems to be the biggest problem here. So I will leave it with you. Thank you.
Sam, I have just a quick question for you. I was taking notes and I missed the phrase you said. So you said there's electronic records have to be accessible unless something, there was an exception. Could you just repeat that,
yes,
please?
so of course I turn the page. And it is reasonably possible to provide it.
Thank you. Senator Kime, go ahead.
Thank you. Thank you, Sam, for this really great overview. So I just wanted to clarify one thing. So, well, two things actually. Is your analysis up on the website and it's not appearing for me? Okay, it's not appearing for me. I will see what's going on there. Yes, because I was looking for some of this. Okay, so then it isn't in statute the age that the healthcare industry has to decide when they stop sharing records, or is it?
So what the statute lacks is what is the age of when is a minor able to consent? That nowhere in statute does it say, okay, 12 is when a minor is able to consent. And I think we heard, I don't remember which of the bills it was. There was some testimony about this because kids at that age are very different. Some kids would have the capacity to consent to some things, some kids wouldn't. And that is what we heard from providers is that is a determination that providers need to make on an individual basis. So there's no like statutory floor for when a minor can consent.
But it is in statute that they can't consent to their records being given out if it pertains to whatever sexual health care.
Oh, so it's actually so there is, let me okay, so at let me get the right citation here. There is some language in statute that speaks specifically to this, actually. It's Title 22, Section 1711C. And I'm sorry you don't have this, but it's on page 19 of the bill analysis, and it's subsection 12. And it says minors. If a minor has consented to healthcare in accordance with the laws of this state, authorization to disclose healthcare information pursuant to this section must be given by the minor unless otherwise provided by law. So if the minor consents to the underlying healthcare, the minor consents to the release of the records. If the parent consents to the underlying healthcare, the parent consents to the release of the records. Does that make sense?
Yes, it does. It does. Okay. Yes, I'm just trying to figure out how it can work better. Yeah, thank you.
Senator Sanborn?
Thank you, Senator Carney. I would move on not to pass on this bill. I think we have really important statutory provisions in place in Maine for minors to consent to certain types of care. And it's really critical that we safeguard those records. And it's really critical that we not try and hamstring our medical providers that are at varying levels of sophistication with regard to their online portals for accessing those records. I think the important piece here, the overridingly important piece here, is to ensure that minors who are consenting to their own medical care pursuant to some part of the statute that provides for them to do so, such as the sexual reproductive and sexually transmitted disease portions of our statute, are ensured that their medical privacy is protected. And the alternative, frankly, could cause them great harm at the hands of their parents who might access that record and then not have a good response to it. And we need to protect them, and we already do. And so we should vote ought not to pass on this bill. Thank you.
Thank you, Senator Sanborn. Is there a second? Seconded by Representative Sheehan. Go ahead, Senator Kime.
Thank you. I'll be voting against the pending motion. I think that what we've seen the healthcare industry do is create policies where no child can ever give their parent access to their medical records. According to Maine Health, I could not give my mother access to my medical records. My daughter could give access to many other people, but not me. So good families are being harmed by this policy. Because there is not timely information being shared with parents, and because we have a few situations that we all know and probably make more headlines than the rest of the good families out there, we're taking away the rights of parents to help advocate for their children's health in a timely manner. So I think this is really important. I do think that we could find a way forward with this. And I think that we're damaging families. We're making great assumptions about all family relationships and stigmatizing them all based on a few that really don't parent well and don't care for their children. And so those that want to care for their children well are roadblocked by the healthcare industry and by policymakers. And so I will be voting against the pending motion.
Go ahead, Representative Libby.
Thank you. I will also be voting against the pending motion. I think this bill has brought up some incredibly important issues. Prior to even hearing about this bill, I had heard from several folks in various areas of the state, not just my constituents, with the exact same story that Ms. White brought up in testimony, that they had tried to access not just electronically their child's records, and that one was the mother of a 17-year-old boy. When he tried to sign consent for his mother to have access to any form of his medical records, was then told that there was no such form. So you must sign the form for the parent to have access, but no, we don't actually have such a form. And I heard that same story from multiple people in different areas of the state. I will say it does seem to be, at least anecdotally, isolated to Maine Health, but that's not very helpful because Maine Health is pretty extensive around the state. I think it's incredibly important, of course, to ensure privacy, but it's also incredibly important to make sure that minors and their parents have access to their medical information. Having to wait a month for lab results is unacceptable. And the excuse that we can't do this because of tech issues is just really very silly. We can do all kinds of things with tech these days, and it would not be hard to put a firewall up so that the specific information that should not be shared was not shared. So that's a really very silly excuse. I will be voting against the pending motion, and I hope that this has at least brought attention so that maybe there can be a form made so that minors can consent to their parent getting information, at least where it's been an issue with Maine Health.
I don't see this as a good family, good medical care provider, bad medical care provider issue. I do believe the medical care providers when they tell us that their electronic medical records systems don't allow them to do this. I hope that they are able to resolve that issue soon so that the firewall can be created and so that these issues are resolved. But I don't think it makes a lot of sense to enact legislation that would then require healthcare providers to do things that they don't have the capacity to do in their current electronic medical record systems. I just think it's a technology problem and not a values issue. Anybody else wish to be heard on the motion? Okay, I think we are ready for the vote. And the pending motion is ought not to pass by Senator Sanborn and seconded by Representative Sheehan. And Ms. Panett, I think we're ready for the vote when you are.
Thank you very much, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Representative Thorne is trying to get attention.
Thank you so much, Senator Keim. Representative Thorne, go ahead.
Thank you, Madam Chair. I apologize. I was just able to get back on. I want to ensure what the bill is. I know it's an ought not to pass motion. I want to verify the bill number 1719.
No, we have moved beyond that. This is
No.
Hold on a second. I'm a little confused myself. It is not 1719. It's the first bill in our work session. It's 1510. Oops. Yeah. Did you get that, Representative? You look like you wrote it
Apologies.
down. Great. 1510, everybody.
Thank you.
Would you like me to repeat, start from the beginning?
Yes, go ahead.
Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier. Representative Thorne.
Okay.
Representative Thorne votes. I heard no. Is that correct? Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Harnett. Representative Harnett is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 6 members voting in the affirmative, 3 members in the negative, and 5 members are absent.
Thank you very much, Ms. Panett. For those who voted in the negative, could you please let us know your report?
Ought to pass.
Thank you very much. And so the motion ought not to pass carries 6-3 with 5 absences. And with that, we'll close the work session on 1510 and open up our next work session. That is on 1591. Yes, 1591. Representative Thorne, go ahead. Just, you can proceed, Representative Thorne.
If I turn my video off, can you hear me better with the video off?
Yes, for sure. Go ahead.
And I apologize that I was just able to get back on, but in my notes, I didn't have 1510 on the workshop work session for today. Sorry. On there in the participants room.
I'm sorry, can you try to repeat
And I
that?
apologize, I'm getting it. I was looking for the lineup in the participants room of the bills.
Oh, I can read them out to you. I actually did. I'll put them in the chat, but I'll also read them out to you. So we just did.
Okay, they're in the chat. I can find them in there.
Well, I'm not sure. Let me just make sure I put them in there.
Okay.
Hold on a second and I'll post it. Give me one moment.
1591.
Hold on. I'm not that great at multitasking. Let me post it in the chat.
Yeah.
Okie doke. So it's now posted in the chat. So we've done, whoops, I made a mistake. So we did 1510. We're doing 1591, 1692, and 1688 in that order.
Okay, thank you.
You're welcome. All right, and I think we're ready to open the work session then on 1592. No, excuse me, 1591. And Sam, if you'd like to go ahead with the analysis, that'd be fine with us.
This is LD 1591. This is a resolve directing the Department of Agriculture, Conservation, and Forestry to identify places with offensive names and methods of changing those names. So this resolve would direct the Department of Agriculture, Conservation, and Forestry to form a working group to identify place names in violation of the Maine Revised Statutes, Title I, Chapter 27. It directs the working group to seek to develop the best methods of identification, study, and suggest the most effective methods to change names, review current methods, and identify other place names with negative historical connotations. It directs the department to report the findings of the working group, including suggested legislation, to the Joint Standing Committee on Judiciary by December 1st, 2021. The committee heard testimony in favor of this bill. It was noted that just this last summer, it was noted that there were 5 offensive island names still on the Coastal Island Registry. Several of those have since been changed, and it is in the works to change the other 2. It was noted that this has been a problem in Maine for quite some time. The original bill from 1977 did ban the use of certain specified names in place names in Maine, but it was noted by folks testifying that some of those names are retained in the state, as well as other derogatory names. There were a couple folks testifying against the bill, noting that it wasn't a good use of state resources. I did include in your bill analysis the full text of Title I, Chapter 27, so you could see exactly what that chapter does require. The sponsor does have an amendment that she provided during the public hearing. If it would be helpful, I can put that up on the screen so folks can see it. It does change the charge of the working group somewhat. So I can either read it to you or I can put it up on the screen, whatever is most helpful to you.
I think it would be helpful, Sam, if you could put it up on the screen, please.
Sure thing.
Thank you. And I did want to welcome the bill sponsor to the panel. Hello, Representative Talbot Ross.
So what this amendment would do is to change the charge of the working group. You will see under Section 1 that the working group would be required to review Title I, Chapter 27 to determine and suggest any additional words to be included in the definition of offensive terms. It would establish a uniform process for renaming geographic features and other places that have offensive names, and it would explore the most effective methods of identifying individuals, entity, and institutions in the state that profited or benefited in any manner from the global economy of enslavement. And it does retain the December 1st, 2021 report back, and including suggested legislation to the Joint Standing Committee. And this draft isn't formatted yet, but you can see the substance of it there. Should I stop screen sharing so you can see one another?
Yes, please.
Thank you.
Yeah, thank you very much. It looks like we've got a couple of hands raised. Questions for Sam, and then we'll give the bill sponsor an opportunity to speak to us as well. Representative Thorne, your hand is up, and I didn't know if that was new or residual.
Thank you, Madam Chair. I'm a little bit at a disadvantage because Spectrum, cable, and phones are all down, and I talked to the guy out on the wire, and it's not just me, it's a big outage, service outage. And I was wondering is it possible, Sam mentioned 5 island names that are we allowed to say those island names? so we know what words we're talking about?
I actually don't necessarily think that's relevant to this bill because I think those names have already been changed. Sam, can you update us on the status of that, what happened this summer?
Testimony, Representative Talbot Ross may know better, but I believe at least 3 of them have been changed and 2 are on their way. But Representative Talbot Ross may know that better than I.
Thank you. Is it okay to speak, Madam Chair?
Yes, go ahead.
Yeah, those 5 names, 3 of them contained the N word and 2 of them contained an S word, which is considered derogatory to Indigenous Native American women. So it's probably not best to repeat those offensive, terribly painful names during this public hearing, but hopefully you can figure out what they are. And I do believe that the names have all been changed at this point in time. But what this does point out is obviously there's a flaw in the system. If just last year we had 5 names that violated state law.
Thank you, Representative. Representative Thorne, does that address your question adequately?
Yeah, it does. I was able to figure out, I believe, what the 3 N words and the 2 S words were. And I didn't know, are they still naming offensive locations, Representative Talbot Ross, that you're aware of, or are these like named from years and years and years ago?
So I thank you for the question, Representative. That's why this bill is necessary, is because we have to make sure that no current or future geographical place names are contain offensive names. And as it's been proven, last year in 2020, we still had 5 that needed to be changed. So that's why this bill is quite necessary, is because we do need people who are paying attention to some of this stuff. I will make sure that I state one other thing, which is not necessarily your question, but that is, this bill is not going to change those names, Representative. This bill is going to identify a process and bring it back to this committee for this committee to do further consideration. But we must put something in place so that Maine's geographical place names are not offensive, to the population.
And this is a committee that will be review all names before they're named to determine whether or not they're offensive?
No.
Is that my understanding?
Yes, thank you, Representative. What we did through the amendment is the Department of Agriculture, Conservation, and Forestry does have a process in place to review the names. What we will be doing is making sure that the definitions under the title that was cited during the presentation, that we have the right names included under that definitions statute. So that's one thing that we'll be doing, is aiding in that work by looking at the definitions and seeing if they're up to date. That's really number one, what we'll be doing.
And will this fall in line with federal guidance also?
Yes. Yeah, I don't know if you were here to hear Director Malvini state that, but there is a relationship between the state and the federal government's database of geographic names. And so there is a relationship there that when we change something in our registry, it gets changed within the federal registry. But even these 5 names, Representative, got by the federal database and the state's registry. These 5 got passed. These 5 got passed. So that's why this is not a bill in search of a problem. There is a problem, and we're trying to figure out the solution.
Okay, thank you. Thank you, Madam Chair.
You're welcome. Thank you. And thank you, Representative Talbot Ross, for those answers. Go ahead, Representative Evangelos. I think your hand was up next.
Thank you, Madam Chair. Representative Talbot Ross, I I did outline a real life experience to you. And the one piece I left out was the reason why those African-American families moved to Warren was because some of the men fought with Major General Joseph Warren. He was the head of the committees of correspondence, and he was killed at the Battle of Bunker Hill. So
yeah,
I'm gonna make a motion not to pass as amended.
Thank you very much, Representative Evangelos, and also thank you for sharing that additional information. That's your personal story was very powerful when we heard it in the bill hearing.
Well, what I wanted to demonstrate today, which I forgot to do the other day, was that even if you fought in the Revolutionary War, you still had the N-word 200 years later. Pretty bad. So this is real. And a lot of Representative Thorne, a lot of this is legacy stuff that's out there. I hope people aren't still doing it, although we have some school systems that are still debating the issue, I guess. But anyways, that's it. Thanks.
Thank you. So we have an ought to pass as amended motion. Is there a second? Seconded by Representative Sheehan. And let's see, Representative Babbage, your hand is up. Go ahead.
Yeah, I missed part of this hearing, and I just wanted, I'm going to support this motion enthusiastically. Actually, I wanted to share that in doing some research myself on a particular ship captain, I was just amazed at my inability to find explanation about involvement in the triangle trade and so forth, which we know he was very much involved in. And you wonder how much revision might have happened in the last 156 years or whatever. But my question to Representative Talbot Ross is in the, do I have that in front of me? In the search for information, for involvement was it enslavement or the slave trade in any manner, in any matter, I think was the phrase. That's merely a search for truth and transparency. Is that right? It's not. I mean, there are associations by degree, and as you said, there's no decision making that would be taking place as a result of the wording in the bill. It's search for truth and exposure. Is that primarily it?
Representative Babbage, thanks for that question. That's an excellent point. This is absolutely the search for the truth, and then this comes back to the committee, and you can decide what to do with that truth. But you know, in anticipation of the vote, I would just say to folks that you know, this history is still palpable. It reverberates in the everyday existence of people. This history reverberates in our lives every single solitary day. And to ignore that or to take that lightly is probably, it's hugely painful. It's very painful that there are some people who still want to deny this history or deny that it doesn't matter or deny that we shouldn't put any resources into it. It's hugely painful for the people who have to carry this around. And so this process is about telling the truth, because the truth telling is a form of relief. But the false narrative.
Thank you for
and
that.
the revisionist history is not. So thank you so much for the question, Representative. Absolutely, thank you. Yeah.
Thank you both. Committee members, any other questions for our analyst? And any questions for the bill sponsor? And Sam, go ahead.
I did just want to ask the committee, I noticed that the bill as drafted doesn't have specific language authorizing the committee to report out legislation. I don't know that it necessarily needs that, but often we see that just as to make it clear that the committee can report out legislation in the second session if the committee wishes, pursuant to the report back. So I just wanted to inquire if the committee wanted that language included in the amendment.
Representative Evangelist, would you like to include that in your motion ought to pass as amended?
Yes, yes, it's very important. Thank you, Sam.
Yeah, thank you for raising that, Sam. And let's see, Senator Keim, go ahead.
Thank you. I would just like to make known that I was greatly in support of the original bill and would like to vote in favor of that over the amendment. And so just putting it out there in case anyone else agrees and would like to go for a unanimous support. Otherwise, I'm happy to vote on my own report.
I think that I would go ahead, Representative Talbot Ross.
Yeah, I very much appreciate that, Senator Keim. I know this isn't I don't get to ask you questions kind of exchange, but I am curious as to what you found different from one bill to the other that would change a vote of support to not supporting. What specifically is there in the original bill? Because I am open to trying to understand that.
Sure.
If it means a unanimous support, yeah.
Sure. So what I do appreciate the original bill, and my vote won't be ought not to pass. My vote would be ought to pass, but not ought to pass as amended. And partly I'm a little concerned with a number of bills I see going through that gives the commission continued sort of inroads into making decisions around what the government's doing. I thought the original bill was adequate and important, and I think that it does adequately address the issue without adding in an extra layer of the commission. So that is, that's how I would like to see it move forward, and that's why I would be voting that way.
So, Madam Chair, if I could just provide a response to that.
Sure, briefly. I would really very much like to do a caucus, but go ahead, Representative Talbot Ross, and then we'll have a caucus break.
Yeah, I absolutely appreciate that, Senator Keim. The issue here is that the department does not have an adequate representation of the people who have lived experience that relate to this bill. So it's really necessary to include the Permanent Commission in this, because otherwise we have a department that's actually inadequate to do this work without that input. And the Permanent Commission is comprised of 15 people with various lived experience, including 4 tribal members, that could provide that necessary real-time information for the department to utilize in understanding what needs to be examined. So that's number one. The department doesn't have it doesn't have a very diverse staff in this bureau in which to do that work. The second thing is the Permanent Commission isn't making any decisions here. We are uncovering and discovering things and bringing it back to this committee to make some decisions. So I don't know about this, invasion almost of the Permanent Commission in making decisions, but it's just not applicable to this particular bill. Thank you.
I didn't use the word invasion, but I would just reiterate that generally when we ask a department to give an overview on something, they ask for opinions. They seek out the people that would have the interest and the stakeholders to inform their opinions. And so I think we do see that we have had departments look into things and make changes. So
yeah,
thank you.
I hear you, Senator. Unfortunately, that is not the case across every state agency. I believe in our state agencies as well. But when you have a workforce in this state that doesn't include people like me to the degree in which we live here, then I think that this department needs help.
Representative Talbot Ross, appreciate your contributions and yours as well, Senator Keim. We are going to take a 5-minute caucus break. We will be back at 3:25. And I would ask Dems to use our regular caucus link, and we will see you all in just a moment. 5 moments.
Done? What happened?
Oh, this we were just on with Claire. Casey was there.
I've done more talking on mute today than I think I've ever done during the course of a legislative day. Committee members, if you have returned to the committee meeting, please activate your video so we can see you all and move forward to our vote on this.
Okay, I was just going to ask Soupy if I needed to register my vote. I had to take a phone call at the end of that work session. So it sounds like you haven't voted yet. Great, thank you.
Nope. Your timing is impeccable.
Perfect.
Madam Chair,
Yes.
this caucusing is starting to work out for me. Yesterday, I got 2 rows of corn planted.
Cool. And today?
I ran out. I changed. I'm working.
Yeah.
I got to get my food planted before Saturday because it's going to rain and we get that warm weather coming. We don't usually get a chance like this in May. So.
Yeah.
So keep caucusing. I'm good with it. That is a change. See, I do change.
Yeah, that's right.
I wish I had some corn or something to plant.
Well, if you've
Such
got
a pretty day out today.
if you've got a lawn with sunshine on it, there's nothing else stopping you other than you get your husband to agree to dig up part of the lawn.
I had a lawn to mow yesterday, but it took an adjournment and not a caucus to get it done.
No, I'm so far behind that we haven't even mowed our lawn, but we live on the. It was slow, you know. It doesn't grow like it has been inland, but we'll get it this weekend. But, yeah, it's just the schedule's been tough. Do you
I still have a 17-year-old to mow my lawn for a few more months before he goes off to college. So he mowed it during my work sessions yesterday.
That's great.
Very good.
So Senator Carney, you don't have a garden, or you can't have
No,
one?
we do. We have a perennial bed that has a lot of herbs in it. And then we have a garden that is dedicated exclusively to raspberries and asparagus. So you can imagine what our favorite summertime foods are.
That's great.
And that's literally all that's in there.
That's all right. Those are two really, really good crops.
Yeah.
What kind of raspberries do you grow? I mean, are they red or different colors?
There's a purple and a red.
Yes,
Two
purple.
different varieties of red. One I really like because it's great for canning.
Yeah. Good for you.
Yeah. All right. I guess we can move on from raspberries and toward a vote on LD 1591. Is the committee ready for the vote? And it appears that we are. And Ms. Panett, thank you very much.
Thank you, Madam Chair. Could we just clarify one quick thing, if you don't mind? And maybe I just missed it. I believe Representative Evangelos made an ought to pass, but I'm hearing it has an amendment.
Yeah, I think there's.
So is the motion ought to pass or ought to pass as amended?
Ought to pass as amended with the sponsors language and the addition of authority for the committee to report out legislation in the second session.
Thank you. And I also did not get the second.
It was Representative Sheehan.
Thank you so very much.
Yeah, you're welcome. Thank you.
I will call it all. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Harnett. Representative Harnett is absent. Representative Galgay-Reckitt. Representative Galgay-Reckitt is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 6 members voting in the affirmative, 3 members voting in the negative, and 5 members are absent.
Thank you very much, Ms. Panett. And for those who voted in the negative, could you please let me know what your reports are?
Mine is ought not to pass.
Thank you.
I am ought not to pass also.
Thank you. Senator Keim?
I'll just go with my colleagues, ought not to pass.
Okay. So the ought to pass as amended vote prevails 6-3 with 5 absences. And with that, we'll close the work session on 1591. And we will move on to the next work session, which is on 1692. And I And Peggy has rejoined us.
Tag team.
We're ready for your
Ready?
analysis whenever you're ready.
Great. So LD 1692 is an act to improve judicial branch facilities in Hancock County. It is sponsored by Senator Lucchini, who is attending, I see. It amends the Maine Governmental Facilities Authority statute that it's not asking for more bonding authority, but it's asking for permission to use the existing funds in an additional way. And it would be to apply to, I think it's working on acquiring and improving property relating to the judicial branch in Hancock County. So this is a preliminary steps for addressing the courthouse situation in Hancock County. It's not additional bonding authority, so there's no costs at this point that at least I understand. This would allow them to acquire property and start their planning process, they being the judicial branch.
And this is Senator Lucchini's bill, correct?
It is. And I think he put it in on behalf of the judicial branch.
I'm just inviting him to join the panel. Welcome, Senator Lucchini. Go ahead, Senator Keim. Would you have a question or debate?
Thank you, Peggy. I just have a question. So it doesn't require any more money now because they have the bond money to use, but then I'm thinking that it does cost more money in future because they're expanding their buildings.
Right. So my understanding is if they decide that they do need to build, either renovate or build a brand new building, that they would come back to you with an amendment to the Governmental Facilities Authority law to provide for bonding for those purposes, for those specific purposes. So that would be additional legislation in the future.
But this money will be used to purchase a building.
Or land on which they could build, yes. Right.
Right. So it sets us up in the future to need more money, basically, for them to need more money. Right.
Going forward with this is a recognition that there will be additional costs in the future that will have to be funded.
Right. And I just was wondering, so my question that was leading to is actually, do we have any idea on what that looks like in the future? Because it's always hard to say, yes, I'll take the first step without knowing where we're going.
Right. I don't think any of that has been estimated at this point. Okay, I mean, you might be able to look at the improvements that have been done in other counties, whether they were new buildings or renovations or additions, and that might give you kind of a range of the potential costs. But I'm not privy to what's been planned, and I don't know how much has already been identified as what they want to do going forward. So I don't know if they have estimates. I see that Julie Finn is in the attendee, but I'm not sure if she has that information. It's usually Mr. Glessner that has that information.
Okay, thank you.
Yeah, Mr. Glessner spoke at the public hearing, but perhaps Senator Lucchini could help us with an answer to that. Do you know, Senator Lucchini, what the status is?
Yeah, thank you, Senator Carney. Yeah, so the judicial branch in 2019 did a study for rebuilding the Hancock County Courthouse because it's next on their list of upgrades that they've been doing for some time. So they've identified an area where they would like to build. And they released the study. Obviously COVID hit, so it delayed everything. So they aren't sure they can get the parcel that they want. So it doesn't specify the exact parcel. So if they aren't able to get the piece that the study identified, they would just identify different land and then come back to the legislature next session with a bond for reconstruct. They plan to rebuild bad shape. And of like several, I guess, favorable economic factors from the previous 3 projects in Oxford and Waldo and York counties. There's leftover money from that facilities bond, which can only be spent in very limited ways. And they felt using it to go to the next on the list would be appropriate. And that's why I guess they worked with the AG's office to make sure that they could do this according to Mr. Glessner. And it would just keep going down the list and they'd come back with a full proposal. They'd have a better idea on the cost if they can see what's by, if that's helpful.
And I do believe that Mr. Glessner is on his way. We just, Julie Finn is trying to reach him, so that might just take a moment. Representative Evangelos, your hand was up next. Do you want to go ahead?
I'll wait till we hear from Mr. Glessner.
Okay.
But then I wanted to speak about the legitimate need for this, but I'm going to wait.
Just so that people who maybe are watching, or Representative Thorne just joined us, Representative Thorne, we're on LD 1692, and we're just waiting for Ted Glessner from the judicial branch to provide some additional information, and he's joining us shortly.
Thank you, Madam Chair. I think we have internet and cable back. So there is, while we're on a discussion of SUPI, I'm trying to get on my computer, but when I use the passcode to try to get in, it says I can't enter as a panelist, evidently because it's a workshop. But that's the only way I can get on with my computer. So I didn't know if that's a switch they can flip to allow me to get in through the back door that way. I don't want to cause a lot of problems. I can stay on my phone, but just asking. By the time we get this straightened out, we'll be back in the State House anyways.
Well, if you come in as an attendee, can't we just move you over to being a panelist?
Yep, but it wouldn't let me in as an attendee.
Not even that.
I'll try it again. Thanks.
But he gets a panelist link.
Yeah.
That's odd.
Okay, so I believe that we are being joined. We don't quite see Mr. Glessner yet, but apparently he's on his way.
I wonder if one of the Julie Finns is really
I
Ted
know.
Glessner.
Mr. Glessner, if you are in the participant in the attendee part of the meeting, could you raise your electronic hand?
Guess not.
Oh, here we go.
That's Julie.
Yes, it's me. I didn't know there were 2 Julie Finns because I did send him my link. I think the other one must be Ted Glessner, who is in fact listening and would be happy to answer your questions.
Thank you.
So there I am again, or not.
All right. And let's see, Senator Keim, when Ted Glessner joins us, did you want to re-ask that question? Okay, I think he's be here in just a moment.
Can you see me or hear me?
I can hear you.
We can hear you.
I don't know why this is happening. I can see all of you. I have from the beginning, and I sincerely apologize. I don't know why that is.
That's right. I'm sending you a little up there. There you go.
There we go. I can see myself now.
Senator Keim has a question for you.
Actually,
And
I've heard
thank you for
Senator
joining
Keim's
us.
question, but I'll
Thank you, Mr. Glessner. I just wanted to kind of have the bigger picture of where this was going. And, this is one small step towards something larger. And was that, I understand it was already identified as the next priority, which is different than being funded for the next priority. So I was just wondering if you could help me understand the picture there and how much. I'm sure it's in the bill and I'm not looking at that, but how much money is this that we're talking about as well that's left over?
So the amount of money that's available right now is approximately $2.5 million. We're not talking about spending that amount of money. Your question is in the bond funds now, what's available, and that is what's available. And that money can be used for planning. There's a number of purposes in the statute, but we of course have to have legislative authorization to be able to spend it. There has to be a reason for spending it. And what we would like to do is to use a portion of that to be able to get the property that we will need to build a new courthouse in Hancock County. And because the money is available, because that's the next one that we have on our list, it's an important step in that direction. And that's why we're seeking the authorization.
Follow up if I could.
Go ahead.
So I just needed to clarify. So it's available. Does that mean that it's just been approved or the bonds have actually gone through and the money is sitting there?
The money is sitting there.
Okay.
What happens, we get authorization to issue bonds. The bonds are issued and they've been being spent over the last 5 years, 4 to 5 years for the projects that have been completed or are under construction.
Okay.
So it can only be used for these limited purposes. We're just trying to get the expansion to be able to, okay.
Yeah, okay, thank you. I understand that. And then, and how much is the project going to cost to build the courthouse?
So we don't know that until we get the authorization, but I would tell you, based on information that we have from our architects and so forth, of course, it always depends on all sorts of things, including when you start the project. But I would anticipate it would be in the range, what the architect told us, about $37 million, could be $38 million. That's the estimate now, and it depends on when the project would start. But that's all contingent on getting authorization from the legislature.
Thank you.
Sure.
Thank you so much, Mr. Glessner, for joining us. Committee members, are there any other questions for Mr. Glessner? Go ahead, Representative Evangelos.
Just an antidote, but when you get ready to build the courthouse, you might want to use brick and mortar and not touch the lumber prices.
Thank you.
It's $10 for a 2x4 the other day.
Representative Babich, did you have a question for Ted Glessner?
I did. Thank you, Thank you, Ted, Mr. Glessner, for being here. And I think the fact that this bill is coming forward is an indication that the process works. That for further authorization, I think this is. I'm glad you're before us, and I appreciate that. When we talked last time, I had 3 questions, and actually you answered 2 of them. I didn't end well on the second one, and I just need to have you confirm. The 3 projects that the original bond was for has this $2.5 million left in the fund, which you want to apply to the next property that the judicial branch intends to build. And this is a great thing. I just need assurance that the 3 projects that have been originally funded, that there is enough money in the account for a successful and adequate completion of those. And I asked this question because York County is still, we're closing 3 facilities to create 1, and we're kind of we've had the property for a while, but we're a long way from completion. And I just wanted your assessment or a statement, publicly that you have successful and adequate funding to complete the job as you wish to do.
I can say very comfortably, yes, we do, for this reason. The Belfast project is 100% done. The project in Oxford County in South Paris is virtually done. One might say 100%, but you get to the punch list piece at the end, there's still some little things that have to happen there. And as far as the project in Biddeford, we have a budget and we're within that budget and we're living within that budget. We still have some contingency and so forth, but we're comfortable in terms of where we are within that budget. And by the way, Representative Babbage, I believe it's next Friday, the last piece of structural steel will go into that building. It's that far along that the framework is up as far as that building.
That is good news. Thank you, Mr. Glessner. Representative Evangelos, is your hand up anew?
Yes, it is.
Go ahead.
Well, I wanted to speak to the matter briefly to Senator Lucchini. I did share with the committee, I spent 2 days in that courthouse, November 20th and 22nd. And when I got home on the evening of November 20th, got up first thing in the morning on the 21st, and for the first and only time, I actually called Mr. Glessner because I was very concerned about the conditions in that courthouse. It definitely needs replacing. I don't say this lightly, and I'm not saying that the building had anything to do with the deficiencies regarding the malicious prosecutions that went down inside, but it certainly didn't help. But the building is in very rough shape. It is not secure. The staffing is spotty because of the shortage of the marshals and stuff, but I'm supporting the bill and I want to make a motion not to pass on it.
Thank you, Representative Evangelos. Is there a second on the motion? Seconded by Representative Babbage. Thank you both very much. Is there any discussion on the motion? I am not seeing any. Mr. Glessner, we really appreciate you dashing over here to our committee meeting to answer our questions.
Thank you. I appreciate it.
And Julie Finn, thank you also very much. All right, committee, is the committee ready for the vote? It appears that we are. Thank you very much, Ms. Panett. And I think we're ready to proceed when you are. So it's an ought to pass by Representative Evangelos, seconded by Representative Babbage.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett. Oh, my apologies. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will recall the absentees. Representative Harnett. Representative Harnett is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 1 member in the negative, and 4 members are absent. That doesn't sound right.
5.
5 absences.
Did I miss?
Got Harnett, Reckett, Hagan,
Yes. thank
Libby,
you.
and Newell.
My apologies, 5 absent.
Thank you very much. And Representative Poirier, what is your report, please?
Ought not to pass.
Thank you. And so the ought to pass motion carries 8-1 with 5 absences. With that, we'll close the work session on LD 1692 and thank the bill sponsor, Senator Lucchini, for being with us this afternoon.
Thank you. Have a good one.
You too.
You too.
And with that, we open our final work session of the day, and this is LD 1688. This is they don't have the full title, an act to improve the consistency of the Maine Human Rights Act, I believe.
It is, you're right. And Senator Hickman is the sponsor, and I know he and Amy Snerson, as well as Barbara Archer Hirsch, are available for any kind of questions if you have any.
Okay, I've just invited the sponsor to join us.
So this bill is very similar to a bill that was proposed on the 129th and didn't make it across the finish line for different reasons. But it has four main focuses. It includes adult family members dependent for care in the definition of familial status. It includes familial status as a protected class in employment. It includes age as a protected class in public accommodations, and it clarifies the scope of the act with regard to education. And then what it also does, it amends and this is why the bill is so long, I think, it amends the Human Rights Act to make sure that there's differentiation between sexual orientation and gender identity, because that was defined, gender identity was defined last year. And so this is putting it, making it clear that that is a separate category than sexual orientation. You know, you might have very specific questions about sections in the act or in the bill. And one of the things that was recommended by people testifying in favor of the bill was to do what happened last year when the Judiciary Committee considered it, which was to go through the rest of the statutes, not just the Human Rights Act, and every place where sexual orientation is identified also include gender identity. So I've included those sections, and that's why the bill analysis is so long, starting on page 8. Those would be the additional sections if you wanted to go forward and make all the other statutes consistent with the Human Rights Act, to include gender identity. So it goes through Title 5. I think the last amendment is in Title 36. Are there any questions?
While committee members are pondering whether they have questions, I wanted to thank you for pulling together the other information that we had requested at the bill hearing on the other statutes.
It was actually very easy because it was in last year's committee amendment, but you're welcome.
Yeah, you can still take credit for it. Thank you so much, Peggy. And I see we have Senator Sanborn. Go ahead.
Thank you, Senator Carney. I move ought to pass as amended.
We have a motion ought to pass as amended, and it looks like it's seconded by Representative Babbage. Lots of hands went up on that one. So we have a motion ought to pass as amended, and the amendment is the addition of the additional statutes that were identified by our analyst. Great. Okay. Thank you. Discussion on the motion, Representative Evangelos, go ahead.
Thank you. Just a quick question. I think this was the bill where we raised the question of extending the time limit. Do you remember that? Maybe.
Right. Well, one of the things that this also clarifies is, let's see if I can find it. I'm looking in the wrong part. Is the I think that one of the proponents recommended or talked about an extension. The bill itself does not provide for an extension. And I think it came up in the context of the administrative dismissal of claims, and the bill clarifies that the fact that the executive director dismissed a claim because it was filed too late does not give somebody the permission, the credit for filing in time to go directly to court and get attorney's fees. If you want to file your own case, you have to start with the Human Rights Commission and file your own complaint with the Human Rights Commission in order to be able to collect attorney's fees if you are successful. And so one of the things we did last year, or the committee did last year, was provide for the dismissal of late filed claims, because you're right, there is a limit to file a claim or complaint with Human Rights Commission, and it's 300 days.
That's what I remember.
Right. So if somebody filed a complaint, the law now allows the executive director to dismiss that complaint administratively if it was filed late. But that doesn't authorize someone to use that administrative dismissal to go forward with their own complaint and qualify for attorney's fees. They can still go forward with their own complaint in court, but it doesn't qualify them for attorney's fees.
Okay. Well, unless Ms. Nixon is not satisfied with what we're doing, I'll leave it at that. I'm going to support it. Thank you.
Okay, yeah, and we did have a standalone bill, Representative Evangelos, that would have extended that 300 days, and we have already reported that out of committee. Does anybody need to hear, you referred to the ED Sneerson, Representative Evangelos. I don't feel like we need to hear from her. I think she was pretty clear in her support for the legislation. Does anybody have any additional questions for our analyst? I would like to then recognize the bill sponsor, Senator Hickman, who has just joined us, and give you an opportunity to address the committee if you would like. We are on an ought to pass as amended motion. The amendment.
Thank you, Senator Carney. Representative Harnett is actually in front of my committee right now in a work session, and I just saw that you were taking this up, so I turned on my video to see the vote. I have nothing else to say. Continue with the work.
Very concise. We're happy you're here. Is the committee, any more discussion, committee members? The committee is ready for the vote, I believe. Thank you very much, Ms. Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne. I'm sorry, Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I will repeat or recall the absentees. Senator Keim. Senator Keim is absent. Representative Harnett. Representative Harnett is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 6 members voting in the affirmative, 2 members voting in the negative, and 6 members are absent.
Thank you very much. And Representatives Poirier and Thorne, could you please let us know what your report will be?
Ought not to pass.
Thank you both very much. And so the ought to pass as amended motion carries 6-2 with 6 absences. Do want to remind committee members that if you missed any of our votes today, you have until noon on Monday to register those with the presiding officers. And in addition, on Tuesday, we'll start up with meetings with the nominee for the Chief Justice position, and then we'll be doing confirmation hearings in the afternoon and possibly taking up some additional work after the nomination hearings in order to complete all of our work by next Friday. Are there any scheduling questions that anybody has? All right. And Soupy or Peggy, do you need anything from us or? No, all set?
Thank you.
All right.
Have a nice weekend.
Yeah,
please
you
do.
too. And good work this week, everybody. See you Tuesday.
Well done. Take
Thank
care.
you. Bye.